Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning. Good morning, everybody. It is a good morning. I am in shock. I can fit into something I haven't worn in ages. I'm so happy. Lost a lot of weight. I'm Ada K. Thank you so much for joining me this morning. We are starting a little early. Hello, Jesse, one sunny day. Because, why? I forgot. Nix is being sentenced today. And you're asking, who is Miss Nix? Well, let me tell you. Oh, well, my screen's doing some crazy things. Okay, so this is Polk County, Florida sentencing. A jury found grandmother of Floridian, Tracy Nix, not guilty of aggravated manslaughter in November 22 in the death of a 7-month-old Uriel Shook. A jury did convict her of leaving a child in a motor vehicle in excess of 15 minutes. She faces potential sentence of 8 years in prison when she's sentenced today. So the second grandchild to die under Tracy's care, 16-month-old Ezra drowned in a nearby pool after Tracy fell asleep. The judge ruled that Ezra's death could not be mentioned during this trial. So the jury had no idea at all that this is the second time the grandmother has unalived a grandchild by neglect. This was a very heated trial. So let's hop on in and see what they do. We will go to Monica Sementilli as soon as it starts.
Hang on, Mr. Coleman. Just have a seat. Let me get this up and going.
He's like, I got to get all this going. Your Honor.
Leaving a child in a motor vehicle in excess of 15 minutes for serious injury to Uriel Shock on November 1st, 2022, contrary to Section 316.6135. We're here today because 7-month Uriel Shock was severely injured and died, and Tracy Nix is to be sentenced for a conviction for leaving Uriel Shock for over 15 minutes in a hot car that directly caused the baby's severe injury and death. So at this point in time, we're going to begin with the proceedings. State, are you ready to begin?
Yes, Your Honor. Thank you for the urgent.
Go ahead, sir.
Your Honor, at this time, would you like to hear from the state witnesses that are going to testify as to sentencing?
Yes.
Okay. I'm sorry, Your Honor. This is the first time I've heard.
Yay! Congratulations.
At this point, Your Honor, the state would call Mr. where would you like?
I'm going to have the clerk swear everybody in. So the first will come to the clerk, and then he can either stand, he can either sit in the box, or he can stand at the podium. It's entirely up to you. Wherever you want to stand or sit. And if you're going to stand, we're going to have you stand right there, okay? But you got to swear in first.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
And Your Honor, I'll only be putting Mr. Schock's name on the record. You'd just like to make a statement to the court.
That's fine, thank you.
Clerk, could you please state your name for the record
Yes, sir. My name is Drew Schock,
and spell your last name?
SCHOCK.
And sir, how did you know your?
She was my daughter.
Okay. Is there a
Oh, my
statement
God.
you'd like to make to the judge concerning?
Yes, sir, I do. And I don't know how easy this is going to be. I'm supposed to come up here and really explain to you about my child. We've been doing this for the past 2 years. It's been tough on my wife and myself and our son, and now we have another daughter. And, we're basically trying to put a price on my child's life with time. And I had all these notes and everything, and I'm up here now, and I just, but basically what we're doing is we're justifying my child with time served in prison. And a lot of you know here, this is not the first time this has happened. This is the second time.
Whoa,
Fortunately, we weren't
that wasn't
make
able to
that
be
case
brought up in
with-
trial. Why are you
with the
bringing it up
jurors
now?
Due to circumstances, but everybody in here knows that this is not the first time this has happened. But I'm going to keep this about her because that's what this is about. It's about my daughter. She was born on March 5th, and she was a blessing to my wife and to myself and my son. 2 months before that, we had lost our son, and it was devastating. My wife was 6 months pregnant with our daughter during that time, and it was really hard for us because she was trying to take care of our daughter, who was 6 months pregnant, and trying to grieve for our son. And when our daughter was born, she was born into grief. But she was
Oh.
a blessing. She kept us because we were looking forward to her. Despite everything that was happening, we were looking forward to her taking away a lot of that pain. And she did. Yeah, we protected her more than you can imagine. As parents, when you lose a child, you become helicopter parents. You
That
think
is
about
true.
all these scenarios. So let me watch over her, let me protect her from this, because you have this living in the back of your mind with our son. And we were very diligent and vigilant with her. My wife and I actually got together when our daughter was born, and we set parameters because of what had happened prior. We told ourselves and said, look, once she gets up to where she can move and walk, we're going to go ahead and restrict her from this location because of past circumstances with our other son. We were nervous about her getting out and around, and when something like this happens, you recede all the way back. You want to protect everything. You put fences around it. We put fences around our oldest son. We wouldn't allow him back over there because of the situation here. But it doesn't matter, no matter how hard you try. There's just some things that you don't think about. And we, as parents, have to live with that for the rest of our lives. Like I said, I no matter what we do or what we say, I'm always going to feel responsible because these are my children. I am responsible for them. So we're going to carry this. And I'm always going to think about what ifs, or if I wish I would have done this or done that, or if we would have known details about the prior one, if we would have. But all that is it's too little, too late. You know, she was our blessing. You know, when she was born, she was our angel child. She looked so much like our son, it was ridiculous. We seen him every time we looked at her. She looked at us, and it would just cut right through us, and we took that like it was God saying, "Here you go, here's your other shot. You know, I know this happened, but I'm going to make this daughter look just like him, and you guys are going to have this." And it was taken from us. Like I said, it's tough. My wife and I sat here through all these court proceedings, and we had to sit here and listen to people speak as if they knew what was going on, as if they knew what was happening, and none of these people had a clue. Now, once they asked us, "Hey, Drew, what happened? Hey, what really happened?" That's what I would have loved to have told them. How everything happened, how everything went down, because it was not how it was portrayed in the courtrooms. And I was planning on coming here and explaining all that. But in the end, like I said, the result's the same. I'm standing up here in front of you guys, defending my children from a woman who took them away from us. To me, that's insane. It's insane. She's done this twice. And the fact that we're debating whether or not she deserves jail time is just insane to me. She took 2 lives. To me, it's black and white. But my wife and I are the ones who are going to have to live with this. They can go and do what they want to do. 20 days locked up. They're done, forgotten all about my children. Forgotten all about them within 20 days. Like it never happened. Going off, doing their own thing, living their own life. Making her own friends. She's not grieving. Not at all. This is the pain that my wife and I wear. Nobody else. We're here for justice. That's what we're here for. For the memory of my kids. I just ask the judge, don't let this be in vain. Because I got a son who still asks about his sister, who still asks about his brother. And as parents, we still haven't told them. But now my son's asking me what happened. And as a parent, that's the hardest thing. Because he's wondering, Dad, why'd you let it happen? I tell myself, son, I don't know. We didn't see it coming. We didn't expect it. We didn't think that this would be something that would happen. Not once, but twice. I remember when our daughter was born in the hospital. all the pain that my wife and I were going through, it just faded. When we looked into our daughter's eyes, it just melted. And I can tell you this, as a father, I love my sons. They are our future, and they are my future generations. But I remember looking into my daughter's eyes as a father. This is so much different. The love a father has for his daughter, I can't explain it. I'm not saying it was, I love my daughters more than my son, but God, she could wrap me around that finger so fast. My son, I tear his butt up, when he's doing something wrong. I remember my wife went to try to get on my daughter over something silly. It wasn't nothing. She was being, and when she said, I remember coming almost unglued just because it was Daddy's girl. And it wasn't nothing major, but I don't ever remember doing that with my sons. Like I said, with my daughter. To have that taken away. Now that we have our other daughter, as a parent, it scares me. Because I thought I knew the people I was sending my child with. I thought I knew them. So much was kept from us. If we had been made aware, we would have made other arrangements. If we had been made aware of medications, we'd have been made aware of. We would have done things differently. And I blame myself because part of that was just wanting to really believe that she was different. I didn't want to tear apart a family after going through so much with this. I didn't want to destroy this. This is my wife's family. And like I said, they had their house dedicated for kids. They had a room set aside especially for kids. And I didn't want to take that from my son. And I wanted my daughter to have that. Now it's pipe dream. She was a blessing. I planned on going through and that day, but I can't still be up here and talk. We've had to relive that moment every single day. Every time it's in the paper, we had to relive it. Every time it's just so for me to sit up here and talk about that day. I'm not. Everybody was familiar with what happened. Everybody. I just want you to know that as parents, what would you guys do in my position as a parent if this happened? Not once, but twice. All we can do as parents is try to see it through. That's all we can do. Just make sure this doesn't happen again. Because nobody thought it would happen the second time. But I'll be damned if I'm going to stand by and let this pass me by and let this continue to happen. Like you said, we're fighting for our kids' names. We're fighting for their memory. And for somebody to just walk away and think they just deserve to just walk away after what they've done to my family, to my son. It's insane. I said, I can't fathom it. To be able to do this, some kids and act like it wasn't your fault, like it was. Blaming somebody else. Not once have we got an apology. Not once have they said, Drew, I'm sorry. I'm sorry for what we did to your family. I'm sorry. Not once. Because from any of this. I just want you to know that I'm going to continue to carry their memory the best the way I know how. I'm going to continue to raise my sons and raise my daughters to do what's right, to be God-fearing children. I had some moments where I questioned everything. Well, when you go through stuff like this, you question everything. Question your faith, you question everything that you believe because you just couldn't imagine. And through that, you just, God brings you a daughter like we have now, Adrian. And like you said, when she was born, she looks just like my son and my daughter. It's the craziest mixture. But I see both of our kids in her now. And it's hard for me to still question everything because in the strange way God has a sense of humor. He gave me what I lost and put it in this little girl who has me wrapped around her finger. And right now she's about the age that we lost Uriel. And I see her, and I see my daughter and her. I think about that accident. I think about how you can do that. We live in
I
Florida.
think it was a good
It's hot all the
relationship.
time. I know everybody knows it.
I would not leave my child with anyone who was a part of their unaliving the first time.
You imagine how fucking hot it is in that car. Hey, you get in, you go to the grocery store, 30 minutes. You get out and it's blistering inside that car. Every time I do that, I think about what my daughter went through for hours by herself, screaming.
That's horrible, y'all.
About that. For what? For what? In a hurry? But I'm reminded by that every single day. Because every single day is that temperature. Every single day I get into my truck and I feel that and I think of my daughter and my heart breaks. Because I can't imagine. But I have to because she did. She sat there and suffered and screamed and flailed. We had already gotten to the scene. Everything was packed up. We went to the hospital. And that's a sight you don't ever take back. Something you don't ever unsee. The love of your life laying there 11 months before, 11 months after, going through the same thing. It's deja vu. So Judge Adam, as a parent, like you said, we weren't able to get all the facts out to the jury like we should have. Because nobody in their right mind would let this happen twice. Twice. We just asked that you would just think about this when you sentence. I can tell you how to do your job. You do better than I do. All I can tell you is that this is something that we will have to suffer with for the rest of our lives.
Hello, Miss Barbara Anderson. Good morning, Miss Elena. Good morning, Jesse. Good morning, Gerald. Good morning, one sunny day.
Anything from the defense?
Good morning, David.
That's right.
Okay, thank you. Thank you, Mr. Shock. Next witness, take.
May I just have one moment? Your Honor, the state would call Kayla Nix shot.
Okay, Ms. Nix, you're welcome to sit again in the box or stand to swear in with the clerk, please.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
That's the mom, I believe.
May I please take it for the record?
Kayla Nix, Shock,
Study picture.
Kaila-Nix, and I am not legally Shock, but SCHOCK.
And I think we all know that. How did you know you?
That's my daughter.
Would you like me to say?
I will.
How would you?
Thank you. God,
Take your time. I sit aside all day for this hearing.
thank you. Good morning, Your Honor. I had a beautiful daughter, and her name was Uriel Jane Shock, and I named her from an angel from the Old Testament of the Holy Bible. She was nothing shy of an angel. She was my rainbow baby. You know, as much as I want to start with her, I have to start on the day that my son Ezra Shock died. And I have to start there because I received a phone call from my husband screaming about my son, and I was unaware of what was happening. And I got into a vehicle and I flew as fast as one can fly to 1478 Kazan Road in Marshall, where I called my home for a large majority of my life. And on my way there, I was very careless in driving. I could see a helicopter coming to their address, and I looked at the helicopter, and I didn't look in front of me. And I had a front-on collision with a very innocent woman, and I damaged that woman. And I want to publicly say that I am deeply sorry to that family because I caused them harm in that moment, and I would like to take a moment to acknowledge that and take ownership of that. But that woman isn't the only woman that I damaged that day. I was 6.5 months pregnant with my daughter, Uriel. And in that car accident, I had a placental rupture. I totaled my car. I bailed out of the passenger window with all the airbags that fell on me, climbed through the glass, barefoot, took off running down the street to 1478 Kazan Road. And I was so stricken by grief with Ezra that I already had put her in danger due to one circumstance And as I lay there in Tampa General with my son, I demanded an OB team come down to the NICU to sit with me because I could not leave my son, but I could not harm my daughter anymore. And I sat there for what felt like weeks, but I'm aware that it was less than 24 hours. We decided that my son was brain dead, that he had realistically died at my parents' home, and they had revived him. And so I lay there with my husband in my bed, in his bed, 6.5 months pregnant with Ezra's sister, while we took him off of life support and held him next to me here in Uriel while he died. That was the closest they ever were together on this earth. Was her in my stomach, harmed by me, while he died. I had my daughter on March 5th, that following year. I had been on very strict bed rest. My sole obsession was Uriel. I had been told by my doctors that I needed to choose. I had to choose whether I mourned Ezra or I saved Uriel. And so I put Ezra in any version of a box that I could find inside my heart. And I put him here in the name of protecting Uriel. She was my restoration. She was going to salvage my family. And that was never meant to be her purpose. She was just meant to be a beautiful little girl. But by circumstance, she became my salvation. The day that my daughter died is one I could clearly never forget. No matter how much I wish I could wash it away and just hold beautiful moments, it's not something that I can do. Had a family friend at my door to tell me again that my child was dead, and I screamed at him, "Why are you telling me about this? Or why are you here?" And he said, "No, Kayla, it's your daughter. This man I've known my entire life was there to say to me again that I was going to bury a child." The day that I agreed to invite my mom into
Good morning,
my
Miss
mother's
Robin.
life, I was afraid. I was terrified. But I wanted restoration with you. I wanted that. I wanted our family. I wanted to save something, Mom. I did. I wanted to save something.
That's her mama she's testifying against.
Anyway, and I don't sit and believe that this was an intentional act. I wear this today. You and I gave me because I'm still your daughter. I'm still your daughter. And nothing is changing any of this. I still love you. I hate this. I hate that I had to choose. But you know I had to. But it doesn't change my heart. She was gone. I walked in with my husband to the hospital to identify her body. And I never felt, well, actually, that's not true. I felt that air leave my body before. When Ezra died in my arms, I felt it. But this time she didn't die in my arms. She was just there. God, my beautiful Hitler was gone. The officers on site were concerned for my physical safety in that moment. They could not rationalize how one human could bear the weight of this reality. At which point they decided to take me to Tri-County. And it's not something I've spoken of before. But they brought me to Bartow. And I was on the other side of the door. And I could hear you on the other side of the door talking as I sat there. And I just remember feeling so alone in that moment. So alone, because the other thing in my head was that Drew was alone with Asher, telling my son that his sister was dead. And his next question was, "Where's my mom?" And I don't even know what he said. I don't know what he said. But I know I wasn't there for my son. So they transported me to Lakeland. They didn't have room for me there. I sat in a chair in the lobby. They next to the nurse's station while they made fun of me for giving another opportunity to the person who had already taken so much. And the entire night I didn't sleep and they talked about me. And all I wanted to do was talk about my daughter, and I couldn't say a word to anyone. I was completely and utterly alone. And morning I was exposed to horrific things. Mentally ill men across the table doing disgusting things under it while I just sat there alone, waiting to be saved. Anybody who would give me, because it was not suicidal. And yet there was damage there too. My daughter died and somebody's masturbating under the table. It's horrifying. And then this court proceeding began. And all I ever wanted was for it to stop. I just wanted this to stop. I wanted this to end. But I had to seek justice for my daughter and my son because I had already been forced to choose. The day we came here, I knew I was forced to choose. And I am not a mom that is going to sit down and care about my feelings as someone's child more than my God-given role as their mom. All of these decisions are things that I find suffocating. I have felt nothing shy of cornered for 2.5 years, with the only move to make is to stand up and say my children's names, say Ezra, say Uriel, say they deserve better than this, because they did. Beautiful children, children we prayed for, longed for, and cherished. But I wanted to salvage my family, and I thought that was something that could be done, because I still love each of them so dearly. It makes this so gutting. It just eviscerates me to stand here. But this court process has been skin thickening. As we've gone through, I've had to find my strength and find my voice and find a way to survive this. Survive what my children went through. My son is now 6. His name is Asher. And he asks for Ezra. He asks for Yuri. And not long ago, we sat down and he just said, I didn't realize they were really dead. I didn't know that they were really dead, that they're in the ground and they're dead. And a handful of days later, he came home after going to a ball practice. He had seen a newspaper and spelled out words on the newspaper. And it was a very recent one. And I certainly did not define those words for him. But he asked me why his grand was on the cover of the newspaper. And that was the first time he did not have a way out. Because I had never told Asher. I never told him. Because I don't want to. I don't want to. He loves you. He loves you. He loves you, Dad. He loves you guys so much. And y'all's presents are missing from his life in a way that I didn't get a vote in. And it's caused more than just my dead children, which is so heavy. It has caused my relationships with my family, my parents, my extended family. I have never felt so alone. Ever. It isn't about my feeling. It is about what I know. And what I know is that my son drowned on a very cold day in their pond, and he drowned alone. And I know that my daughter died on a scorching hot afternoon, alone. And I had to step out of the courtroom during the trial while they described those details, because I don't feel mentally capable of hearing those more than the times I had already heard. But that absence in that room in that moment did not lessen our presence there. We have a son and a daughter that we have to go back home to. And so yet again, we stopped and we tried to choose our living children. My daughter Adriel, 17 days away from outliving her sister. So I said, and I hold my daughter, and I wish that she knew her family. And I look at her, and I just see the beauty. I'm humbled by God's mercies that He's renewed and the blessing He's given us to move forward. But it's impossible to not see my son, to not see my daughter. And as it relates to the sentencing. I said this before. I hate it so much, but as her daughter, I don't want any of this. And as their mother, I beg you to honor my children's deaths. It doesn't lessen my love for my mom. It doesn't lessen my love for my father. It doesn't lessen any of it. But as I've had to explain to my son, there are times where things happen and they're not on purpose and no one meant harm in those moments. But there are real consequences. And this is a moment that I struggle to say that. Because I just want some version of a family that I've lost. Family my children have lost. It's not coming back. And while there's room for restoration, I do put forth the request that you will honor my children's deaths when you consider the sentencing. And I love you. That has not changed. And I appreciate you. Look at me. Thank you. This way. Thank you, Your Honor.
Thank you. Any cross? All right, thank you, Steve. Next witness. Thank you, Mr. Shaw.
Thank you.
See, it's for the witnesses, Your Honor, and we would just have a recommendation.
Okay. Defense, do you want to do your witnesses first, or have the state do the recommendation now, and then you present your witnesses?
I'd ask that the state do the recommendation.
All right, state's recommendation, please.
Yes, Your Honor. I don't know what process the court goes through with determining a appropriate sentence, but I can imagine it's a lot like the state when they make a recommendation. I think Your Honor and the attorneys in this court are in a unique position in which we're in a system and we see a lot of things. And we realize that everyone knows there's degrees of crimes, first, second, third degree felony, but we also learn in the system that there's degrees within those individual crimes. And when I look at this case, I think we have to look at the severity of what she was convicted of, as far as on the spectrum for that individual crime, where does that fall? And Your Honor, I think you can only reach one conclusion. It falls on the most severe end. She was found guilty of leaving a job unattended in a car for more than 15 minutes, and it results in a great bodily harm. The great bodily harm in this case was a painful and torturous death. That's a fact. And in my next step, as far as making a recommendation to the court, we look at who was the victim in this case. And in this case, it was a 7-month-old. A 7-month-old is wholly dependent upon the person responsible for them, not only to be happy, not to be healthy, but to be safe.
Okay, for those of you who don't know, let me clear this up. The grandmother, the woman who was convicted, was charged with babysitting a grandson whom she fell asleep or wasn't paying attention, and the grandchild went outside and drowned. Then later, now that was not brought up in this trial. That backstory was not permitted during trial. Then she had her granddaughter and left her in the car, very hot heart, while she went and ran errands, I believe, or forgot about the grandbaby in the car, and she died. That is what she is being sentenced for. I was wondering if they tested. I didn't get to watch this trial, but I was wondering if the grandmother was ever tested for Alzheimer's or dementia. Just wondering, but too late now.
The fact of the matter is, the victim in this case should have been turning 3 years old last month. And she's not. Which brings me to the who. And in this case, who committed that crime? What position was the defendant in? She was grandma. Next to mom, she should be the safest person. And dad, she should be the safest person.
That's true.
That you're a good member. Not only was her grandmother, she was a woman, as I'm sure you're going to hear, that was involved in the education of children for her entire life. She was a woman who had children of her own, who had grandchildren before that. And most importantly, and I believe both Drew and Kayla touched on it, she is in the unique position, more so than anyone in this courtroom, to know what happens when you let your guard down, when you're responsible for someone who told you things on you until they're. That's the process the state goes through when we're making our recommendation. And I hope the court will go through the same type of process, because I think when the court goes through all that, I'm not going to go through the facts, you understand that. But when the court goes through all that, we're dealing with a third-degree felony that's punishable up to 5 years in Florida State prison. 5 years is wholly inadequate for the damage that was done in this case. But I think when you look at everything, when you go through that process, when you look at who she was, who Yuri was, and what happened to her, while 5 years in prison is wholly inadequate, it is the only thing that's appropriate. As Mr. Schock said himself, when the court goes through that analysis, it becomes black and white. And I think the only thing that is appropriate for this court to do in this case is to sentence the defendant to 5 years before the state.
All right. I have your score sheet at 44 points. Defense, before you begin with your witnesses, do you have any additions, corrections, or deletions to the score sheet?
There you are.
Okay. State, I understand the score for severe injury is 40 points as opposed to death. And I think you're doing that based on the Brown v. State case 24-7-3-562, which cites the 3.704D9 that says victim injury must not be scored for an offense for which the offender has not been convicted. Since the manslaughter charge was acquitted, you're not scoring that. Is that correct?
Your Honor, I think you went ahead and pulled exactly what I looked at before I submitted the case law. Additionally, Your Honor, because the legislature didn't put death in the file, I think we already done the first part. I had to determine what was appropriate.
Correct. Instead of a 124-point sentencing score sheet, it's a 44-point sentencing score sheet.
Yes, sir.
Okay. All right. Defense, you agree with that?
Yes.
Thank you. Defense, please go with your whichever one you start with. Again.
I saw Nate next.
Okay. Mr. Nay, next, come on up. Again, any defense witnesses can either go from the podium or the chair. It's entirely up to y'all. Just take a seat wherever I stand.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Okay. First, to stand here, Judge,
That's fine. Entirely up to y'all.
state your name for his own.
So this is
Nate, Nick.
for the grandmother. I think this is her husband.
You heard the testimony of your daughter and your son-in-law.
Yes.
Okay. After Uriel was born, how often did you keep her?
Depending on the week, depending on what Kayla and Drew needed, we were keeping her anywhere from 2 to 5 days a week.
Okay. All right. And you've heard them talk about the first child when you were there, gone over there, you got a ruling on that. And I know you testified that Tracy and the lady were sleeping, you slipped out and went shopping out of your sleep. Regarding the woman.
Yes.
Okay. Did you or do you not, Tracy, try to keep any of those details from you?
No, we did not.
And Tracy had a red Lexus at the time of the passing of Uriel, is that correct?
Yes.
Did it have a child on in the backseat?
No, it did not. That was an option when we purchased the car. We did not get it.
Okay. Let's talk about Tracy after Uriel's passing. What did she do in connection with the red Lexus?
The Lexus became an issue in the garage, just sitting there. Tracy would not touch it, get in it, or drive it. She didn't want anything to do with it because it brought back too many memories. And so on a scheduled service date at the dealership, I drove the car there, get tires rotated and oil changed, and have them do their inspection on the car. As I was there talking to different salesmen, one of them struck up a conversation with me, noticed that the car we had was low mileage, and being a car salesman, offered me a really good deal to swap cars. I thought about it for a little bit because I also felt like that might be kind to Tracy to.
Thank you,
remove the car.
Tash. Hello,
My
love.
application.
Welcome, welcome.
So my only question to her was, is the color okay?
That
She did
better?
not have a choice in it. That's why the car is also.
He's hard to hear.
You got rid of the red Lexus and you bought a new Lexus.
Yes.
I want you to tell us, Honor, the changes that you have noticed in Tracy since the death of your.
Tracy mourned in silence, more at the house, more away from people. There wasn't any hope of really, other than the time that she went to Beef O'Brady's with some friends there, taking the baby with her. After that, there was no hope for us to really go anywhere in town to eat. She wouldn't go outside hardly at all. She used to love to do yard work. She'd spend hours online, and sometimes she would take a bath for days. You know, the days seemed to run together. Her eating habits changed over to Oreos and ice cream. She didn't care what she ate. And she wanted to, a lot of times, she didn't want to come to the other end of the house, you know, where the dining room was, or you know, where we had just a casual table. She wanted to eat in bed. She did not want to get up. She suffered. I hope this wasn't intentional, but social media and the news media were brutal. And a lot of the information that was posted was totally incorrect. They didn't have the full story, or they only had enough to make it sensational. Her sleeping habits were all over the road, but she got to where she'd stay awake till 1 or 2 o'clock in the morning watching TV or surfing the internet. And then as soon as she woke up at 7 or 8 in the morning, TV had to be on again. There were also one vivid part that I really noticed, and it affected me also. We had no holiday celebrations in our home for 3 years. No Christmas decorations, no any other decorations. The only celebration we had was before Yuri passed. We would have family dinners at our house that Drew, Kayla, and children were invited to and brought to, and we tried to celebrate as family.
I understand, Tash. We're all good.
It's,
You had some pigs at your house.
yes, we did, in enclosed pens. Our other 2 grandsons had 4-H and now FFA pigs that we allowed them to have at our house because, of course, we were further out in the country, and they were able to come and work with them, clean up after them, feed them, water them, and on occasion, the boys would want to go fishing in the pond, would want to do stuff. Tracy never, ever came out. Tracy never spoke to them, ever, during that time. Whenever those boys were there, they were outside with me and me alone.
What about after Uriel's passing? What did she do regarding her hobbies?
2 of her hobbies were very important to her, only because she was passionate when she did something. One of the hobbies was wanting to learn to play the piano. As soon as Uriel passed, she hasn't touched the piano again. I continue to wonder if I need to get rid of it, move it out, try to be kind and remove that from her view if she ever got to come home. The other is she loved to do oil painting and drawings. And she used to be very proficient in those and could do them, you know, do an individual unit fairly quickly. But since Uriel, she would start on one, she would paint some background, didn't like it, paint over the whole thing. Sometimes she'd do that 3 or 4 times. She just couldn't focus enough to get back at it and get it finished. And she just got to where her painting just stopped.
Tracy was taking medication during this time.
Yes.
She had been taking medication for many years.
Yes, sir.
Okay. Did you have any knowledge as to whether these medications were affecting her?
At the time, looking back now, after I've been reminded of it, after I've had it explained to me, and after I've read about it, I look back now and say, yes, there were changes.
get specifically with you. Yeah, yeah. Since your passing, has Tracy been to counseling?
Yes,
Can you tell
she
us more
has, one, I believe it's psychoanalysis. We would drive to Punta Gorda once a week. And once a month, she would go to, I believe it was a psychiatrist. Again, I'm not sure of the actual name of their specific talent, but going to the one in Lakeland was the doctor that could issue her or prescribe her medications if she so judged that she needed. After a year and a half, the doctor in Punta Gorda left their practice, moved to New York, and we were able to find a comparable doctor in the same building with the other doctor in Lakeland. So we consistently, once a week, we go up there.
Did you also have some inpatient treatment?
She had inpatient treatment first at Peace River.
You know how long
Center.
that, you know how long that was?
That was for 2 weeks. And then I hunted all over the eastern United States trying to find a facility that Tracy felt like would help her. She had specific criteria.
Hello, Adair.
What she felt like she
Welcome.
needed help with. And so I hunted, and finally was able to locate a facility up in St. Cloud. And that facility allowed her at least a 30-day treatment. I think it was actually a little longer than that, but she was able to be inpatient. I was able to visit her once a week on a Saturday, but that was it. There was no other discussion or conversation with her.
You have family photos at the house
Yes, we do, of all of our family.
still there?
They're still there. We still have pictures of Uriel and Ezra and Asher, and we have Adriel, and we have our other grandsons, our other daughter and son-in-law, Drew, Kayla, and our extended family, all on the same rotating picture screen.
I'm sure you love your daughter, Kayla.
Yes, I do. It has been difficult to follow the direction of.
Sorry. You are right. If you're going to give me a jailhouse call, make it to where I can understand what's being said. No, make it sure it's clear and audible and we can follow along. Yeah, I'm done with jailhouse calls.
Of the court.
So done.
We not talk. I tried to go to visit with Asher's son. We tried to remember every birthday, every time, for both Asher as well as you and Kate.
Kayla, I'm sorry, Tracy loves her.
Yes,
Get to know grandkids also.
yes, very much so.
Any questions by the state? Thank you. Next witness, Mr. Fletcher.
Call Dr. Estevez, Your Honor.
All right, let's bring him on up. What's his first name?
Is that correct?
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
You gotta sit. You gotta sit your this on.
Yes, please. Go ahead.
State your name for the court.
Ryan Estevez.
And sir, how are you employed?
I am self-employed as a forensic geriatric psychiatrist.
Okay. And can you tell briefly, if you can, your education, training, and experience in that regard?
Sure. I have degrees from Harvard, Stanford, Tufts, UCLA, University of Florida, University of Texas, and another one from Stanford. The degrees are as followed. It's a 4 years degree, a bachelor's degree in psychology, a 2 years master's in public health, a 2-year degree in social psychology with an emphasis in criminal justice and delinquency, a 4-year medical degree, a 5-year PhD in experimental health psychology with an emphasis in neuropsychopharmacology, a year degree in medicine and neurology, a 4-year residency in general psychiatry, and 3 separate 1-year fellowships in geriatric psychiatry and neurobehavior and forensic psychiatry.
Are you board certified in any areas of medicine?
Yes, I have 6 board certifications. They are in general adult psychiatry, forensic psychiatry, geriatric psychiatry, consultation liaison psychiatry, addiction medicine, and psychosomatic medicine.
Okay. And have any training, education, experience in psychiatry and the law?
Yeah, so social psychology, if you concentrate on the law, that has to do with how groups act in general, and what motivates groups to act. And so I have a master's in social psychology, but I also have a forensic psychiatry training, and that is psychiatry as it relates to the law. So what motivates people's behaviors, and in that case, not just in general, but as they apply to criminality, and how that interacts with the law, how the two systems interact.
Okay. And have you testified in that capacity in court?
Yes.
And any idea how many times in Florida?
I don't keep track of how many times I've testified. It's in the tens, 100 times perhaps.
Okay. Can you testify in other states also?
Not anymore, but I have testified in California and in Texas.
You also have a degree in psychopharmacology.
Yes, that's part of my doctoral degree.
You're published?
I am, yes.
And you were obviously a witness in this case.
That's correct.
Okay. You've been involved in this case for well over a year, perhaps.
I think since spring of 2023.
Okay. And can you tell the court what you did in this case?
Sure. So I did what I do in any case that I'm asked to look at, and that's get information. I requested all of the available medical and police and any other information that might be relevant. In her case, it was around 1,100 pages of medical records. Those include outpatient medical records from the last 10 plus years, the inpatient records that were from Peace River, psychiatric hospitalization that she had, as well as the inpatient records from Blackberry, where she was at. I also went through all the police reports, the discovery documents, information pertaining to the actual event, spoke to anybody that would speak to me, friends, family, colleagues. I ordered an MRI for brain, spoke with one of the country's leading neuroradiologists regarding that study, got neuropsychological testing. And then most important is that I did a psychiatric evaluation of Miss Nix, and have followed up with her on multiple occasions.
Okay. And did you form any opinions to a reasonable medical certainty regarding this?
I did.
Can you tell the court about that?
Sure. So, you start out with not knowing anything other than kind of the headlines of what happened. A child is with guardian and grandparents in this case, and dies. So that's got a very visceral, sort of shocking feeling to it. And you begin to step back, at least in my position, is trying to figure out, well, what, if anything, contributed to that? You're, somebody that's in my position that has spent a lot of time in dealing with the criminal justice system. The first thing that you think of, well, there must be drugs or alcohol or some other malicious motive. This has got to be a bad person.
I didn't think that.
Careless
I
person,
wondered
at
if she
least.
has dementia.
Those are the initial things that you're thinking of. They go along with that sort of visceral response.
Yeah. Bit of early onset.
As I kind of went through the record, and then as I, after evaluating Ms. Nix, and then reviewing all of these records and documents, speaking to people, I got the exact opposite impression. Now, granted, I've evaluated the whole spectrum from serial killers to clergy, in teenagers to people that are over 100 years old. So there's a lot of variability there. But Mrs. Nix is one of the most genuine people I've ever interviewed. I found her sincere. I found her honest, remorseful, and just a good person. I don't frequently interact with people that have her profile in my capacity. So, this just doesn't add up. Something just doesn't add up. So, I was thinking after speaking with some of her colleagues, particularly a boss of hers who had hired Tracy after she retired from the school system. And Tracy had dedicated her life to children, protecting children, educating them, had an exemplary record, was promoted to positions of leadership and responsibility. She's a very detailed person, very intelligent person, very organized person. And so this made sense that one of her, I don't know if I want to say friends, but a colleague that was on friendly terms, hired her to be she was opening a school and she hired her to be a teacher. And a very interesting document that was, in all of these hundreds and hundreds of pages that I came across was a very well-written, articulate, detailed letter of explaining to Miss Nix why she would not be coming back to the school the following year. And I was amazed at the things that were in there. It was because she was doing things that were not like she had been previously, and also not the way that I had seen her or had tested her. These things were as simple as giving the wrong homework to children, swapping homework assignments, giving books from last week as opposed to this week, just these very simple sort of errors that that have to do more with attention and concentration, focus, and those sorts of things. And when I spoke to the principal about this at Harvard, she said, I couldn't make sense of it. It was so out of character for her. But nonetheless, it was there. And so this did not reconcile with the testing I had done with her and the testing that I'd then gotten, further testing with a neuropsychologist that said that she wasn't having difficulties with her attention, concentration, and focus. I think I kind of solved it when I got to her list of medications from the pharmacy that you get. They can give you, if you order a historical record of the medication that she's been on for the time that she's gone to that pharmacy, and went back about 15 years, I guess. And at some point in the early to mid-teens of this century, she was prescribed 3 different medications of note. She has something called fibromyalgia, and that's a chronic sort of vague, I would say, a disease that affects your joints and your muscles, but in different places. You can't always pinpoint, but it can be very fatigue causing. Sometimes it can hurt really bad, other times not as much, but it's a chronic sort of thing. So she was prescribed a muscle relaxant for that, a muscle relaxant called cyclobenzaprine. And there's 2 things that are notable for that. Number one, we know that medication does not work for fibromyalgia. So that's one thing. Another thing is that we know that medication is sedating, but it also has a property in it called anticholinergic property. That just is a fancy way of saying it has a specific side effect that targets the brain and can affect your attention, focus, and concentration. Okay, so she was taking this medication, which I thought was interesting, and she was taking it for years. She was also taking some Ambien, that's a Zolpidem. It's called a Z-Med. That's a medication that we also know it's actually got a package insert warning that it can cause issues with clarity the following day after taking it. And it's only supposed to be taken for 8 weeks. And she had been prescribed that for years. At about a
that's
well, according to the package insert, that was the only the intention of the package. According to the package insert, is to only take it for 8 weeks. So a short-term fix for insomnia. Now she has something called sleep apnea. So it's another reason you wouldn't give that type of medicine to somebody with sleep apnea. You do other things, behavioral interventions. She takes what's called a CPAP machine to help her sleep. But there are other things that you should do if you're having difficulties with sleep. So that's another one. And then she was given another medication called lorazepam. That's a benzodiazepine, which is also supposed to be only taken for a few months because it's got properties that are addictive, but it also can cause sedation, lethargy, and difficulties with attention and concentration. So what it becomes more meaningful, these medications have exacerbated side effects as you get older. So as you get older, this happens to everybody, your metabolism changes because your body changes. You have a higher percentage of fat and water to muscle. Your liver is not as efficient. And so medications that can be tolerated, let's say, by somebody in their midlife or earlier, a young person, can disproportionately or even dramatically affect somebody that is elderly. So this is a phenomenon that's been very well known, very well described, so much so that a guy, a doctor with the last name Beers, like the drink, came up with a list of medications. This is back in 1991, whose risks, or whose benefits are not as much as the risks of these medications. That was the original intent. What is causing some of these issues with these elderly people that are taking these medications? They're having falls. They're having a dementia type of behaviors. They can't concentrate, this sort of thing. Well, let's look at the medications that they're taking. So that was in 1991. Since then, they've had 7 different iterations of that. The last one they published was in 2023. It's a very complete set of medications that are potentially inappropriate for geriatric population. So these are medications that, this isn't controversial. This isn't like that some people say, well, no, those are fine. It doesn't mean that you can't prescribe it, but you better have a really good reason. There must be some esoteric or anomalous reason why you're getting it. These recommendations in the 2023 iteration were based on the review of over 7,500 studies in these medications. It's a massive review, a massive project. It's done now by the American Geriatric Society. So these medications that I'm talking about that I noticed, and I knew this because if you see geriatric patients, you should know that list anyway. So I recognize them, but sure enough, all 3 of these are on the Beers list. Medications that you should not be prescribing for elderly patients. These medications, each one individually, can cause negative effects on elderly people. It can cause, in the body, but and most importantly in the brain. And together, 2 of them, 3 of them act synergistically. And so when I asked Tracy, what do you think happened? Why would you fall asleep? Why would you not be vigilant and alert? Something that she had demonstrated being her entire life as somebody that is committed to protecting and educating children. She didn't have a good answer. She said, I don't know. I just was so tired. I just sat down. The next thing I knew, I was asleep, and didn't have an explanation for it. In other words, she didn't know that these medications by causing it. She's taking medications that were prescribed for her. And so I think after reviewing everything that that had a real dramatic effect on her and contributed to this happening. In other words, if she had not been on those medications, I do not think that this whole event would have happened.
Talk about Ambien. What kind of dose was she on with respect to Ambien, say at the end of taking that?
Well, she was on actually double the maximum recommended dose. She was having
What?
difficulty sleeping. She was still having difficulty sleeping. The dose was doubled. I think this was less than a year that from the event in question. So she had been taking double the dose for a long time.
Okay. So according to the Beers list, she shouldn't be taking Ambien, or at least have a good reason for taking it.
Correct.
You're also only supposed to take Ambien, you said, for no more than 8 weeks.
Correct.
And from your record, you can see she's been taking it for many years.
That's correct.
Okay. And at some point, before she ceased taking the Ambien, and do you know when she stopped taking the Ambien?
Yes, I do actually. When she was admitted to the psychiatric facility after the incident that happened, psychiatrist
Yeah, Grandma had a
reviewed her
mental
medications
breakdown
and
after the
first day
baby
took her
died.
off. It said, shouldn't be on these medications. You're off them.
And in addition to the other things with respect to Ambien, she was taking double the dose that a female should be taking.
Well, I would argue it's even higher because the actual dose that's recommended for geriatric patients is lower than the normal adult dose. But when I was speaking previously, it was just the normal adult dose, and she was taking double that.
To think I'm in the geriatric phase now.
Anything else that you
Well, almost.
did with respect to your findings and your evaluation here?
In regards to that review, no, I believe so.
Pretty much covered it.
Yes.
Did I have another one?
Please.
Would she be aware of these things? And she's on these meds. Would she be aware of what these meds are doing?
So that's a good question because you would think that you would, but these medications are not like having some whiskey, and you know what happens if you drink a lot of whiskey. You're going to be drunk. You know that pretty quickly. One of the problems with these medications is that they build up over time. Let's take cyclobenzaprine. It takes approximately 15 weeks for the body to completely metabolize one dose of cyclobenzaprine. It has something what we call a half-life, which is this fancy way of talking about how fast a medication can metabolize a drug.
15
Cyclobenzaprine is
one
a long one. It is 15 weeks. So you can imagine taking it over time, especially if you're an elderly person, that medication is going to build up and build up and build up. If you're not metabolizing it as fast as you otherwise would, it's going to build up. And so you'll see these effects happen inconsistently during certain periods, like when you're tired, let's say, would happen more so than when you wouldn't be if you're not, if you didn't get rested well. And you would see them more as you age, but also the longer that you take them because of the buildup of these medications.
People closest to her, like her husband, they noticed these things that maybe it was affecting her, it wasn't affecting her.
I don't think so. They can, I run a memory disorders clinic, and I have a lot of people that come in that I pretty quickly know are experiencing some form of dementia. And I'll ask their spouse or kids, have you not noticed anything going on? No, not really. How about the car accident, the 3 car accidents they've been in the last 6 months? Yeah, but he was tired during those days. So when you're close to somebody, and every single day, you're less likely to notice, first of all, changes that are happening. It's much easier to notice changes if you see somebody on one day and then you see them again, the same person, a month or 3 months or 6 months. Wow, they've changed, they've aged. There's a difference there. If you're with somebody every day, you're less likely to see those changes, especially if they're subtle. And so I don't think that they necessarily would have been noticed. Also, just my experience, loved ones are less likely to ascribe negative sorts of things or changes that happen to people in the worst terms. So it's easier to say someone's having a bad day than somebody's brain is failing. So that's why I think this letter that I found from her boss or principal that was just so detailed and so articulate, and giving out lots of examples of what's going on. She noticed that there were some changes, but she was not emotionally attached that way. She was trying to run a school, and she wasn't with her on a single daily basis. To answer your question is, I just don't think so that you would really notice anything like that.
If I pronounce this word, anosognosia.
Anosognosia.
Can you tell the whole place that?
So that's a phenomenon that is described in my field that is common in mental illness and in cognitive disease, where the person does not recognize that they are either sick or that they're having cognitive difficulties. And most people experience a friend or neighbor or loved one that has had dementia who has no idea that they already ask them how they're doing. Oh, I'm doing great, no problem. How's your memory? No, yeah, it's just great. And then they proceed to ask you, how you're doing, how your kids are for the next 3 times in the conversation. But they have no actual understanding of that. And it's also applied to severe mental illness in terms of predominantly schizophrenics that are hallucinating or having delusions, and they don't realize or recognize that these things are hallucinations or delusions. They're quite real to them.
When you began your interviews and your involvement in this case, Tracy had been off that medication for a good period of time.
That's correct. So that accounted for that discrepancy, because when I was reading these things that had happened and their description of her versus my observations of her and this neuropsychiatric testing that she had done that didn't reconcile with that. So we've got to make sense of this data. This doesn't make sense. And she had been off the medication when I saw her over a year, when I saw her for the first time, a year plus. And so the medication finally had an opportunity to get out of her system.
This medication, including the Indian indicated, was prescribed to her long-term by her medical care practitioner.
Correct. So it was a physician assistant, but it wasn't. But he was her healthcare provider. He was prescribing the medications legally to her. She was taking them as prescribed.
Okay. In your as a social psychologist, you testified in court regarding the 5 components of justice.
So as one of the duties that I've been trained on, and I've done many times, is in mitigating and aggravating circumstances for sentencing. That's done predominantly in capital cases that I've testified in, but I've done some in non-capital cases too.
Okay. And then look at that with respect to this case.
Sure. So I think that.
Can you tell it?
Sure. Absolutely. I think that there are multiple mitigation circumstances that are applicable in this case. We had just talked about the influence that she was aware of at all, that the medications were having on her and how that affected her cognition, her attention, her concentration. But there are also, I'll just go through how we describe them in my field. The components of that, there's 5 different components to justice and the punishment aspects of that. And they're retribution, rehabilitation, restitution, incapacitation, and deterrence. And if you look at those individually as they apply to Tracy, and that's what courts typically ask us to do, because you can't apply those fairly unless you understand or know the individual. And once you know the individual, then you can make attempts to kind of advise the court or to educate the court before they make their decision. So what are these different aspects? So, rehabilitation has to do with the idea of somebody typically with a substance abuse problem or a severe mental health problem needing to get that fixed before they can kind of join society and be a productive member of society. A lot of people that don't have vocations or kind of not do anything, get them vocational training. Doesn't really apply to Tracy. She doesn't have a substance abuse problem. She's got a mental health diagnosis and post-traumatic stress disorder. It's not what I gave to her. It's what her psychiatrist at Blackberry gave to her, but I agree with that diagnosis. But she doesn't have a severe mental illness. That doesn't really, I think, apply. She also has a vocation. She was a teacher, but she's retired. Incapacitation is the idea that is part of punishment. You require the protection of society. So the society need to be protected from Mrs. Nix, and I don't think they do. She has followed her bail perfectly over the last 3 years. She has no prior criminal record. She's elderly. I don't think it's arguable that you need to be protected, or society needs to be protected from her. Restitution is the idea of making the victim whole. Two things. Number one, it's impossible. The victim's deceased. But how, for the other people, that the parents, the family members, how do you make restitution for a deceased child? I don't think you can. I think that's impossible. There's no way to do that. There was a civil case that they settled that is I think, attempted restitution. So the restitution that they could make, I think, has already been done in that sense, from a financial sense. But ultimately, that's not, I think, a real possibility.
How are you doing?
Deterrence is another one. That's the idea that you want to prevent this from happening. I think that's another difficulty in this particular case, because this was not premeditated or purposeful action. And it's hard to deter a crime that's not committed voluntarily. I think that's kind of self-explanatory. I won't get into any more of that. And finally, there's retribution. That's the idea that you are punished because you deserve it. And that, I think, what is noteworthy for that is the fact that I think that Tracy has been punished in a lot of ways by this event too. I mean, I think that regardless of the punishment she receives from the court, she's going to carry this with her for the rest of her life. It's something she carries with her every day. It's something that will never go away. I think that that's just something that I think is going to be impactful on her and her relationships that she has, the way it's impacted her family, etc. I think there are also practical reasons that have to be considered, such as does the state of Florida, the community, want to pay to have Tracy in prison? Is that a good use of resources? Can those resources be used in other ways? And I would argue that it's not a good use of state resources to pay to have her in prison. I also think that there is potentially a disproportionate effect on her as a geriatric person that's never been in prison, of a prison sentence is given. She's, I think, almost 67 years old. We know that geriatric individuals don't fare very well in prison. They kind of, what we call age acceleration occurs in prison, is the term that we use.
That is true.
Correct.
There is a fact.
Absolutely.
There's an age
Absolutely.
acceleration in prison.
Unquestionably genuine.
Thank you.
Okay, any questions?
Yes, Your Honor.
We have people on two sides of the courtroom on this one. Some feel that she shouldn't have been charged, that they should have looked at all this mental stuff prior to charging her. Others feel like they should have charged her. The first question I had when I heard about this case was, does she have dementia? Does she's got something going on? And if so, why is she being left with the care of these children? Not blaming the parents, okay? I'm just saying, if there was anything known, why was the children left with her? If not, okay.
Is it your opinion that, I think you said this, that this wouldn't have happened had she not been on the medication she was on? I'm just asking yes or no question. If I got it wrong, let me know. I'm pretty sure.
If you're going to force a yes or no question without any caveats, then I would agree with that.
So is it in your opinion, was she, the reason why she left Uri to die in a hot car is because she was experiencing side effects from medication she was on?
You're ascribing intent that I don't think she had. What I think is that, and what I argued was that her attention, focus, concentration, and energy were affected by the medications that she was on.
I'm asking you very particularly, you tell us that was affecting her at the time she left
Yes.
Uri to die in a hot car. What can you point to show us exactly that she was under the effects on that day? What can you point to?
Well, I told you, I went through that at length about the effects. I want to go through the medications
No,
again.
I'm not asking for your opinion based upon medication. I want to know, is there any one specific thing you can point to that day that shows us you're correct in your opinion? Like she was acting in a particular way that day. Can you point to something that shows this demonstrates, other than leaving her in a hot car to die, this demonstrates she was under the effects, she was experiencing the side effects from medication?
I think it's a natural deduction from the review of all the evidence.
So let me ask you this. You talked about your review of the evidence. There is a video in this case of her at Beef Grace. Did you review that?
Yes,
Okay. And so you got to see how she interacted at Beef Grace.
correct,
You got to see how attentive she was to urine.
correct.
You would agree with me she was very attentive.
I do, yes,
You agree with me she took care of her needs.
correct.
You would agree with me that she brought in a backpack full of supplies for urine.
I don't remember that specifically, but I take your word for it.
Fair enough. You would agree with me she didn't forget urine in the car at Beef Grace.
No, she did not.
And when she left, and she was there for what, over an hour?
I don't remember how long she was. I would assume it was that.
So for an entire lunch.
Sure.
And you would agree with me that she didn't leave the restaurant without taking urine with her.
I would agree with that, yes.
And you would agree with me that when she got back to her car, she put her in a car seat like a person should, right?
Correct,
Strapped her in?
correct.
Okay. So you would agree with me that what you saw in that video is a person who is not exhibiting any side effects that you're talking about.
I would agree that in that particular instance, you cannot see them from the perspective of somebody taking a video of that.
So you would agree with me that the person that we saw interacting with Fury, taking care of her, supplying everything she needed, in that video, didn't exhibit any of the symptoms we're talking about.
At that particular moment, not necessarily.
And that was 15 minutes before she got home, and this incident occurred. It was
Correct,
video.
correct.
Okay. Now, as part of your opinion too, when you were asked about your opinion, I'm just trying to clarify. You said that you believe the defendant is a good person and a genuine person.
I do.
Is that your expert opinion?
That would be my expert opinion, yes.
And the defendant's paying you here to evaluate her, correct?
Or her attorney is.
And then you're being paid to testify here.
I am not being paid to testify. I'm being paid for my time.
Okay, so you're getting money for being here.
I'm being paid for my time, yes.
Okay, no further questions. Any bigger?
You think you're going to record it as open questions?
Well, just that I think that I want to reemphasize that it's not an all or nothing phenomenon if you're being affected cognitively with these medications. First of all, there is going to be an effect that fatigue has. I would argue that the launch of anything contributed to the fatigue that she had, but also that these things are not predictable and are inconsistent. There's times that there are going to be better, times that she's worse, much like somebody that has a dementia or cognitive impairment. Times that they're doing great, times that they're on. Conversations that they have that are good, conversations they have that are not, and that is very difficult to predict and just very inconsistent.
When you're sitting in front of a child and seeing the child, might be easier to get.
Of course, if you have that, absolutely, if you have that stimulus right in front of you, it's much easier to attend to than a stimulus that's not there.
Thank you, sir.
Thank you. Excuse, sir. Defense, next witness.
Take a short break. 10 minutes, everyone.
Your dad and I didn't want to have children right up front. And, you have this thought that when you want to have children, that it'll just happen. And that's not what happened with you. I went through fertility. We tried on our own for a long time. And then I went through fertility drugs. Next.
Kayla is your firstborn child.
She is.
Grandmother. Oh, let's hear her.
When you were pregnant with her, was that a difficult pregnancy?
It was difficult getting pregnant. It wasn't, the pregnancy itself was not difficult, but getting pregnant was very difficult.
And how did her birth make you feel?
How did what?
How did her birth make you feel?
I'm glad that you're sitting there, Kayla, because I want to speak directly to you. That's why I'm sitting here facing you. Your dad and I didn't want to have children right up front. And, you have this thought that when you want to have children, that it'll just happen. And that's not what happened with you. I went through fertility. We tried on our own for a long time. And then I went through fertility drugs to try to have you. And then I went through surgery to clean everything out and to try to have you. And I tell you that because I want you to know how much you were wanted and how much you were loved. I thought you were the most beautiful girl that had ever been born on this planet. I thought you were the smartest girl that I had ever seen. And I adored you.
Toxic. You ruined it.
Was I a perfect mom? No, I wasn't. But I love you. And I have always loved you with all my heart. And I tell you that because I can't imagine how I would have acted and reacted had you been taken from me. I cannot imagine that. And then if Rebecca had also been taken, it would have been more than I could have taken in. And that's the only way that I can understand what you've been going through and what Drew's been going through. I miscarried, but I didn't lose a baby like you've lost a baby. And I've tried very hard to understand where you've come from, where you are, and how I could be anything to you. I guess I answered that. What more?
You've been on medication, oral medication for a long time, about 20 years. Okay. Do you have any idea those medications were affecting you?
No,
Okay. Did you trust your medical provider?
I did.
Who all in your family went to this?
Rebecca did, and I think Kayla did. I believe Kayla did as well.
And when were you taking off this medication?
If you'll allow me, I need to back up just a little bit. May I?
Yes.
I know that both of you have felt that I have evaded questions. I haven't evaded questions. I wasn't allowed to talk to you. I wasn't given the opportunity to talk to you. And I think that the one piece, I mean, different ones have alluded to how things happen, but the piece that has been left out is I had Uriel 4 days the week before, and I wasn't expecting to have her on this particular day. Kayla called me and asked me, said she was getting her hair fixed, and asked me if I would be willing to take her. I would be willing to take that child any day of any week, or as long as they needed me to. I love my grandchildren, and I would have done anything for them. So when she asked me to take her, you know, it disrupted what my head had in mind for that day, but I was glad to have her. So after I had a prayer time that morning, and I called Kayla and asked her, I said, a few ladies wanted to get together and go to Beef O'Brady's. Does she mind? She had already asked me if I would keep Uriel, excuse me. And I had said that I would. I said, do you mind if I take her with me? And she said, no, that would be fine. So the piece that was left out is that when I went to the glass shop to pick her up, the other Kayla Nix, or Kayla Chalk, helped me. I had Uriel in my arms, and she had the car seat. And I always put the babies on behind the passenger side so that I could see them out of my periphery. There was when your baby's sitting behind the passenger side, you always can just turn your head a small amount and see them. That particular day, there was a car that was that had pulled in close to the passenger side of my car. And when Kayla Shock took the car seat around to the passenger side to put it in, as I had asked her, the car was too close, and Kayla couldn't get the car seat in the car. So she came back around and she put the car seat behind where I was sitting, behind the driver's seat.
Oh, so it's
And
somebody
we went on about our business. She was the talk of the town at Beef O'Brady's. We thoroughly enjoyed her. She was
Didn't see the
perfect.
baby she thought about.
And when everything was over and I put her back in the car seat, I very succinctly and carefully had everything all packaged up, and I slid it on the floorboard under her car seat. And she was so sleepy, I think from just being on that whole time, that I gave her bottle, and she immediately fell asleep. And I don't live far from Beef O'Brady's, but she was sound asleep within seconds of me backing up. So when I pulled in at the house, there were roofers. We were having our roof redone, and they had asked me to not pull into the garage because he didn't know if there'd be stray nails or whatever in the driveway or on the driveway. So I backed up under an oak tree, and I can remember literally looking over to the passenger side in the back. Nothing was there. I looked in the passenger side in the front. Nothing was there. I looked at the dash. Everything looked clean. And so I got out of the car and I went in the house and began to do the things that I had on my mind to do. And this is perhaps where the medication does come in. She got quiet, and I forgot that she was there. She was quiet, and there was nothing there to remind me that she was in the car, except the things going through my head that I needed to do. So I may I go on from here, or do you want? I didn't realize that Uriel was in the car. I literally forgot it for a long period of time.
I know that that can happen. Under a lot of stress, distracted, not a part of routine. I get it. But she still needs to be held accountable.
Did know that I had made plans with Aiden, which is my oldest grandson, to take him to Walmart in Sebring to look for some Christmas ideas for him. And then I was going to take him to dinner and have him back early because it was a school night. He was about 4:15 or so. He was feeding the pigs back behind the barn. And I got in the car and I pulled up to the barn. And Nay came with his lawnmower around so that my driver door and where he was sitting in the lawnmower, I just opened up my driver door and we could talk. And we were just chatting about, I don't even know what. And I
Couldn't smell
I
it.
said, when did Kayla come for Uriel? And he just looked at me. He said, I've been outside. I don't know. And then I said, when did Kayla come for Uriel? And it began to dawn on me. And then I opened the door and realized that she was in there all along. I could tell that she had passed when I looked in the car. And I ran back behind the barn to the west side of the barn. I looked for anything I could find to hurt myself. I wanted to be gone. I did not want to have to deal. I didn't want to have to look at Kayla and Drew and tell them that this had happened. I wanted to be gone. But there was nothing there. And there was not anything that I could find that would do that.
Guys, I
So I
can't
fell on my
to her emotionally. I have to self-care.
I don't know if you want
I
to
have
ask
to
kids, but
self-care.
if you do, I'm sure it would be your worst nightmare.
Case, and I excluded that child is. And and anything to the contrary, and any excuse to the contrary is testimony about the girl was sleepy and gave a bottle and immediately fell asleep. And there's a video, and I don't recall seeing that. But I also recall in the trial, they talked about giving the baby a straw and some water and a straw, and that this was a situation where their baby didn't have food and milk. And I went through, and I'm going to come down to this in a minute, but the evidence that comes in, I wasn't there, you weren't there. The only people that were there were Miss Nix, and at the time, we get evidence after the fact. And when we're sitting in the room and we're watching it, it comes in. Like, here's the back seat of the car, evidence 41 that came in. Here's the front seat of the vehicle, 40, where there's wipes and things in a car. And when people go places with kids, they leave objects, bread on the steering wheel, things in the front seat to remind them where they had a child. And I'm not talking about a child that was there, you had an hour-long, 2-hour-long drive. I'm talking a 7 to 9 minute drive. Here's the exhibit 29. It's the back seat of the car. There's evidence everywhere. Then we see the picture of when Nay and them got there. That's evidence 23. I then have a half-empty thing, a bottle, evidence 35. So I see all of that, and I see all the reminders. And then I remember Kaylee and Nix saying that the Lexus, the red Lexus, was equipped with a red rear occupant alert to alert an adult to a child in the back seat. And I know that these cars, Fords, Lexuses, everything has so much weight in the back seat, beep beeps go off. And I hear her saying I didn't have that. But then I read the deposition taken of Kaylee and Nix, docket entry 201, October 1, 24. Do you know who put the car seat, page 32, line 5 to 7? You know who put the car seat into the car that day she picked up Uriel at the glass shop? I do not. I do know it was her tendency to put the car seat in herself. Okay, Kaylee answered. She typically, whether I was standing there or not, would pick her up and set her in there. And then I would typically help reach over and strap her in. But a car has sensors, weight sensors. So that, just like my vehicle, whenever I stop and put it in the park and turn it off, there's a loud ding that says, check your back seat if there's weight in the seat. And so those are things that I'm aware of that were in a vehicle. So when she put her in there, I did not imagine that I had any other staff assistant in the moment putting a car seat. Did she normally put the car seat behind the passenger or driver's seat? I have her telling me it was in the driver's seat because Kaylee did it, and I have Kaylee saying that it was typically in the driver's seat. And then I have these tendencies and these things that I see that show that there's a baby in the car. And let's not forget that we just left Beefville Brady's. This child was the apple of everyone's eye there. I've been to the Beefville Brady's. I've had lunch there. There's a lengthy video. There's a video of the car in the parking lot. At the end of the day, Kaylee Shock presented this evidence to me through her testimony, her victim impact statement, and her the deposition. The defense has presented to me the witnesses and the evidence. What I know for a fact is Tracy Nix left Uriel in the car at 2 p.m. for over 3 hours. At no time during the 10,800 seconds that elapsed did she think 1 second about her granddaughter. Uriel Shock was there for 2.5 hours with her that day, and she just saw her 7 to 9 minutes before, and then she goes to the residence 7 to 9 minutes away. This child, like I said earlier, was the apple of everybody's eye. It captivated, entertained the patrons and the people at Beefville Brady's, much like a 7-month-old does, a year-old does, a 2-year-old, a 3-year-old does. You know what you're doing with them, and in 7 to 9 minutes, by golly, you know where that child is. And and anything to the contrary, and any excuse to the contrary is just that. I heard and saw the body cam footage along with the interrogation room video of Tracy Nix immediately discovering what happened after she has a grandchild passed away. She was distraught. I don't believe there's a lot of remorse in that about her grandchild suffering and death. Rather, I see her more concerned with her community image and the death of the child. I want to leave. I want to go away. I want to do this. I want to do this. I want to do this. And I hear today the evidence and the testimony, and I get a little more remorse on that, but is it truly remorse? Tracy Nix, throughout these proceedings, has contended these acts were involuntary. She couldn't form the requisite intent to commit a crime. Her narrative is that she forgot because of senility or by taking her prescribed mind-altering medications. There's no credible evidence to the court that's persuaded this court to mitigate her sentence as the attorneys have requested. This defendant, like many other defendants facing prison sanctions before, is trying to avoid or lessen a prison sentence once arrested and after a jury finds them guilty. They justify what happened rather than accepting blame and truly evidencing remorse. I have practiced law for 30 years. I've sat on this bench for 3.5 years. I've met my share of people in the Florida state prison system, the federal system, and I understand that they minimize their conduct and they also don't accept responsibility. And that's how it is. There's a pile of them down at Hardy Correctional that'll tell you the same stories that I heard here today. The ultimate determination of when we do a case, and I excluded the evidence of the experts on the defense side. It's when you look at whether a defendant is competent to proceed, it's my determination in state court, in a trial court. Under the Dougherty v. State case, 149 Southern 3rd, 672 at 678, the trial court is not bound by the reports or opinion of experts. The defense in this case never afforded nor volunteered Tracy Nix to the state of Florida to have her evaluated by its own experts. So the state of Florida, the citizens of Florida, were denied the right to contest the evaluation and procedures and conclusions of the Tracy Nix retained, hired experts. They all say we're here for our time. They come in here, they get paid, they give their opinion. They give their opinion. If it's valid for the defense, they testify. If it's not valid for the defense, they don't testify. I heard this man's testimony. In a competency or an insanity case, the state has a right to contest the evaluation procedures and the conclusions of the court-appointed experts. Had she alleged incompetency or not guilty by reason of insanity, the state of Florida and all the citizens would have the ability, the state would have the ability to hire its own experts to evaluate her mental and physical claims. The state was not afforded that here. And that's why we have a 35-year-old law that says you can't bring in diminished capacity. I ruled on that. I'm not going to revisit that rule. The state, as a representative body for the citizens of Florida, has a right to a fair determination and meaningful opportunity to be heard to conduct its own review of Tracy Nix. All of her defense experts were hired for their time and to defend her. They had unbridled access to her so they could present their opinions to the court. What I noticed was there was no, what did the MRI findings say? I don't know. I wasn't given that. There are many tests that mental health experts can perform and routinely do perform on criminal defendants to determine if a criminal defendant is falsifying or exaggerating facts or symptoms. There's called malingering. There's no medical records nor testimony presented to this court that she suffers from Alzheimer's, dementia, or senility November 1 of 2022. None of the defense experts have testified they tested Tracy Nix.
Had that been there, I would be a little more sympathetic. In all honesty, I have no sympathy.
From malingering or confabulation. They simply say, trust us, we are experts. The court declines to do that. In Florida, the term for imprisonment for a second-degree felony is up to 15 years in prison. First degree is up to 30 years. Life is up to a defendant's life. And in a capital case, I can sentence somebody to death if the aggravating factors exceed the mitigating factors. In this case, Tracy Nix has been found guilty of a third-degree felony, punishable by a maximum of 5 years in Florida State prison. On January 15, 2025, a jury found the defendant guilty of one count of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm, but in reality causing death, and not guilty of one count of aggravated manslaughter. I've already gone over what I've talked about with Rule 3.704D9 about the victim injury points. Her score sheet is 44 points. Under Florida law, the maximum sentence I can impose for Tracy Nix is 60 months or 5 years in Florida State prison. For me, as a trial court, to impose a departure sentence, it's a two-step process under Banks v. State. 732 Southern 2nd, 1065, 1067. First, I must determine whether I can depart. That is, whether a legal basis exists for the departure sentence that has been established by a preponderance of the evidence.
Nail her butt
Two,
the wall.
even if a valid and supported legal ground exists to permit a departure sentence, the trial court must still determine whether it should depart and whether a departure sentence is the best sentencing option in a given case. Two facts the defense argued in their motion to mitigate. 9, that Tracy cooperated with the state of Florida to resolve the offenses she was charged with on November 1, 2022. The court finds that not to be the case here. Tracy Nix did not cooperate. There's no competent substantial evidence that the crime she was charged with was resolved as a result of her cooperation. To the contrary, she investigated it, she went to trial, she didn't enter a plea to count 2, and she didn't cooperate with law enforcement or the state prosecutor. The second ground they sought mitigation is 10, which is an unsophisticated, isolated incident. There's 3 elements that must be proven by the defendant when you raise that mitigation, not 1 or 2. Number one, Tracy Nix has to prove to the court that the offense was committed in an unsophisticated manner. Number two, it was an isolated incident and she has shown remorse. All three elements have to be proved. You can't prove one or two, all three. Tracy Nix and her husband had the 17-month Ezra at their home who died 11 months earlier. That is a fact. That came in every hearing I've been in, and I've heard it today as well. The grandchild urial shock tragedy is not an isolated incident. This is the second. The court watched and heard her interview. I do not believe she's showing remorse. I believe she's showing sorrow. It is impossible for a defendant who refuses to accept responsibility for an offense to show remorse for that offense. Sympathy is not the same as remorse. Sorrow is not the same as remorse. When I look at the Florida statutes, when I deal with sentencing under 921.02, subsection 1B, the criminal punishment code's primary purpose is to punish an offender. Rehabilitation is subordinate to the goal of punishment. Subsection C, penalty imposed shall be commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The court does not find that the defendant's sentencing proposal is the best sentencing option. Rather, Tracy Nix should spend the next 60 months in Florida State Prison with credit for time served. The trial court is guided by the code, the sentencing guidelines, and the express purpose for criminal sanctions under Florida law, and a Florida State Prison sentence of 60 months is the best sentencing option. The court also finds that she knew how she was feeling on November 1. The multiple videos, some with audios that day, and the testimony of her Bible study and many friends unequivocally established her awareness that day she is not competent, nor is she insane. She caused urial shock to suffer an agonizing, prolonged death that was avoidable. The court saw all the evidence in the photos. I want to note the diaper bag that was brought into evidence, Exhibit 36, Exhibit 37, Exhibit 38, Exhibit 39, was the most organized diaper bag I've ever seen in my life. And I heard testimony that the child didn't have food, this, that, and the other thing in the beef O'Brady's, and they fed her through a straw. I note that it was an excellent diaper bag. The bottles, food, medicine, and the items were all in quart bags, Ziploc bags. For witnesses to say or allude that urial had no milk, formula, or food is hypocritical and untrue. The court finds such testimony by any such witnesses not credible for sentencing purposes. The defense's recitation of the mitigating factors without confirmation by any unbiased expert, in addition to the deficiencies the court found earlier, also fails to establish by a preponderance of the evidence any mitigation that is to be considered by the court today, nor do they amount to competent, substantial evidence for this or any court to justify a sentence of less than 5 years in Florida State Prison. The defendant restrained urial shock in a car seat, and the child was severely injured before she died. There were plenty of signs to Tracy Nix that she had a baby in her car that day and she was responsible to protect it. She failed in her protection of urial. I will not fail this state or this community in my duties as a judge to fashion a sentence that I feel is appropriate for these type of charges. You can call it whichever one of the 5 points you call it, but I'm calling it a just and determinate sentence based on the facts and evidence that I have seen here and heard here and presented today. The court hereby sentences Tracy Nix to Florida State Prison for a term of 5 years, Florida, or 60 months with credit for all time served. A $5,000 fine shall be reduced to a judgment lien. The cost of prosecution and restitution will be reserved for 60 days. Y'all can agree on it or we'll have another hearing. She will be remanded under the supervision of the Department of Correction until her term of prison ends. Now I'm going to speak to this community. I'm not from here. I'm from Winter Haven, Polk County. This community needs to move past this case and leave Kayla and Drew Shock alone. Let them and their 2 children live in peace. This family has lost 2 children, Ezra Shock and Uriel Shock. The tragedy of this case is undeniable. A baby's life is over way too soon, and a family has been severely impacted in unimaginable ways. Whenever a child dies, this entire community suffers. This community needs to move forward and start the healing process. I have made a final determination here. I'm not putting people on probation to be walking around this community to rehash an issue or something to come up. I have sentenced her to 5 years in Florida State Prison. I want this community to move forward. The legislature defined this felony crime. A fair and impartial jury found Tracy Nix guilty, and I, as a circuit judge for Hardy County, have sentenced her accordingly. Ms. Nix, you have 30 days to appeal the judgment and conviction of this court. If you cannot afford an attorney, one can be appointed for you without cost for appellate purposes. Mr. The state, do you have anything further I need to deal with?
Your Honor, to head off an issue will waive cost of prosecution, so we don't have here.
Okay. Do you want to reserve on restitution? If you don't, you can reserve it, and then you can either agree, disagree, or say, Judge, we're not having it, it'll go away on its own.
Your Honor, we can reserve it, it'll probably go away on its own.
Okay. Mr. Fletcher, anything further we do?
One thing I have to say as her attorney, they Nix today, and I think, I don't know if she's still here, Alex Amanda Fletcher testified there wasn't any car.
I understand. I understand.
Because you said that, I thought you said there was.
You talking about the car seat?
Obviously, we
How do you
disagree
like
about
the rug on that
I'm
man's
not
head?
agree with that. we also have a motion for supersedes bond.
You're absolutely correct. Once you file your notice of appeal, the supersedious bond steps will go into effect. You'll have a hearing on your motion. But the first event that has to happen is a notice of appeal. Once that's happened, send it to my JA for your information. Ursula Nathy is my current JA. Next week, my new JA will be Julie Cochran. Her email address will be circulated on the website. It'll be J Cochran. So file your notice of appeal. You can either reiterate the motion you've already done on supersedious bond or file a new one. And then I'll set a hearing time that's commensurate with both of y'all's calendars. Mr. Coleman and my JA will work with you on that, okay? And if you're not going to handle the appeal and you got a public defender, please get your paperwork in sooner rather than later.
We have an attorney.
Thank you. Court's adjourned.
His,
I'm adjudicating your guilty, okay?
he needs, I'm sorry, dude. You are trying so hard to be so much younger than you are. That rug on your head is like 30 years too young for you, dude. I'm sorry. Not.
Correct.
I'll fix that file as well. That's an old-fashioned lawyer for you. Okay. So found guilty, convicted to the maximum under the law that they could. We have some Karen Reed documents we're going to read real quick, and then we're going to get into the Monica Sementilli trial. We are late, but I felt it was important to go ahead and watch that. Okay. Karen Reed, thank you, Discord, for this documentation. Yet again, you have come through for us, as you always do. Thank you again for the documentation, and we greatly appreciate you so very, very much. Thank you. So, the defendant, April 2nd, 2025 motion requesting the clerk's list of jurors. Now comes the defendant, Karen Reed. Miss Reed, defendant in the above captioned matter, requests update clerk's list of jurors for the Norfolk. Miss Reed asked for the list to be released to her, lawyers, and jury consultant, and the law clerks who are working with Miss Reed's legal team. Then motion 622, defendant's motion requesting clerk list of jurors. It's the same thing. Reiterated. That's what I have at the moment. We are going to, let me pop up. Oh, that's not what I wanted to do. Let me see if Monica Sementilli is live, and we will pop on over to Monica Sementilli. Yes, Monica Sementilli, closing arguments will happen. God help us if that woman goes long. I'm kind of glad we're delayed because we can zoom her. And here we go. Monica Sementilli is now on our court docket for this morning. Closing. Oh, I think I already have that. Let me cancel. State's closing arguments. There we go. Let's see. Matthew, I don't know what you're cooking, but it smells great. God, that smells so good.
The defense exhibits were received except the transcripts of the audios and item number 621. And all the remaining exhibits from the people have been received except for the transcripts. And they're available to you if you ask for them, but they're not received in the evidence. So all sides have rested. And this is the opportunity of the lawyers to argue the matter to you. You're admonished once again that any statements of the attorneys are not evidence and not to be considered by you as evidence, and that includes arguments. The people will argue first. The defense will be able to argue, and the people will be able to close because they have the burden of proof in this case. This time, the people may argue.
Of course.
Ladies and gentlemen, feels like it's been a very long time since I stood up here and spoke to you last. I actually counted up the days yesterday. I think I've aged significantly. It's been about 40 days that we've now been in trial. And I know that you're all very anxious to get to deliberations. We're very anxious for you to get to deliberations. But I also wanted to take the opportunity to thank you over the course of the last few months. It's actually only a couple, but it's March, so it's like 3 months. So I'm going to count it that way because we started in January. And if you recall, when we started, it was around the time of the 8th anniversary of Fabio Sementilli's murder. And we've come far since that date when we started an opening statement. And if you recall, I told you from the beginning that the evidence in this case is enormous. And in my opening statement, I laid out what I expected the people's case to look like. Throughout the last several weeks, we've then presented exactly what I told you we were going to present. And in addition to that, we presented much more. And I know that you might have surmised by now that I tend to be very thorough and detailed.
Long-winded.
And so I hope that you'll bear with me in my closing arguments because I will likely be just as detailed and thorough.
Oh my
I've
God.
learned over the years
2 days closing
that
with her.
it's my job, my responsibility. We have the burden of proof that if I go over with you the evidence, not all of it, some of the witnesses I'm not going to talk much about because I think you've heard a lot about the details of what happened on January 23rd of 2017. I think all of you could probably lay out the timeline as well as I can. But I'm
By
going
now,
to highlight
I
some of
think we
the
can.
pieces of evidence, some of the witnesses that were significant in this case. I'm also going to try and break down the law that Judge Cohen's going to give to you at some point, maybe tomorrow, and try to explain to you how the law and the evidence fit together, how the evidence proves the crimes charged, as well as the 2 special circumstance allegations in this case. And also try, because this is not an interactive process, I do not know what questions may have arisen in your minds throughout the trial, but I try to anticipate those so that it makes
I'm
the
going to
deliberation
zoom.
process
She talked.
go more smoothly, so that perhaps that process in the deliberation room goes more efficiently. And feel free to stand up, to stretch when you need to. I have serious back issues, and as some of you may know, I wound up totaling another car on the way into court at the beginning of this trial. So I totally understand. Also, it helps to move around, if not necessarily that you're bored, but things can become tedious. Feel free to do so. As you've probably noticed, it doesn't throw me off at all. So
thanks for that permission.
yeah. As I told you at the beginning of this case, during opening statement, that this would be a case about betrayal. It's a case about greed. It's a case about lust. And during the trial, I looked up the definition of betrayal. And the judge is going to instruct you that you can't do that. You can't look things up when you go back into your deliberation. So I did for you. And I wanted to see what the dictionaries defined betrayal as. And this is some of the adjectives, the synonyms that I came up with. deception, disloyalty, treachery, duplicity, devious, cheat, trickery, fraud, cunning, breach of trust, false-hearted, underhanded, unfaithful. Each of those words perfectly describe this defendant. This defendant who was the mastermind behind her own adoring husband's gruesome murder. You heard in this case that he was slaughtered on his own back patio by the one person he should have been able to trust the most. And I told you at the beginning of this case that a marriage is an agreement, a contract, a decision, a choice that's made between two people who presumably love each other, hopefully grow together, raise a family together, are there for each other during difficult times, which absolutely are going to
we're
come
good,
no
Ronnie.
matter what
We're good.
you set up in your life. Things don't always go as
Ronnie, I want to move it along because she is going to have us here for a month. Man, I think she risks losing the jury if she does what she does and
we
didn't
plan.
open.
I know a lot of you are aware of that. And that although Fabio was the provider for his family and that he worked to give his family the best, even moving his family from Canada down here to the United States, California, he did it because he wanted to provide for his family. And you heard about that through his executive assistant, Alicia, various other individuals who knew him. And what you heard was that he wanted the best for everybody. And he was a unique person. It's not that often that you come across somebody who has such a large personality, who's larger than life, and who's able to inspire. But he also loved his wife. And what you learned is that his wife is an incredibly selfish person who portrays herself as the victim. She's a narcissist. She's a liar. She's a cheater. She's a manipulator. And she's arrogant. And she's the one who's brought all of us together in this courtroom where you sat and listened to the evidence. Nobody who gets on the stand, other than maybe the detectives, knows this case in terms of all of the details the way you do. And in this case, what you heard was that the defendant deceived everybody. She deceived her family. She deceived her friends. She deceived Fabio's colleagues. And worst of all, she deceived her husband and her children, who relied on her, who trusted her, who believed that above all else, this wouldn't happen, that she'd be there for them. You heard from Luigi Sementilli, Fabio's son, that while staying with his father and the defendant the year prior to Fabio's murder in 2016, the defendant bragged about manipulating people at a car dealership. She had purchased a new Fiat. And she told him when she got home that she cried and screamed and threw a tantrum at the dealership in order to get a better deal. And maybe it didn't mean that much when he said that because it was prior to Fabio's murder. But little by little, there were small details, pieces of evidence that built the foundation for what came next. Who was Fabio? Who were the people close to him? And that was important because we wanted to make sure that we demonstrated to you that this is a person who had no enemies, that he worked hard to reach out to people and, as you heard, to bring them along with him because his success was built on so many different people and his interactions and his ability to communicate as a hairdresser, which is what led him to this very unique position, perhaps the first person, as you heard from some of these individuals that testified, in the world who were able to bridge that gap from the hairdresser's chair to an executive position at a multi-billion-dollar company. That he knew the industry, he knew the people, and he had great instincts. He had great instincts. And I'm going to get back to some of the evidence that we heard where perhaps Fabio's instincts told him one thing, but his heart told him something else. And so he trusted the defendant to be his partner, to never betray him. And she took advantage of that. She took advantage of the fact that she knew he was that type of person. And of course, you then saw that same type of behavior, that manipulation at another car dealership after the fact, which is so much more horrific and offensive when you use your husband's murder to get a deal. And in addition to that, I want you to also keep in mind the reckless disregard this defendant demonstrated for her own children's lives. And I want you to ask yourselves, what do you think? What do you think would have happened had Isabella arrived home just 5 minutes before and found Robert Baker in the house? You think Fabio would have allowed a witness who knew him, who knew he had just murdered somebody, to survive? Somebody who wasn't completely loyal to him, like we know Austin was, who would just blindly follow? You think he would have let her live to testify against him? Maybe. Maybe not. But from almost the beginning of 2016, the defendant and Baker were involved, as you heard, in not just your run-of-the-mill affair. When the defense told you at the beginning of this case, the only thing we have evidence of is an affair. That wasn't true. This was an obsessive, all-consuming love affair, where these individuals, these two depraved people, the defendant and Robert Baker, believed they had found their soulmates in each other. And you know what? I think they did. They wanted to be together. They planned a future together. And that included traveling, as you heard, and living together. The problem was that in order to get that future, to live that life that they so desperately wanted, they had to get rid of Fabio. And I don't care what the defense gets up and says. Divorce wasn't going to get them what they wanted. Her family never would have accepted her divorcing somebody like Fabio, who over the years they grew to love, like a son, like the son they never had, who took care of them, who stayed with them when he traveled, who treated them like his parents, because you heard from Morella Sementilli that Fabio's father died when he was very young. And he loved them. And they came to love him. But there's no way on God's green earth that these people were going to accept someone like Robert Baker, a registered sex offender, an ex-porno actor, a habitual liar, a convicted felon, someone who had no money and no prospects to be their next son-in-law. That wasn't going to happen. And the defendant, as you saw throughout numerous witnesses, is someone who needed people to feel sorry for her because she's always portrayed herself as the victim. She needed people to want to help her. And what did you see in this case? Weeks and weeks of witnesses testifying who fell all over themselves to help her children. And she needed to get her hands on some money because we know she was unemployed. She did not have any job prospects other than perhaps, as somebody mentioned, maybe going to work for Baker. She did not take Ernie up on his job offer to work in one of the warehouses and run one of his businesses. And she certainly wasn't going to wait, as you heard from that divorce lawyer who broke one of the cardinal rules of confidentiality when you're a lawyer. You don't get up on the stand and talk about all your clients and all the divorces.
It is overruled.
He did that. He'll own that. She needed to get her money, her hands on money fast, not over the course, as he told you, of perhaps a decade, which was completely speculative. And as Ms. Ebersbacher told you, was completely speculative, hence why she couldn't include an exact number in her chart. I think you understood that. But she needed money so that she and Baker could fund their new life together. And certainly with him out of the way, instead of getting half of the house, she gets the whole house. Instead of maybe a half of his stock options, she gets all of the stock options. Instead of whatever alimony, temporary or permanent support a judge might award her that required her also to get a job, she needed more money than that. Keep in mind, and I know this goes without saying, but it was something that maybe got lost in the mix of all of the arguments about things that really didn't matter. There's no life insurance if someone doesn't die, right? And how much does she get? If she divorces, there's no life insurance. But in this case, once he dies, she knows she's the main beneficiary on Fabio's policy. And you saw, and we'll talk about the percentages and all of that, but in each case, she got the largest piece of the pot and the children split the difference. We also heard about her planning for the future through various witnesses that she and Baker told about their plans for the future, such as Sheila Salahian and her husband, Ricardo Cabrera. And you saw some of the photos of their evenings out and their trip to Las Vegas, or Ron and Michelle Ray. And we'll talk about, again, in more detail, the plans that they discussed with them. And you heard an enormous amount of evidence about the fact that the defendant and Robert Baker acted in concert. They acted together as a team in order to bring about the object of the conspiracy to murder Fabio Sementilli. That object of the conspiracy, the death, the end of Fabio Sementilli's life. And you might believe that the defendant loved her children, and that may be true in her own narcissistic way, but she certainly loved Robert Baker more. And she couldn't wait to start her new life with him. And you heard about that as Detective Gable testified about how important the post-murder behavior is. And we'll talk about that this morning as well. But what you heard, even through one of the defendant's closest friends, a woman who claimed that she was also close to Fabio Sementilli, Miss Obad, every time Fabio turned his back, the defendant was on her way out the door to meet up with Baker. And you heard in cross-examination the questioning about the fact that while Fabio was on a business trip, that the defendant was texting him, "Good night, baby." And then the next thing you know, she's telling Jessica, "I'm out the door, door's open." And 45 minutes later, she's in a French maid costume, dressing up at Baker's apartment. And after the brutal murder of her husband at their home, remember, your home is your sanctuary. And I know some of you, we discussed during jury selection, have had that unfortunate occurrence where someone breaks into your home, or it's something that you take steps to prevent, to protect your family, what's yours, from somebody coming in and doing something like what happened in this case. You don't feel safe in your home anymore when somebody breaks in. I'm not saying when somebody breaks in and robs you or burglarizes your house. I'm talking about when somebody is murdered in their residence at the place that is supposed to be your safe haven. When you have someone that violates your safe haven, you can no longer feel safe there. And you heard about that in this case from Isabella Sementilli. And so again, after the brutal murder of Fabio in their home, night after night, the defendant's out partying, having sex with Baker, going to comedy clubs, bars, playing pool into the early morning hours of the next day. And also keep in mind a point that you heard, that Baker stayed at various locations immediately after the murder. You heard about LaShane Holmes' house or apartment. That was the guy that was on the ankle bracelet. That was also a registered sex offender that Baker had met years ago in prison. He stayed for a time, as you heard, with Sheila and Ricardo Cabrera. And then eventually he goes over and he stays with Roger Brown out at 331 Salem Street in Glendale. And the defendant is going there to pick him up. She knows he's on the run. Well, why do you think she would believe he would be on the run? From what else? So again, if you use common sense, which you all have, and that's why you're all here, when you use common sense, these questions aren't that difficult. Of course she knew about his role in the murder. This would have been, in and of itself, a dead giveaway. And otherwise, if she didn't know who the killer was, you think she would be leaving her kids alone in the home? No, the reason she does that is because she knows they're not in any danger, because the real killer is out with her. It's the only reasonable explanation to explain her behavior in the aftermath of Fabio's murder. Anna, the defendant's sister, testified that the defendant flew home on February 8th after the funeral, the services, the cremation, because the defendant wanted to grieve alone with her girls. And because February 8th would have been...
That bothered me. She expected the company to send his body from America to Canada, tens of thousands of dollars. And then, instead of burying him, they cremated him, which the company paid for. Oh my gosh. Plus
her 20th anniversary, her 20th wedding anniversary with Fabio. However, what you heard was that as soon as she got home, the defendant went out with Baker that night. That's how much she cared about the fact that she had spent almost 20 years living with Fabio Sementilli. And Bella, a young girl who was obviously terrified about being left alone in the home where she found her father dead, is texting the defendant that she's afraid, that she's in distress. Even Sally Schoen. Do you remember Sally Schoen? She was the executive from Wella who told you that Fabio was her successor at the company, that she ran North America for a period of time, then left it to Fabio, and she went over to Switzerland to run global for Wella and then Cody. And what did she say? She's a grown woman. She told you that she was frightened to be in that house after the murder. And that was as an adult with multiple other adults around at the time. And Jessica, regardless of how much she wanted to convince you that she was fine with her mother always being out after her father's murder, was also just a young girl. And what kind of mother brainwashes her children to get up on the stand and testify to what an amazing mother?
Objection, Your Honor. That's argument.
It is?
This argument, it's overruled.
Attacking children.
I'm sorry, counsel. I've ruled.
What kind of mother
Woo! He's like,
brainwashes
I'm
her
so
children
done.
to testify to what a great mother she is, when we all know there's a mountain of evidence that proves otherwise? And make no mistake, Miss Stagel and I, we're not here because she's a horrible mother. We're not here because she's a horrible person. We're not here because she's a cheater or a liar or any of the other words that you could use. We're here because she's a killer.
I'm
And
gonna
what
get some
kind
socks. I'll be
of
back.
parent? What kind of parent completely destroys her entire family? I mean, literally throwing away happiness with both hands and a shovel. What kind of parent destroys the lives of her family, of her children, for somebody like Robert Baker? And you heard the defense try to sell you a false narrative. They called Isabella, they called Anna, and they did that to try and humanize the defendant, a person who's utterly devoid of integrity, human decency, honesty. And as I discussed, her sister Anna tried to convince you that the defendant is a trustworthy, honest person. She even testified that the defendant is not secretive. And yet, as you saw, as you did with so many of the defense witnesses on cross-examination, everything they told you on direct was destroyed. Because her text messages to her sister while she was in Myrtle Beach contradict that proposition. She knew her sister wasn't in Myrtle Beach alone in May of 2017. And Anna admitted to you that her sister lied to her over and over and over again, just like Miss Obad did. In fact, she was lying for over a year while she and Anna were having their late afternoon, early evening talks over the phone while drinking their glasses of wine. Day after day, this defendant was deceiving her sister. Some of these witnesses were brought in to serve a particular role, and that was to tell you how great the defendant's marriage was with Fabio and how devastated she was by Fabio's murder. And remember when Anna testified how she had to take the defendant home early from Fabio's funeral service because she could barely function because she was so mentally drained? You knew something bad was coming then, right? And that story totally failed because she was then confronted with pictures we didn't show you, we described, but we didn't show you them, of her sister in their parents' home during the funeral services that took place throughout the first week of February of 2017. Pictures of the defendant that she took of herself, where she posed naked.
My God, we're going to hear that again?
Masturbating.
La, 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 la,
I think that's
la,
the first time I've said that word in court in 30 years. While wearing her wedding ring. And a picture is worth 1,000 words, but I don't think we need 1,000 words of a picture in this case. I think you got the picture. And maybe Anna really doesn't even know her sister. Either that, or she's not particularly perceptive, or she was untruthful with you. You can choose. Or maybe the defendant is just that good at deceiving and conning people so that they see what it is she wants them to see. And you heard about that over and over and over again. Because as you heard, and as I told you in opening statement, this defendant deceived so many people. And damn right they were angry because they felt betrayed. after everything they had done. And yet they were attacked for that. It's called human nature. So many good people gave her the benefit of the doubt, would have given her the shirt off their backs because of their love for Fabio. And
Thank you
despite
so much, June.
all of the defendant's lies and deception, Anna, just like the girls, is going to support her sister. And we understand that. I mentioned that that was what I expected was going to happen in opening statement. No matter how guilty she is, that's their family. It's totally understandable. It's also Anna's best friend, as you heard. And as you heard from Miss Obad, they were thick as thieves. However, the court is also going to instruct you on the law. And the law gives you many different factors that you can take into account in considering the credibility of each and every witness that gets on the stand, whether we're talking about a law enforcement officer, whether we're talking about a family member, or whether we're talking about somebody who's a convicted felon like Robert Baker. Bias, interest, motive to lie. I'm going to say those things a lot over the course of today. Those are all things that you can take into consideration
Yes.
in determining
Oh my God.
the credibility of witnesses, and I have no doubt that you'll follow the law. Another thing that struck me during Anna's testimony was the lengths to which she was willing to try and help her sister. And I understood all of it, but this one part, and that was her attempt. That was apropos of nothing, to disparage a murdered victim in this case by getting up on the stand and telling stories about how they were kicked out of bars and clubs. Remember that? Because of Fabio's jealousy? Remember that testimony? Tell me, please, how that helped you to make any decisions in this case as to whether or not the defendant is guilty of murder, conspiracy to commit murder, or the special circumstance allegations of lying in wait and murder for financial gain. That was a step too far. But now, when I started to think about all of this over the course of the last couple of weeks, knowing we were coming to an end, in hindsight, I could put some relevance to it in my own head. That Fabio, as we heard from Luigi from the very beginning of this case, he knew his wife was a cheater. She had done that before. He knew that she was disloyal. So he likely had very good reason to be concerned about her fidelity. That was my takeaway from that. Maybe you have something else. But that's what Luigi experienced growing up. Because what we heard in this case was over the course of a year, this defendant was constantly lying, going behind her husband and family's back. And all of that supports his lack of trust in her. You were told the defendant and Fabio had a great marriage, that they were so happy together, that they were best friends, that the defendant loved her husband, and that even though she had been sleeping with Baker for a year, she had no reason, remember that in opening? No reason to want her marriage to end. Turns out all of that was completely false, proven by the evidence. It certainly might have been true on Fabio's side, but it certainly was not on the defendant's. No one who lies on a daily basis to their best friend, to their partner, to the person they have pledged to grow a family with and grow old together, has a great marriage. I don't care what anybody says. Those things are mutually exclusive. And then there was all of the evidence. Because as you heard, and at the beginning, you might have been wondering where we were going with this. You heard from Matt Nurse. And so now, like I said, I'm going to put pieces of evidence, little pieces of evidence into context for you. You heard from Matt Nurse, as well as from Baker, that the defendant told them she was unhappy in her marriage. So what they told you was false. And Austin knew from Baker. What was his phrase? She wanted him gone. They also told you the defendant didn't go looking for Baker. He went looking for her. And again, we know from the testimony early on in this case from Matt Nurse that the defendant went looking for sex outside of her marriage. She tried with Matt Nurse, her personal trainer that she hired. She downloaded pictures of him shirtless. Remember that? She made him food. She flirted with him. She asked him out for drinks. He testified at the grand jury that the defendant had propositioned him for sex, but he turned her down. And then we also had the Facebook message from Baker to Ron Ray. Remember that from November of 2016, where he was telling Ron how he and the defendant, his girlfriend, had been together for about a year and how the defendant came on to him. And remember his testimony, he said within 2 weeks of the defendant coming on to him, they were already sleeping together, which is corroborated by the sheer volume of communications between them starting at the beginning of 2016. So again, additional points that were made that were 100% false. And they told you that the DA, that we turned her affair into a motive for murder. Well, based on the evidence y'all sat through for the last 2 months, it appears that the defendant created an enormous amount of evidence that shows that she did all of that on her own. And yet you were told that the defendant was happy balancing her love affair with Robert Baker and her wonderful life at home and her marriage. Again, no one with any common sense is going to believe that. And they also showed you pictures. They showed you pictures of the defendant and Fabio together as if somehow those photos or those videos were proof of anything other than what I saw, which was a complete betrayal. Given one was dated, I believe, October of 2017. No, I think one was dated January of 2017. The same day she sent herself a picture of Matt 2 weeks before Fabio was slaughtered in the backyard. And another was dated of October of 2016, less than 3 months before Fabio's death. And all the while, the defendant is running around, lying, cheating, and plotting. And they presented, as I said, 2 videos of them singing and dancing together from both October of 2016 and December of 2016, where you saw the defendant lured Fabio into this false sense of security, that everything was just fine. But what their daughter saw and what Fabio wanted to see, none of that was actually real when you start stripping back the layers, because we heard that the defendant told numerous people how she was unhappy in her marriage and that she was planning on getting out of it. And we saw numerous pictures of her having the time of her life with her lover, both before and after the murder of her husband, where he was stabbed through the heart. And make no mistake, that was intentional as well. When you think about the crime of murder, there is a lot of ways that one could kill another. And we hear often or see often in television shows or movies where somebody shoots another individual. And that's a crime that's committed at some distance. It makes noise, which is why it would be an effective alternative in this case. But when you think about the idea of stabbing somebody to death, that's a crime that's very personal. It's very up close and personal. And there's a reason for that in this case, because it was so personal. And that was one of the things that looked wrong, that looked off at the crime scene. And you remember the testimony, we'll talk about this, of Detective Verna, where when he got to the crime scene, there were a lot of things that didn't add up and they weren't quite sure what they were looking at. Because of course, as you saw, Fabio was stabbed to death. He's cut in the neck so that his carotid artery and carotid veins were severed. You heard that
you guys,
his artery in his leg, his femoral.
do you guys want me just to zoom? Do you want me to zoom? I'm zooming.
Or maybe a couple less, that they ever were interviewed, and that Baker was so nice to her and to them. That's when they started having a problem with Baker, after their mother was arrested together with Robert Baker, and they learned for the first time that their mother had been lying to them for a year. The other story I believe that they brought up, again, which proved nothing, was that at some point, Isabella went to, I think it was a Denny's, and she was seated next to a table where Baker was already seated, which means Baker was there before her. So again, all of that was revisionist history. This is one of the videos that was shown to you. But this is how Fabio ended his life at this house that he loved so much. Remember, Sam Pulera talked about they loved this house, and one of the reasons loved it was Queen Victoria, which reminded them of their country that they were from Canada. And here you see in the photograph on the left, the Rolex on his left wrist. So again, when I tell you that what she did to Fabio was the ultimate betrayal, I am not overstating that. The fact that she was pretending to be this loving wife and mother every day, day in and day out, when she lived with this man for almost 20 years, while plotting his murder with her lover, that's the reason we're all here. Had she just divorced Fabio, none of us would be here. That would be none of our business. But the conspiracy to kill him, that makes her entire obsessive, lurid affair highly relevant evidence in this case. And that's why you were provided with that evidence, because it does provide motive. It provides motive for what happened in this case to Fabio Sementilli. And that is one critical piece of evidence, no matter how you want to downplay it.
I just went back and froze it on that picture. Oh my God, y'all. Y'all don't want to see it.
Or cover it up,
see
or
it.
try to conceal it. The fact that she lured him into thinking that their marriage was solid and then had him murdered in his favorite place shows how evil this crime was. That was the truth that the evidence showed in this case. And so, as I mentioned, there are layers and layers of evidence that we've provided to you that this defendant, as I said in my opening statement, was living a double life that she grew tired of, that she wanted more. She wanted to be able to live her life with the person, as you heard from her own mouth say, with the person she believed was her soulmate. She.
I'm just going to take a break.
Sure.
Let me interrupt counsel. We'll take a morning recess for 15 minutes. The admission applies. See you back in 15 minutes.
Okay, guys. I will show it, but you guys have to have self-care. Okay, let me get it up again. Give me a second. Give me a second. I got to time it. Trigger warning. That is the image. Okay, I'm going to take it down now. They still on their break. That was bad. That is horrible. And the fact that she cleaned up the cushion and everything on that chair and then kept it there for everyone to see. She put a little shrine on it. That was just sick. You're right, Barbara. It is shameful. It's horrible. It's shameful. His face, all right. His head is here. His left arm, his right arm is on the chair. His head is kind of stuck between the cushion and the arm, and he's just kind of precariously dangling there. Face down. That's just... That's horrible. We'll share some of this. Won't we share this while we wait? This is this morning before the jury selection.
Hear ye. All persons have any business before the Honorable Beverly Canones, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, if you're attended, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
I'm sorry, could you stand and raise your right hand one more time? I need you to stand and raise your right hand, jurors. I'm sorry. My fault. Do you solemnly swear to make true answers to such questions as you put forward to you by the court, so help you God? Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Please.
Your Honor, this is docket number 2282CR117, the Colorado versus Karen Reed. Can I have counsel identify themselves for the record?
May I introduce myself, Your Honor?
Please.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts, along with two of my colleagues.
Good morning, my name is Laura McLaughlin. I'm the Assistant District Attorney for the Norfolk District Attorney's Office, representing communities within Norfolk.
Good morning, my name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. Thank you very much for your time.
All right. Thank you, counsel. And then counsel for the defense, and please introduce your client as well.
Good morning. Let's try that again.
Good morning. My name is Alan Jackson. I have the privilege and honor to represent my client standing to my right, Ms. Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning. My name is Robert Alessi. I likewise have the privilege of representing Ms. Reed, and I thank you for coming today.
Good morning. My name is David Yannetti. I'm an attorney. I have offices in Boston and here in Dedham. And it is truly my pleasure to represent Karen Reed.
Good morning. My name is Victoria George, and I have the privilege of representing Ms. Reed, and thank you for being here.
Good morning, I'm Karen Reed. Thank you for being here.
Okay, thank you very much.
Ms. Reed, can you please remain standing for just a moment? Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
All right. Good morning, jurors. My name is Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day is going to shape up. So I just want to say before we start that jury service is certainly one of the most important civic duties we have. And as a civic duty, it does cause us to be inconvenienced. So we do appreciate that you're here, ready, willing, and able to serve if called upon to do so. And our system of justice simply won't work without you. So we do
Willing. Yeah, you're required.
Appreciate you being here, and we appreciate your patience. So today we're selecting a jury in the criminal case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. On the morning of January 29th, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton. The questions rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaires, we'll have you come up to the sidebar one at a time so that we can follow up on your answers to the questionnaire and to questions I will have of you. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps picked on a case, different case from another court. In a few minutes, I'll pose a number of questions to you as a group, and you've just taken an oath that requires you to truthfully answer these questions and all questions put to you. If your answer is yes to any question, I will ask you to raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer may read the numbers from the card. You don't have to get the numbers out now because it will still be a few minutes and I'll let you know. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from serving on this jury. We hear ambulances and fire engines going by every day, many times during the day. And if you're selected as a juror in this trial, we'll be seated in the courtroom across the hallway where we'll hear it even more. So generally, the lawyers stop and I stop talking when we hear it. So if you find a question that I pose to the group is overly intrusive, you can elect to answer that question at sidebar. And I'll probably have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer. All we're looking for is your best, honest answer to the questions. Now, I have a witness list that I'm going to read to you, and it is very lengthy. It doesn't mean that all of these department, Uza from Dighton, Matthew Amber from Norfolk, from whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until the jury make your determination after you listen and consider all of the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. Now that brings me to reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, but it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Now, of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in the case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal principles. So go ahead and take those cards out because I'm going to start asking you those questions. But before we begin, I understand that sometimes jurors do not fill out the juror questionnaires completely. Sometimes we're in a rush to get those forms back in, or sometimes we think that maybe our experience doesn't apply to the question that's asked. So when you come up to sidebar, if we see that something's missing, sometimes people forget to put in a work experience. Many times people forget to put in their age, and we do ask about that. We need that for purposes of this impanelment. But
Okay. Do you want to keep watching this, or do you want to go to Monica Sementilli? She just started again. Monica or Karen Reed? Let me know.
sometimes people forget to put in whether they were a witness in a case that was in court, a defendant, another litigant. So if there's anything that's missing, we'll ask you. But if you know that you didn't put something on there, please let us know at sidebar. All right, so if your answer is yes to any question that I ask, please raise your hand until the court officer reads your number. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names you heard?
Juror number 343, 360, 347, 339, this clerk will be scratched, 360.
Thank you.
Juror number 348, juror number 344, juror number 333, juror number 310, juror number 355, juror number 332, juror number 323, and juror number 312.
Okay. Thank you. Do any of you folks or close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office?
Juror number 326, juror number 328.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Please raise your hand if you have seen, heard, or talked about this case.
Juror number 319, juror number 317, 352, 353, 311, 343.
I agree with you. Okay, let me go in here. I'm good with it. I just wanted those who weren't interested in Karen Reed to have a moment.
They were willing
All right,
to
we're back into the Monica
investigate as
Sementilli.
long as it took to make sure that everyone involved in this murder conspiracy is brought to justice. And they may never be done. And you heard questions about that. And the judge is going to instruct you about if anybody has any issues or questions with respect to any other parties who perhaps have not yet been brought to justice, how you are to treat that evidence in this case, and that is not necessarily evidence of anything. But in this case, despite the argument that all of these homicide detectives from LAPD just went out and arrested the defendant because she was having an affair, what you also heard one after another testify to was the mountain of evidence that they produced throughout the course of their investigation. You heard Detective Roberts, I think she reiterated again yesterday on the stand, over 220,000 pages of paper reports, over 8 terabytes. I don't know how many of you are computer people. 8 terabytes of data. Some computers don't even hold 8 terabytes. But the defense wants you to believe that somehow law enforcement just decided to arrest and prosecute the defendant because of an affair. If that is the defense in this case, then I sat through a very, very different trial. And in this case, you also heard the attacks on the opposite side. Well, why does it take you so long? Why don't you just run up to Alaska and arrest Christopher Austin? If you had information that he was in town, even though you don't have any evidence connecting him to the murder, you have evidence that he's connected to Baker, and there's flight records showing he came into town and then he left. Why don't you go up and arrest him and then ask him some questions? Well, that's not how it works, as you heard. Detectives are going, good ones, are going to take their time. As you heard from Detective Verna, they're going to build their case. You heard about Deborah Obad yesterday saying, well, I called Parshall like 50 times. And I said, go investigate this person and go look at that person and run this plate. And that's not how it works. There has to be evidence. And they build their case. And they're not going to tell the defendant or Miss Obad or anybody else in the public. They didn't even tell, as you heard, we brought in Jim Duggan. He was the security officer, the chief security officer for Cody out of New York. And when Fabio was murdered, he was brought in to make sure that it didn't have anything to do with the corporation. And one of the things he did is he reached out to Detectives Verna and Parshall. And what did he tell you? He said, well, like any other good detective, they were very tight-lipped. They weren't going to tell me anything. They'll listen to you. They'll take your information, but they're not going to tell you what leads they're working. They're not going to tell you what angles they're looking at. They're not going to tell you what search warrants they're serving. They're not going to tell you who they're interviewing. That's not what a homicide detective or any good detective is going to do. They're going to bide their time. They're going to build their case. They're going to make sure that before they accuse somebody, that they have the goods to back it up. And so you heard about that through 4 sets of investigating officers who all told you the same thing. Now, one of the other things that you heard in this case is that the defendant is somebody who uses other people. She uses other people to do her bidding, to do her dirty work for her. That includes her daughters. You heard in this case that she had Jessica lie to her father by promising not to tell him when Jessica found Baker sleeping in her mother's bed when Fabio was away on a business trip. And you heard that on February 21st, when Detective Parshall and Detective Verna interviewed the defendant at her home, that they also separately interviewed Jessica. And Jessica was the first one who brought that up to law enforcement. And yet, when they talked to the defendant, remember, tried to downplay her relationship with Robert Baker. Also, after the murder, remember, the defendant used Jessica to lie to family and friends who were calling to check in on Monica and the girls, to check on their welfare, because they were worried about them after the murder. And so what does the defendant tell Jessica? Tell them I'm asleep. Tell them you're just hanging out. When in reality, we know the defendant's out at bars and comedy clubs and partying with Baker. You heard from Melanie Garibay. Melanie Garibay, as you recall, worked for Wella. She was one of their show directors for these large corporate events that they would put on in places like Los Angeles or Vegas or other places around the country, and that the defendant lied to her and told her that Fabio knew that she was planning a trip to Las Vegas in March. And so Fabio had told her to get in contact with Mel, and Mel would get her a deal on a suite. Remember that? And clearly we know that the defendant and Robert Baker were planning these trips even before Fabio's death, because you heard and saw Baker's Facebook message to Ron Ray, where he said he and the defendant, this is in, again, November of 2016, are coming to Las Vegas soon, so he can introduce her to them and they can all hang out together. You also heard from Sal Macheri, who was the CEO at Wella, and then Cody. You heard from Dave Diaz, also was Fabio's boss previously through Wella, and Henry Meyer, the HR director for Wella for North America. And you heard how the defendant used their relationship with Fabio, with her husband, and played on their grief, their sorrow, because they were close with Fabio, to get them to do things for her, including things that they put into place, as Henry and Sal Macheri talked about, things that the company had never done before that they believed were exceptional, like paying somebody's widow 6 months' salary, extending health care for the entire family and benefits for the family for 6 months, writing off a $9,000 company car loan on the car that, the truck that Fabio had. And you heard about all of the things that were done in the aftermath of Fabio's murder to try and ease some of the burden on the defendant. You also heard from Sheila Salahian. Remember, Sheila is married to Ricardo, and they traveled together. They went on dates, double dated together. In 2016, she and her husband were friendly with the defendant and Baker through the racquetball league. And we heard that the defendant used her as a cover, so that when Jessica found Baker sleeping in her mother's bed when Fabio was away, the defendant lied to Jessica and said, well, Sheila and Rob were both over the night before, and they both had too much to drink, and so they couldn't drive home. But we know from Sheila's testimony, she never spent the night at the house. In fact, she told you that the only time she had ever been to the house was, I believe it was the Wednesday or Thursday after the murder, where she saw Baker for the first time at LA Fitness, and he told Sheila and Ricardo about Monica's husband being murdered, and asked if they would go over to the house with him and Matt to pay a condolence call. And that was the only time Sheila had ever been there. In fact, the defendant tells law enforcement the same, that Sheila's never only been to the house once, and that was after the murder. But she uses her as a cover. She also uses Sheila as a cover when she tells her daughters, or when she tells Anna, that she's going out to, as I said, karaoke is the big cover story, after the murder on night when they're invited over to Fabio's best friend's house, Ernie Valorano, and Anna's in town, and she won't let her sister come with, but she's going to go do karaoke with Sheila. Sheila told you she never went out, never did karaoke with the defendant. The only time she ever got together with the defendant is when they got together as couples, and always with her husband, Ricardo. And then you also heard how she used Ernie Valorano and Sam Pulera, Fabio's friends and colleagues, in order to get sympathy and support, and played on their emotions, as you heard about. They also provided other little pieces of evidence that we're going to talk about. So as I said, the defendant wasn't going to do the dirty work herself, right? She's not going to kill Fabio. But she knew that Baker would, because Baker is a stone cold killer. And he's willing to do it. And she knows that he's going to find somebody to assist him who's loyal to him in order to kill Fabio. They needed somebody who was gullible. They needed somebody who wasn't particularly bright, would go along with the program, would not ask a lot of questions, somebody who would do whatever Baker asked him to do. We can call him, if you will, the patsy in this case. And Christopher Austin was the perfect choice, because once he was convinced to directly participate in the killing, Baker and the defendant believed he'd never talk, that he'd never squeal, he'd never say anything about what happened, because he would have skin in the game. It would take him down as well. What they didn't count on, what they didn't account for, which was between the time of the murder in January of 2017 and subsequent to that time, that he would meet somebody, that he'd fall in love, that he'd get married, that he'd have a baby, and that he would have a family who became more important to him than Baker. And so at that point,
that's how much data, 8 terabytes of data is what they have on this case. That's insane.
he was somebody who was willing to give law enforcement the details of what he knew, to come clean, because he knew they had the goods on him. On top of that, Christopher Austin, whether you believe him or not, has a conscience, and he feels bad. Does that matter after the fact? I don't know. But while the defendant and Robert Baker got what they wanted, which was Fabio dead and plenty of money to start a new life, possibly in another state or country, they were very arrogant and they made mistakes. And they went, as you heard, to great lengths. And perhaps you were wondering during the days in and out of the testimony of various witnesses, including Detective Mitzi Roberts, about all these little small pieces of evidence as I was putting in various pieces of paper and talking about things that we're now going to connect up. And you heard me do some of that through the testimony of Robert Baker. But they went to great lengths to cover their tracks. And they went to great lengths to destroy evidence, such as deleting encrypted applications, as you heard, from their cell phone and all of its accompanying data, or their messages immediately after the murder, or the messages that went back and forth between the defendant and her husband on January 22nd,
Yes,
which
amen.
she had
A lot of
no part in what was supposed to happen on the 22nd. She would have had no reason to delete those messages. And then, of course, on top of that, you also heard the defendant make various admissions, and the judge is going to instruct you on the difference between what is a confession and what is an admission under the law. Confession being where somebody admits to all of the elements of a crime, and admission a statement that perhaps infers guilt or admits to certain portions of a crime or something of that nature, and you're going to receive those instructions probably, as I said, tomorrow. But what we also saw, and as I mentioned at the beginning today, was that Baker and the defendant were like a two-person wrecking crew. Or as Baker said, and you heard this yourself, when they were in the court lockup, he referred to them as Bonnie and Clyde. Now, some of you might be a little young, but I'm sure the rest will fill you in. Bonnie and Clyde were famous for robbing people, killing people. There were a couple and they were on the run. And so you hear Baker making comments about how he and the defendant are Bonnie and Clyde because they were destroying everything and everyone in their path. And you heard them in the back, once again, scheming on how they're going to explain away the evidence against themselves and how they have to stick together, because if one rolls on the other, meaning one talks or testifies against the other, they both go down. And you heard them talk about sticking to the program, sticking to protocol. Even yesterday, you heard that there were, from Detective Roberts, that there was approximately 60 hours of recorded conversations between the defendant and Robert Baker during the time that their case was winding its way very slowly through the criminal justice system. And that the case started out in Van Nuys, and that there were two dates, one of which was June 29th of 2017, and the next one, I believe, was August 7th of 2017. And after that, the case was transferred downtown because they knew it was going to be this lengthy case. And so you heard them talking in the lockup back in June, subsequent to their arrest, where they discussed on June 29th that Baker saying stick to the program. And you heard yesterday, and maybe you weren't thrilled that you were going to be hearing even more recordings, but it was brief. But what I want to point out to you is that, again, we're talking about 60 hours altogether between the 6 dates where recordings were done in the lockup in conjunction with the sheriff's department. And out of 60 hours, in order to give you what the defense thought was beneficial, you heard what you heard yesterday. And even in that portion, you heard them talking about concocting a defense. You heard Baker talking to the defendant about sticking to the program. As Detective Gable, who previously was in the military himself and testified about that, when you hear protocol, that is a plan that's been discussed, where you put it into practice and it becomes the policy. It becomes the protocol. And that's the language, the type of language and the scheming that you heard from these defendants. One of the other things I wanted to point out to you, when the defense says to you at some point in their arguments that, well, you don't have the content of their messages between Baker and the defendant where they are communicating about a murder. You don't have recordings of their pillow talk where they're communicating about setting up Fabio to be killed. Remember something. You can prove a case, you can prove facts by various sorts of evidence. And the judge is also going to instruct you on different types of evidence. There's direct evidence, which is perhaps what you heard in this case, let's say from Christopher Austin or from Robert Baker, people who were present and can tell you what happened, what was discussed, eyewitnesses. That's direct evidence. There's also circumstantial evidence, and most cases are proved by things like circumstantial evidence. It's evidence from which you can infer a fact or a circumstance. For instance, let's say in this case, the gal who was on the witness stand yesterday afternoon as a defense DNA expert, let's say that she had tested the interior of those tennis shoes for what I asked her about, wearer's DNA. And let's say the evidence that was developed, the evidence profile that was developed from that swab of the interior of the shoe, the wearer's DNA, came back, let's say, to Jessica. That would be circumstantial evidence. Sometimes people believe, well, if you have blood evidence, it's DNA, that's direct evidence, right? No, it's circumstantial evidence. It gives you information from which you can draw another fact or a set of facts. And so you're going to be instructed on various types of evidence in this case, and you're going to hear that direct evidence and circumstantial evidence are equally valid means of proof under the law. And there are certain circumstances that you have to take into account when you're dealing with circumstantial evidence, which I'm also going to talk about today. However, what I am going to tell you that I want to point out to you, we don't give killers a free pass because they're successful at destroying and getting rid of the evidence against them. You got to look at what evidence you have. But again, the law contemplates various things. And one of the things that the law contemplates is that criminals would do just that. And you heard from various witnesses like Cyree, I know Detective Roberts talked about it. You heard about things like, you probably learned about a lot of things. So now when you start watching those shows at home, you're going to be correcting them. But you learned about burner phones, right? Some of you might have known what a burner phone was. Some of you might not. You learned about encrypted applications. Some of you might have known about that. Some of you might not. But again, the law covers the situation where you have criminals who destroy, conceal, and suppress the evidence against themselves. And you're told under the law, and I'll cover this too, that those are facts and circumstances that you can take into account. And it's called evidence of consciousness of guilt. When you have an individual who, let's say, is in the lockup pending trial in a murder case for acting together, and they are writing jail kites, letters to one another. And then you hear one of them, the defendant in this case, saying, now you got to flush it. And then remember that day when we were listening to the recordings and it was so loud because not only could you hear all the other individuals in the cell area in the lockup, but them talking over the other individuals. And what did you hear? You heard the sound of the toilet flushing repeatedly. And they would talk about, now you got to flush that. Oh, let me read this part. Okay, then flush it. When you have two individuals who are actively in concert trying to destroy the evidence that they are talking about and whispering about, all of that is conscience of guilt evidence. All of that is circumstantial evidence that you can take into account that obviously points to guilt, as does motive. You're going to hear that motive evidence is not required, that there are cases, criminal cases, where it's very hard to decide why somebody committed a particular crime. And you therefore, as I said, the law contemplates these types of circumstances. And so what the law says is that if you don't have evidence of motive, it might point to the fact that the person isn't guilty. However, but it might not mean anything as well. So it kind of gives you both options. But it also tells you that if you have evidence of motive, that is something that you should take into account, because it also may point to guilt when you have evidence of motive. And in this case, when they get up, because I don't necessarily get to get back up and respond, nor are we going to do that. We're not going to get up and do this tit for tat, okay? So I'm going to spend my time now, and I'm going to tell you what I think is important, okay? And then when they get up, hold them to it. Because Ms. Stadel and I, we're not afraid of the burden of proof. In fact, we told you that during jury selection, which I know seems like eons ago. Hold us to the burden of proof. We don't shy away from it. The burden of proof in this case, the judge is going to instruct you on, is reasonable doubt. That means, again, what have I mentioned several times already today? Common sense. You know, if you look around amongst yourselves, and you've been together now for quite a while, and I'm sure you've all managed to get to know each other a little bit. You are a very diverse group. We have people from different racial backgrounds. We have people that do different things. We have people that live in different areas. We have people of different age groups. And so you all come to this room with experiences, some of them difficult, and you've survived them. Some of them you're still looking forward to, what's going to happen next. Some of you have children. Some of you can relate, some of you can't relate, but you come into this room with your life experiences. Don't check them at the door. When you go back there, bring your life experience with you. Because again, when you look at the evidence, you're going to look at it through your own lens, through your own life experience, through common sense. You all are sitting on this jury because of that. You have it, take it with you when you look at the evidence. And that's what I'm going to talk about again and again today, about how the evidence in this case is based on common sense. Because what the law tells you is
Let me explain that, because a lot of people are going to go, what? Okay. Monica Sementilli was using another inmate's ID number, to pass letters to, or mail letters to Baker. Took a while, but they finally got caught. They are housed in a jail. They have the male side, the female side. Okay. They are housed separately. She was also using somebody else's phone IDs to contact Baker, and he was doing the same. The other thing they were doing is when they were taken to the jail, from the jail to the courthouse has individual cells, probably 6 by 6 or maybe 4 by 6, really small, that they hold them in until it's time to go see the judge. She was across from Baker, and it was a solid door. But there was a lip about yay big that they could lay down and see each other, and they self-pleasured in the courthouse holding cell. Both of them self-pleasured and did all that crazy stuff. Got raunchy in the courthouse holding. Yeah, that was not a fun day of testimony.
that when you're looking
Hi, Jane.
at circumstantial evidence, again, evidence that's
Welcome, Jane. Thank you for being
subject
here.
to two different interpretations. One, let's say, that's reasonable, and the other, that is not.
I
Not
think I
reasonable,
educated
Not
Jane. I did a huge education on Tanika, and I did a live together. She's another content creator. And Jane, I went in great detail about toilet talk. Called Toilet Talk. Yeah, that was disgusting.
based on common sense, not based on evidence, but based on speculation or some possible or imaginary doubt. The law says, directs, that you must reject the interpretation of the evidence that's unreasonable and go with the interpretation of the evidence that is reasonable. Again, the law takes into account that you might have circumstances where you could come up with all sorts of excuses for evidence, for behavior. But you are required to base your decision on reason, on common sense. Now, I want to talk about Christopher Austin a little bit. I did tell you that I am not going to spend a ton of time talking about Christopher Austin because you not only got to hear him on direct, you heard about how he was eventually, when the detectives were good and ready and had built their case, taken into custody and what went from there. And then you heard him be recalled in the defense case, and you sat and listened for a day and a half to his proffer session with me, with Ms. Stagel, with the detectives. And where we asked him various questions, he gave us answers, he clarified some answers, he corrected us, he came back the second day and did the same. One thing I want to say about Christopher Austin that happened from minute one. Remember, this is a guy, like I said, his life changed dramatically between the time when he comes down as Baker's patsy to commit this crime with Baker. Whether he was paid or not, he was going to do whatever Baker wanted, right? And the time that he's eventually apprehended and taken into custody, where he's now living in Vancouver, Washington. He now has a family. So he has other things that are now critical and important to him. But the first thing that happens after 8 years almost, when he's taken into custody on his way to work, he's, I think, a juvenile probation or parole officer up in the state of Oregon at the time.
That's right,
And
Jane.
when he's taken into custody that day, he admits immediately. He does the opposite of the shuck and jive dance that you saw from Baker. He admits to personally stabbing Fabio Sementilli. He admitted it. You can't change that. He admitted it. It was recorded. He said it over and over. And at that point, he sealed his own fate. And you heard about that seatbelt ticket. Once he was ticketed in the rental car that Baker used, that was the nail in his coffin. But it wasn't that easy, apparently. Didn't come up under numerous inquiries. Finally, it comes up in the database when the detectives are looking in a particular database. And once they have that ticket, now they believe, with everything else they've managed to put together, that they have enough to go up and arrest Christopher Austin for this murder. And you heard that they got warrants to do that. And so what happens is Christopher Austin is arrested on his way to work. He has no idea this is coming, but he admits to it. He knows, he tells you, as soon as he got pulled over, he had a feeling that this is what it was about. It was going to come back and bite him. And sure enough, he tells the detectives that day, and he tells Miss Stagel that day, I stabbed Fabio. And so when the defense argues to you, as they did from the beginning, that Christopher Austin is a liar, but Mr. Baker is telling the truth, keep in mind how the facts, the reality of this actually went down. Because in this case, like I said, you learned about a lot of different types of police investigative techniques. One of the things that you generally don't hear about on television is a Perkins operation and what that means. And you've heard that detectives use this very powerful tool to solve some difficult homicide cases. They're limited in the type of cases they're able to use it in. But again, even before Austin meets with a lawyer up in Vancouver, Washington, he admits to stabbing Fabio. And he admits that he was brought into this by Robert Baker. And he explained that he knew Baker's girlfriend was involved, even though, as he said, he didn't know her. They weren't friends, as he said. They didn't hang out together. He didn't know much about her. He only knew what he knew from Baker. But he lays out from the beginning that he was brought into this conspiracy to kill Fabio by Baker and Baker's girlfriend. And then you heard that during the Perkins operation in Vancouver, Washington, he tells his cellmate, he doesn't know the cellmate is an undercover police officer. That's the whole point of a Perkins operation, that the motive behind the murder, remember this, was insurance money. Baker's denied that to today. But yet, what did you hear? You heard that Baker not only admitted in this court his guilt to count 1 being the crime of murder of Fabio, count 2 being the conspiracy to kill Fabio, but he also admitted lying in wait, and he also admitted murder for financial gain. He admitted to a special circumstance, which means he is going to serve a sentence specific to that special circumstance allegation of life without parole. But he wants you to believe he only did this crime because he wanted to be with Monica. So why did he admit to a special circumstance allegation of murder for financial gain? Christopher Austin tells you from the beginning, cellmate asks him, what was this all for? What was the point of this? Insurance money. How does Christopher Austin know about that? The only evidence in this case is that he learned about it from Baker. How does Baker know that Fabio Sementilli has life insurance? From the defendant, of course. Again, this is just common sense. Now, also keep in mind, as I said, that Austin was the only one, the first and the only one to mention the life insurance proceeds. So this is way before, as you also heard, he ever speaks to a lawyer, because he's never been in trouble before. He doesn't know how the process works. And once he speaks to a lawyer then explains to him how offering up a proffer session with the district attorney's office and the investigating officers would be in his best interest. Because he's now admitted to being a direct perpetrator, which I'm going to talk about. He doesn't do any blame shifting like you heard from Baker, who made up excuse after excuse after excuse and changed his story every single time he had the opportunity to do so over the course of, I think it was 13, because the last interview was during trial in March last month. Austin gives up this information before there's anything on the table. And he asks them, I want to go home to my wife and kids. Miss Heather, will you let me go home? And what do they all say to him? You're not going anywhere, buddy. The only place you're going to Los Angeles. You're being extradited to LA to face charges. Because what did I say earlier this morning? 4 sets of detectives from LAPD told you that they're not going to be done until they arrest and prosecute everyone who was involved in this murder conspiracy. And you also heard Austin explain why he wasn't completely forthcoming immediately after his first arrest in his life, either to his cellmate, who he didn't know, who was a stranger to him, or to the LAPD, or to Miss Stagel. He has no idea what's coming. And of course, that's understandable because we're not talking about Baker, who's been in the system, right? We're talking about Christopher Austin, who's never been in trouble, who's been told over and over and over again through his father and through Baker over the years that Baker's going to take care of him. Baker's going to watch out for him. He believes that. So he hasn't spoken to a soul. Even his wife knows nothing about this until this all came out. He has never spoken to a soul about what he did to Fabio Sementilli until he was arrested on his way to work almost 8 years ago. But again, what he doesn't do, he doesn't minimize his role. He doesn't do any blame shifting. He tells you, this is my fault. I did this. They brought me in, but I did it all on my own. Nobody forced me. Nobody threatened me. Nobody coerced me. I came to LA to do this hit. And he had every opportunity to minimize, because remember, had he said what Baker wants you to believe, because it means that he's not as knowledgeable as what he told you, if he was only what Baker said, which would be a lookout, he might have been looking at an entirely different sentence. He might have been looking at an entirely different charge. But that's not what he does. And that's why his statements are so credible, because he doesn't minimize.
Thank you. Thank you for joining
And on
us.
top of that, the other thing that you heard about and that you have as evidence, there's 3 different documents, sets of documents in this case. You guys probably know, just like any business that you might work for, there's a chain of command. Whether you're talking about if you work in a corporation, if you work for a company, there's always a chain of command. There are certain protocols in place. Unless you work for an unaccredited lab, then you can do whatever you want. But there are rules in place. There are rules in place for a reason. So that the rules are followed, so that things are administered fairly between individuals, so that the same standards are in place, so that you know that we're not cutting corners, that we're not just trying to get someone to say something, because that wouldn't be justice. That doesn't do anything for Fabio and his family. We want the truth. Not the truth until we throw you up on the stand and then you can say whatever you want and just parrot back. Oh yeah, we told you to tell the truth. We told you to tell the truth. We told you to tell the truth. You didn't 12, 13 times, but we're still going to put you on the stand. And maybe, just maybe, because you've been sitting here listening to the evidence day after day after day, so conscientiously, maybe you also figured out without me saying it why we didn't call Deborah Obad to the stand. We'll talk about her. But he doesn't minimize. And there's 3 sets of documents that prevent him from doing anything other than telling the truth. The first is his proffer agreement. He had to sign a proffer agreement with his lawyer, Mr. Aval, with me, on the record. We put him under oath. You heard that at the beginning of the proffer session. That goes up a chain. There has to be approval. There's all these different things that you heard about. And the proffer agreement says, hey, we used to refer to it years ago as your queen for the day, which means you give us all of the information. Whatever you say here, we can't use against you unless you get up on the stand at some point in the future and lie, then we can use what you told us today to impeach you. In other words, like what you saw with Miss Obad, where we can show the jury that you're a liar. But if we are able to corroborate, meaning support, prove what you're saying is true by independent evidence, then if we believe you provided valuable, truthful information, then and only then are we going to be like negotiating with your lawyer in a plea deal. But right now, we're giving you nothing. Like, you're basically taking us at our word. You're going to pony up the information. We're going to, through law enforcement, see if we can validate what you've told us is true. And then and only then, we might engage in plea negotiations with you. And so you heard about that. The second document in this case, you heard about his plea transcript. We put it into evidence. In fact, I'm going to give you a perfect example. This is a problem because, just so you know, I tend to go off script in a closing because I think of all these little pieces of evidence that I've had in my head for 8 years, and it just makes it longer. But
Definitely.
I'll skip other things.
I'm
as we
so
go
ready
forward,
for
'cause
her
I'm going
to
to talk
come.
about it anyway. Think about Robert Baker, right? Robert Baker got on the stand and testified at the
Only been
beginning
2 hours.
that he didn't understand when he took his plea in this case. Remember that? Remember that? And so what did that mean?
I object, Your Honor. That's not the
It's overruled.
Yeah, because basically what he was saying is Judge Cohen, who you probably noticed, who's a stickler for rules and procedure, follows, again, a protocol. And he does the same thing every time when he takes a plea. And there's a plea transcript. Because Brooke, or a court reporter who sits in the courtroom, writes down everything, as you've seen, that gets said. And why do we do that? So there's a record. So when you hear somebody like Deborah Obad, who testified that she lied and perjured herself in front of the grand jury,
That's uncalled for.
It's overruled.
specifically testified that she lied to the grand jury, and you hear Baker get up and commit perjury where he says, I didn't understand what the charges were. No one told me. I didn't plead I didn't plead to that special circumstance stuff. What happened? I brought out the transcript. I put it on the projector. I went through it with him. Remember when the Judge Cohen asked your lawyer, is this what you want to do? And then he didn't just talk to your lawyer, Michael Simran. He talked to you. He asked you specifically. He turned to you. He had a conversation with you. Sir, is this what you want to do? Do you understand that you have various constitutional rights that you are going to waive by entering your plea here today? And then he goes over all of the constitutional rights that Baker has to waive. So again, when Baker gets up on the stand and he tells you in an open courtroom that he didn't understand what he was pleading to, and he did it again, if you remember, when we got to his prior sex case, and I had to do it all over again. You'd think he'd be smarter and understand, like I had the plea agreement from the transcript from this case, and clearly I was going to have it from that case, but flat learning curve doesn't get better. So again, I'm asking him, do you remember when the judge turned to you and said, is this what you want to do, sir? These are the charges. How do you plead? Right? It's all laid out for him. He agreed to it in this courtroom on the record. That's a record. Right?
Ouch!
So we have the plea transcript from Mr. Austin, also in front of Judge Cohen in this court, where we did the same thing, and the judge went through the same practice. These are your rights. How do you want to plead? This is the deal. Before they even admit to the plea agreement, and you can look at these because they're all in evidence. We marked them all. It's all transparent. Before he even takes the plea, the judge tells him, this is what the consequence of your plea is. Is that what you want to do? Your attorney has indicated that you want to plead to this, but is that what you personally want to do? Yes, it's what I want to do. Do you understand, Mr. Austin, that your plea agreement is based on your truthful and complete testimony at trial? Yes. Because if not, guess what? No plea agreement. And who makes that decision? The defense wants you to believe it's us.
It's the
But I don't
judge.
run the court. You've heard him yell at me. He runs the court.
Me too, Your Honor, me too.
Anyway,
Got a little hand smack for that. Yeah,
So,
we can't be doing
the
that
judge
in
makes
court.
that decision. He has to sit
The
and
judge-
listen. And he takes
The
notes.
judge is the one that
And
decides
he
whether
reads
Austin.
what's being said.
The judge decides whether Austin gets the plea deal or has to go through trial.
Off his screen as Brooke is typing it. And then at some point later, Mr. Austin comes back before the court for sentencing. Sentencing gets put over, as you heard, until he's testified. And he's on the hook for testifying and cooperating with as many cases as it takes until they're done with everyone in this case. So the judge makes that call. And then there's a third document, and that was an agreement for testimony with our office. Before we put you on the stand, you agree that you're going to tell the truth. It's a contract. If you don't hold up to your end, we're going to ask to be released from our bargain, and we can go to the trial, and we'll pick a jury, and we'll see how it goes for you, right? So there's different documents that are in evidence in this case that you can look at. So again, keep that in mind when they get up to argue. Now, I said I was going to talk about the law. I thought it was going to be sooner, but here we are. So in this case, you heard, or you're going to hear the judge instruct you, as I've said, about the applicable law, which is the framework for which you have to look at the evidence and make a determination on whether the evidence that Ms. Stagel and I have presented, whether we've proven our case, whether we've proven the elements of the crimes and the special circumstance allegations to the standard of law beyond a reasonable doubt. And what the law says that people who are involved in committing a crime are referred to as principals under the law. That's the term, principals. So who are principals? Well, principals include those who directly and actively commit the crime. So if we're thinking about who actively, directly, personally committed the crime, and we talked about how a stabbing is a very up-close personal crime. Who's wielding the knife? Well, in this case, we have Mr. Baker and we have Mr. Austin, right? They're the people who go to the crime scene, go to the house. They're the people who stab Fabio to death on the back porch. They're not leaving until that job's done. Those who aid and abet the commission of a crime are also principals. Now, when I say aid and abet, what does that mean? Aiding is, that's an easy term, plain meaning, but abetting, what does it mean to aid and abet a crime? This is where the defendant comes in. You have to have knowledge of the unlawful purpose of the perpetrator. So in other words, that she knows that Baker and his co-conspirator are going to commit murder, the murder of Fabio. In addition to that, she has to have the intent or the purpose. What's her state of mind? Judge is going to give you instructions on state of mind and what that means for the various crimes and allegations. That she has the intent or purpose of committing, facilitating, encouraging, somehow aiding, assisting the crime. How does she do that? We're going to talk about this when we get to conspiracy. She does that by setting Fabio up, luring him into this false sense of security. And as I'm going to talk about this afternoon, by setting in motion this very, very short window of time, this timeline. Remember that PowerPoint presentation by Mr. Ed Cozen that we played through Detective Roberts' testimony, where we laid out the entire day so you could see how all these things fit in and how short that timeline is? I think 418 joggers are just turning from Oakdale left onto Queen Vic. It's the second house up on the left, and they're out pulling out of the Porsche at the bottom there at the intersection where the neighborhood surveillance cameras are about half an hour later. Very short. Got to get in, got to lay in wait, find out where he is, got to kill him, take him down. He's a big dude. Takes two. We'll talk about that. Got to then set the crime scene up, stage it, as I talked about already today, and then got to get out of there and back, out of the area. Okay? So she has to have the intent or purpose to encourage or assist her intent, her mindset. And then she actually has to assist. And actually, she has to do something. She has to aid them, again, by setting this crime in motion, by telling Jessica, don't be late for babysitting, by looking at the IDMS Light app to make sure that Jessica's gone, that there's no one else there now in front. It's just Fabio alone. And then she aids, she promotes, she encourages, or she instigates the commission of the crime. So this is law the judge is going to give you. Feel free to take notes as I go through the law. I'm going to break it down. I'm going to talk about it in small pieces and try to make it simple for you. So again, when you go back into jury room and you select your foreperson, you will be able to have meaningful conversations right from the bat. Okay? So again, the judge is going to give you this law, and it shows you how you can be a principal, either as Baker and Austin did by actively committing the crime, but also those who assist those direct perpetrators in getting the crime into motion. Okay? Let's talk about murder. Count one. Murder is, as you can see, is fairly simple. It has three elements. A human being is killed and the killing is unlawful. Okay? Human being, it's a done deal. Fabio, right? Killing's unlawful, no brainer. So malice aforethought, again, that mental state element. What does it mean to have malice aforethought? And what the judge is going to tell you is that malice can either be expressed or implied. You have implied malice in this case. If I usually would give an example of, let's say you're in a crowded park, someone shoots a gun into the air, it comes down that bullet as everyone would expect it to, and it kills somebody. Reckless disregard. Okay. This is obviously an implied malice case, but more than that, it's an express malice case. And so I'm going to spend a little bit of time talking to you about express malice. Express malice simply means intent to kill. And you're going to hear from the instructions that Judge Cohen is going to give to you that an intentional killing is sufficient for proof of express malice. We know in this case, Fabio was intentionally murdered. He was not stabbed. He did not suffer 7 sharp force injuries on his back patio accidentally. This was an intentional killing. That's murder. The other portion is aforethought, and that means that your intent to kill has to come before you kill him. That's, again, in this case, fairly straightforward, very commonsensical, based on the facts and circumstances. They knew when they went up to that house that they were going to kill Fabio. They didn't kill him and then decide afterwards, oh,
You got that? Yeah.
they
Hello,
knew
it's Britt.
what they were going for. That was the plan. That was the
That is
conspiracy.
so
And that's
true. Hello, it's Britt. I am struggling. Ronnie, that is an amen. Thank you, everybody, for joining us. We appreciate you. I'm hoping she's winding down because she took 1 2/3 day with the opening statements. Ugh.
going to lead us into the second count.
That's only time for now. In 5 minutes from now, when you find a good place, let me know.
Perfect. I'm done.
I had a feeling that would work. We'll take our lunch recess until 1:30. Again, as always, the admonition applies not to discuss this case among yourselves or with anyone else or form express opinions of the cause is finally submitted to you. Have a good lunch.
Hallelujah. Hallelujah, 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 hallelujah. Praise the Lord. Let's go over to Discord. I am looking for document. Nothing's popped up. Okay. So let me get to what I need to get to. Don't need that. Okay, we watched a little bit of the Karen Reed. We'll watch a little bit of it where they go through and ask questions.
47.
And I've set to the benefit 1:30, and you'll go Patrick Haggerty from Somerset, clock for lunch break will provide whatsoever or to do anything. Testimony that difficult. You don't necessarily have Any question that I ask, please raise your hand until the court officer reads your number.
Heck yeah.
Do any of you folks or
Hallelujah,
close
yeah.
personal friend or family member know, or have
Hallelujah, yeah.
you had any prior dealings with any of the witnesses whose names you heard?
Juror number 343, 360, 347, 339, I swear we can scratch 360.
Thank you.
Juror number 348, juror number 344, juror number 333, juror number 310, juror number 355, juror number 332, juror number 323, and juror number 312.
Okay. Thank you. Do any of you folks or close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office?
Juror number 326, juror number 328.
Thank you. Do any of you folks or close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses.
There was one last time.
Please raise your hand if you have seen, heard, or talked about this case.
Juror number 319, juror number 317, 352, 353, 311, 343, 360, 347, 354, 324, 328, 322, 326, 339.
Juror number 330, juror number 357, juror number 321, juror number 333, juror number 351, juror number 344, juror number 348, juror
No, I
number
didn't, don't I?
361, juror number 341, juror number 310, juror number 340, juror number 334, juror number 338, juror number 355, juror number 332, juror number 349, juror number 325, juror number 323, juror number 337, juror number 350, juror number 312, and juror number 359.
Lastly, juror 329.
All right. Thank you very much. Could you please raise your hand if you have expressed or formed any opinion with respect to this case?
Oh, let's see.
Juror number 319, 353, 311, 343, 347, 354, 322, 326, 339.
Juror number 330, juror number 333, juror number 344, juror number 348, juror number 361, juror number 341, juror number 310, juror number 334, juror number 320, juror number 312, juror number 350, and juror number 325.
Thank you.
21. Wow.
Are any of you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? Please raise your hand.
Juror number 326, 328, 354, 319.
Thank you.
Oh, cool. And then it's 21 of the
Do any of you folks have any difficulty hearing or any problem with understanding the English language or any
I have a
physical or mental condition or any religious or philosophical?
I have a huge problem with that.
Any problem hearing? That's what interpreters are for. They have listening devices. That to me should not be a prerequisite. If you have a problem understanding the English language, do you have language barriers? That's fine. But honestly, if you're disabled enough like I am, you would already have notified the court and you would have asked for an interpreter. I have a problem with this question. It does rub me raw.
Philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict. Could you please raise your hand if you do?
Juror number 344, juror number 321, juror number 325, and juror number 342.
Thank you.
Number 360, 324.
Thank you. Please raise your hand if you think you will have any difficulty following the important constitutional concepts that I've described to you. First, that the Commonwealth has the entire burden of proof in this case. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant is presumed innocent and does not have to do a thing other than sit in that chair for the trial. Would anybody have any difficulty applying those very important constitutional principles? If so, please raise your hand. I see no affirmative responses.
Oh, I figured one would be.
I can tell you folks that after every jury trial, I talk to jurors. And though they may not have been thrilled about having jury duty, they always tell me that they have found the experience to be a very interesting one, and often jurors tell me that they find it to be a very rewarding one. But I do understand that with this case and this,
I am pissed that they are doing that. I really am. I don't think it's right. I don't think it's fair. And if I lived in that county, I'd be filing lawsuit.
schedule, it may be an undue hardship for some of you. Let me tell you what I mean by undue hardship. When I told you earlier that all civic duties cause us some inconvenience, an undue hardship or a substantial hardship is much more than that. It's
Jane. I got to do it. Brilliant, Jane. Good one.
Something that means that it's personal to you, and the person sitting next to you will then have to step in and give up time from their lives. I generally think of it in terms of either you're a student or you have airline tickets or surgery scheduled for the time that we will be on trial. So with that in mind and that very rough definition, please raise your hand if you think that you have a substantial hardship that will prevent you from being a juror in this case.
Juror number 319, 317, 352, 311, 343, 360, 354, 326.
Juror number 361. Juror number 348, juror number 351, juror number 346, juror number 333, juror number 355, juror number 338, juror number 334, juror number 310, juror number 341, juror number 350, juror number 323, and juror number 325.
Okay. So in a minute, I'm going to leave the bench and give you an opportunity to fill out those supplemental questionnaires. I asked.
All right, that's the end of that. That'd be it for the end of the day. So we've got a long time to kill. So what I'm going to do is I'm going to go ahead and I don't want to do that. I'll start that tonight. I don't want to get us too crazy. Everybody, let's have a little stand up and stretch. Y'all stretch. Y'all go to the bathroom. Do what you got to do. We're going to take a little break. We'll be back. Hey guys, here we are. Hold on. I know. I was saying something I probably shouldn't have said. My son has one of those voices that just carries like crazy, so I had to go shut the door. And we have a new Karen Reed document that just dropped. Thank you again. I cannot thank you enough. Our fabulous partner in crime and your one-stop shop place for court documents on over 500 trials is As the Gavel Drops in Discord. Go to Discord, find As the Gavel Drops, log in, create your account. Then you need to verify your account. Once your account has been verified, you are free to look and download all the same documents that we have here. And they're the one and only place to go. There are other places that try to do what they do, but boy, let me tell you, As the Gavel Drops is amazing. And they're the ones you want to go to for any and all court needs, especially in documents. Okay, no more new and unread. Okay, we got it all. Okay. Here we go. Let me get this in big and a little better so y'all can see it a little better. And I can see it a little better. There we go. All right. Defendant's response to the Commonwealth renewal motion in limine to exclude the expert testimony of Garrett Wing. Now comes the defendant, Karen Reed, Ms. Reed, or defendant in the above captioned matter and respectfully requests the court to deny the Commonwealth's renewal motion in limine to exclude the expert testimony of Garrett Wing. Renewed motion. The entry of the Commonwealth's renewed motion appears to be based upon an inaccurate premise that the defense intends to call Lieutenant Garrett Wing or Lieutenant Wing as a rebuttal expert to the Commonwealth's expert, Dr. James Crosby. Dr. Crosby is actually the defendant's intended to call Lieutenant Wings. In actuality, the defendant intends to call Lieutenant Wings as an expert witness in her case in chief and not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. As a defendant in the state previously on June 18, 24, the court determined that only medical doctor could opine to the medical cause of the injury of a human to a human. Until March 6 of 25, the defense therefore operated under the impression that only medical doctors were able to testify as to the medical causation of injury to humans, including injuries caused by any dog bites and or claw marks. Footnote 1. Defendant does not waive the reserve any argument put forth against the Commonwealth original motion limine to exclude expert testimony of Garrett Wing. Oh gosh, I'm going to start getting the yawnies now. I always do this time of day. Additionally, until March 6 order, several questions remained about how wait a minute, I really jumped. The court on March 6 order caused the defendant to revisit the topic of wounds to the right arm of the decedent, including potential witness experts in the dog inflicted wounds on a human who were not medical doctors. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness for Crosby. Rather, that the court's determination for Dr. Crosby include the defense motion for reconsideration on March 6 order would infirm defense strategy regarding Lieutenant Wing. Additionally, until March 6 order, several questions remain about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. An oral argument on March 4th, 2025, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against testimony of defendant's expert witness, Dr. Russell. If you are brave to chat about KR, I once asked an open-ended question in chat that one freak replied to me, "How's long before I come to your house?" These people are okay. If anybody said that on this chat, they are banned immediately. You are allowed to have different opinions here, but no one will hunt you down, hurt you, or threaten you. Because if they do, they will deal with me. And honey boo, you don't want to deal with me. I will send you to the block party so fast. And if that did happen here, then Miss Jane, get a hold of me in private chat in Discord and tell me who it was, and I will handle it. The court asked, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief? Commonwealth responded, absolutely not. Commonwealth renewed motion, docket number 658, Exhibit B 3424 cited. However, the court March 6 order contained no such limitation or scope to Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Due to the lack of memorialization of the Commonwealth speculation, the defense reasonably assumes that the Commonwealth could call Dr. Crosby on its case in chief should it choose to. For the first ever time in writing, that should be for the first time in writing, and after receiving the report of Lieutenant Wings, in its renewal motion of the Commonwealth state that it intends to offer Crosby only if necessary to rebut the testimony of Dr. Russell. Commonwealth renewed motion at 1 docket number 658. The defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wings decades of knowledge, skill, training, experience, together with a documented methodology, qualify him on the subject of dog-infected wounds on humans to cure any perceived complaints by the Commonwealth that Lieutenant Wing original report. The defendant will provide an amended report of Lieutenant Wiggs, which will remove all reference to Dr. Crosby. The defense expert to provide this amended report to the Commonwealth within the next 5 calendar days. Wow. Yo. I got this yesterday. It's a chocolate camel. And I so want to eat it. And I need a cup of coffee. Something seriously. I seriously need a cup of coffee. And Isaac gets me one. But I may have to get more water. Should have done it on break. Dagnabbit. Okay, guys. Give me 1 second. I'm going to put music on. We got to pause. I got to get me some coffee or I'm going to fall asleep. Okay, guys, sorry about that, but I'm just really struggling and realized I had no coffee today. Okay, as the defendant intends to call the Lieutenant Wings as an expert witness in her case in chief, the discussion of law on the page 2 of the Commonwealth's renewal motion is inapplicable. See Commonwealth renewed motion at 2. Notwithstanding, and reference to the Commonwealth incorrect assumption. I love assumptions. They make, that the defendant intends to call Lieutenant Wing as a rebuttal witness to the testimony of Dr. Crosby. The Commonwealth states in its renewed motion that there is no sub-rebuttal in Massachusetts. This statement is accompanied by no authority and is incorrect. Woo! Hoffman, Holton, Chemical Corp. 434 Mass 624-641 2021 allows sub-rebuttal witnesses. The judge limited Holton to one sub-rebuttal witness only. Cited. Again, allowing sub-rebuttal witness on sub-rebuttal, Brown testifies 2 Walkmans were returned to him after his arraignment. Okay, in fact, expert witnesses are explicitly allowed to testify in sub-rebuttals in Massachusetts. Cited. A defense sub-rebuttal expert who examines the same test results reaches different conclusions and testified that Brown was not malingering. Therefore, if the defendant did indeed call Lieutenant Wing as a sub-rebuttal expert, there is no Massachusetts law the defense could locate that would prohibit her from doing so. Indeed, there is contrary law in her favor on this issue. Wow. Okay. In conclusion, on page 4, for the reasons set forth here, within the court should deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. The defendant intends to call Lieutenant Wing in her case in chief, not as a rebuttal witness. Well, that's good to know. That very good to know. Making my coffee, y'all. I know. I'm may keep me up, but oh well. As of the court's March 6 order allowing Dr. Crosby to testify as an expert, experts are no longer required to be medical doctors to testify about the medical conditions of injury, causations of injuries. See, that's what kind of perplexed me. Last trial, she said they had to be medical doctors. Now she's gone back on that. Decades of knowledge, skill, training, experience together with his documented methodology qualify him on the subject of dog-inflicted wounds on humans. Finally, and in the alternative, only rebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. And it was Robert Alessi, Alan Jackson, Elizabeth Little, David Yannetti, and Robert Anessetti, but the other lady didn't sign it. Oh, okay. Well, that's fine. So we are how many minutes in to our lunch? We're about halfway there. Yes, get yourself some Hitchman Homestead coffee. You can order it through we have a link. Hey, y'all, please help me welcome the Hitchman Homestead coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Kirk option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. This cup is very special. I made this in a ceramic class. This was a sticker they put on. My father was in the Coast Guard, and I made this. Oh my gosh. 46 years ago in a ceramic class for my daddy. And he passed away, and my mama gave it to me. Thank you, Mama. So the defense is requesting the last 2 days in the Karen Reed's case. They've been requesting in the last 2 days the list of jurors that have been accepted thus far. Do we have any jury counts? I need to go to X and see. All right, on our poll, we have 47% said 1 to 2 hours. Only 13% in the poll said 2 to 4 hours, and she did it in, let me look at the time. $3:12 all the way. $38, 138, 238. Right, just over 2 hours, between 2 and 3 hours. She did have a 15-minute break. So good. We're going to get into the closing arguments of the defense, and they are running a little behind. It is now 1:00 there. So it looks like we're going to go into jury deliberations. It'd be great to have this thing done and completed and in full by tomorrow night. I don't know how they run their courts. I will stay here until they give a verdict. We do have another case we're paying attention to. That case is the Linda Sturmer trial, where she is being alleged to have unalived her husband by burning down the house and running him over in the car. I know. Thank you. Brings back sweet memories. But they are nowhere near the end of their trial. But if you guys like spicy attorneys and bantering, y'all got to come join me for that trial. That particular trial, oh my gosh, y'all. It is, those attorneys, the witnesses are meh, but boy, some of the medical witnesses got a little snippy with the attorneys too. So that was way cool. Way cool. So I'm going over to YouTube right now to see if there's anything we can find that we need to watch. I'm looking. Lori Daybell will start on Monday, early in the morning for me. Maybe not. I don't know. We have volcanic eruptions in Hawaii. So that's going on. I am looking for important things. Let's go to trials. Judge Boyd. We love Judge Boyd. Oh, this is a Selena wannabe. This woman is a Selena.
I know that's sort of less than, but you know.
Pick it up a little. Oh, this is trial. So they're in the middle of trial.
I mean, if you want, we can reset it for sentencing.
Judge, let's try to talk to them. See if there's an option to spread up the listener appointment until the 10 days. But There's another option, extra service hours or extra monies in lieu of a 15-day confinement.
The judge is
No,
like,
yes.
no,
They
just want a
recommend
jail booth.
partial GPS.
We can do partial GPS. But I still am gonna want her brought back for sentencing. Let me just tell you, sometimes I will do this, sometimes not, but based upon what I'm reading in the report, I think we need to get a TAP evaluation done just so I can see what will be appropriate for her. How long would a TAP evaluation last out of custody?
2 weeks.
Judge, I could probably get it done maybe within 2 weeks.
All right, so let me see where that puts us.
Mm.
Is it possible for us to shoot for April 17th?
Nope. That's
I
all.
know that's sort of less than, but that's my mom's birthday week coming up.
Sure, Judge, I can ask for.
Yeah, her and her mom
All
are
right, so
close.
we're gonna come back on April 17th. The state said they will be in agreement to you're just doing GPS instead of Bear County Jail. And just let me know and put on the record that she has employment. She will lose her employment. Then I can find that there's hardship that exists if she were to serve the 10 days, and she can serve it on GPS partial for employment. All right, so we're going to recall this, and you're waiving the PSI, correct?
Yes, sir.
All right, so we're going to recall it for
So
April
she got 10 days
17th.
in trial.
And what's going to end up happening is, after reading everything, I'm going to follow your plea bargain agreement, but I need to find out if you need sober support meetings, if you need any type of thing to help you with this alcohol issue. You understand? All right, so make sure you make all of the appointments that probation sets up for you, especially that TAP evaluation, because that'll tell me everything I need to do, okay? All right, thank you. You're welcome. Yeah, well, once she signs the reset form and once she speaks with probation, she'll be excused. Thank you.
Thank you, Judge.
See, she can be real reasonable sometimes. Either people hate or love her. One of these days, after the Karen Reed trial, I'm going to go and I'm going to sit in that woman's court. I was going to bring my baby with me. She's gone. For those of you who don't know, my service dog passed away Saturday, and it's been devastating and a week of hell. But I am so much better being here with you. Nights are hard, very hard when I'm not on live. When I'm live, it doesn't hurt as much because I'm busy. Just saying. So apparently she's been in court.
Incident to take place, right?
Correct.
And that your vehicle was behind this black Kia.
No, I'm going to go in person and sit in her
You
court.
saw a struggle inside the Kia, right?
Y'all can see me. I'll set it up.
Well, I thought that they were just playing around.
You thought they were playing around?
Yes. Mhm.
Okay.
As far as how I can see it from behind.
Okay, gotcha. You didn't see any guns brandished at that time while they were in the car.
No,
You eventually saw someone get pushed out of the car, correct?
correct.
You believe that all the occupants of the vehicle were Hispanic, right?
On my phone call?
Out
Yes.
on the vehicle?
And you later gave a statement to police where you said that you didn't know the race of the shooter, right?
Correct.
You also indicated you didn't remember what the shooter was wearing, right?
I think he was wearing like a sweater that I recall.
Fair to say your recollection
Like a
back
hoodie.
in 2017 was better than it would be today?
That
You
must be
recall
a
giving a
common
written
question.
statement to the police back then?
Not of what he was wearing, but I do recall a statement that I did.
You recall telling the police you didn't know what he was wearing back then?
Yeah. No, I didn't.
May I approach you? Honor?
Yes.
So God, I'll show you what I've already marked for identification as defendants 3. You recognize your name and date of birth here, correct?
Correct.
And you recall signing this document
Mhm.
back in 2017?
Mhm.
And I'm so sorry, Ms. Delgado.
Yes, I'm sorry.
Yeah.
Yes.
Thank you so much. I'm
Oh,
going to call your attention to page 2 of that statement. I'd like you to just take a look at this paragraph. Let me know when you finished reading it.
Okay.
So you'd agree that back then you told officers that you didn't know what he was wearing?
Yes.
Okay. And we hear you on that call say that they put weed in his mouth, but you've acknowledged that you didn't see anyone put marijuana in the man's mouth.
I did not see anyone.
Yeah,
put
we need to get the
marijuana,
numbers
But
on
when I went to
giveaway.
go see the body, there was marijuana in his mouth.
Understood. You also say that you saw the man on the hood of the car kicking the windshield, right?
Correct.
And when you first saw the black Kia and the people messing around or playing around in the car, you and your husband were listening to music. Recall that?
Yes.
I'll pass the witness.
No question, John.
Is this witness excused or subject for recall?
Excused by the defense, Your Honor.
All right, the rule has been invoked. You're not allowed to view or anything or talk about this trial while the trial is occurring. Do you understand?
Yes.
All right, you may step down, remove the microphone.
I like that.
State, you may call
They
your
have
next
the clip
witness.
on. That's nice.
The state calls C. Emily.
And Your Honor, defendants 2 is withdrawn.
All right. Defense exhibit number 2, is that the video? All right.
Oh, wonder what this witness is going to say. I don't even know what case we're on.
Raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear. If you'll state your name and spell your last name.
Catherine Imler, I, M as in Mike, L-E-R.
All right, state, you may proceed.
Ms. Emler, back in 2017, did you have a different name?
I did.
What was that?
Andrews.
Okay. And back in 2017, how were you employed?
I was a crime scene investigator for the city of San Antonio.
Okay. And as a crime scene investigator for the city of San Antonio, what was your title, or what kind of training did you have to undergo to become a crime scene investigator?
Crime scene investigator training requires 400 hours of in-classroom training, along with 5 weeks of rides with a senior crime scene investigator.
And are you trained in evidence collection and preservation?
Yes, ma'am.
And how long were you employed with the city of San Antonio?
Just under 7 years.
Maybe 1 or 2 more days and we'll be done.
And on
Maybe we'll start trial next Tuesday.
2017, were you employed as a crime scene investigator with the city of San Antonio?
Yes, ma'am.
Do you recall what shift you were working?
B shift.
And do you recall what time that was?
That was a 2 p.m. to a 10 p.m. shift.
And on that day, were you dispatched to 27 Northeast Route 410?
I was.
And was that location located in Bexar County, Texas?
Yes.
Do you recall what type of location that was?
It was a Chick-fil-A restaurant.
And do you recall why you were
Chick-fil-A.
dispatched to the location?
I was dispatched to assist another CSI that was processing a shooting.
What was that CSI's name?
Kimberly Wong.
And just so the jury's aware, can you explain what the abbreviation CSI stands for?
They have gone through almost 400. 400. There were 380 something, I think was the highest number I heard today. They've gone through a lot of people.
Crime scene investigator.
Okay. And do you recall the SAPD case number associated with this case?
I'd have to see my report.
So you wrote a report back then?
Yes.
All right. Your Honor, may I approach the witness?
Yes.
No.
Monica's line of defense. She wasn't there. She was shopping at Target. Yeah, I know. Yeah, we're just waiting for Monica Sementilli to come back. The prosecution had finished. They said they finished their closing arguments. Then, if that is the case, we will get to the prosecution. I mean, the defense's closing arguments. Then we'll go back to the prosecution for its rebuttal closing. I'm hoping that the jury will get this today, if not first thing tomorrow. It would be fabulous. So we had a verdict tomorrow. Just saying. But really, Monica's Sementilli, just her defense is I didn't do it. But one thing that I found interesting that came up, and it was kind of glazed over by some, but I think it's very important, that they proved by the security camera data information that her phone connected to the IP address of the security system while she was shopping, and that she was actively viewing the security through the security system, the home. And she knew what was going on, when and where and how and why. And then that she did not arrive home till minutes after her daughter. She waited to return home, in my humble opinion, so her daughter would find the husband, dad, and then she came rolling in, and there we go. I think one of the biggest damning things for me is two things. The phone calls where Baker says he's going to cover it, he's going to take care of it, that don't worry, he's going to take the fall for this. And then the other one was the video camera, security camera system, where it locates the fact that she was logged in for extended periods of time during the day, especially leading up to and during the time of the unaliving of her husband. Just those two facts right there make it hard for me not to say not guilty. She knew something.
All right, now I'm showing you what's been marked for identification purposes as
Very much.
State's Exhibit number 13. Do you recognize this document? Whoa. Showing you what's been marked as State's Exhibit number 13 for identification purposes. Do you recognize this document?
I do.
All right, and is that your name contained on the document?
It is.
And was that your badge number back in 2017?
Yes.
And this is a fair and accurate version of your report?
Yes, ma'am.
And you've reviewed this before today, correct?
Yes.
All right. And would it help refresh your memory if you were able to refer to it during your testimony?
Yes, ma'am.
All right. Just make sure you don't read exactly from it, but if you need to refresh your memory, you can look at it.
Okay, thank you. Yes, ma'am.
All right.
Yeah.
We're going to pause this for a minute. I need to read something. It's a one-page thing. Thank you so much. June. Right now, there is a petition for a writ of certiorari to the United States Court of Appeals for the First Circuit. Petition of writ of certiorari. I can't say it. Somebody help me. That was filed. It only gives me the cover page. Details will be coming up. But what is that? A writ of certiorari, if that's right, is a type of writ that orders the lower court to deliver its records in a case so that the higher courts may review. The word certiorari, I wish I can hear this pronounced. Aurora. Oh, hello.
It's surgery.
Thank you. Hold on. Surgery. Sorry, babe, didn't mean to hang up on you. Let me get back to where I was. Comes from the law, Latin mean word to be more fully informed. Its decision by the U.S. Supreme Court to hear an appeal from a lower court. The act of granting a certiorari, if I said it right, means the Supreme Court agrees to hear the case. Other courts, such as the U.S. Court of Appeals, state Supreme Courts, and the State Court of Appeal may also issue such writ. So they are still fighting vividly, viciously, and very, very strongly for the double jeopardy. So they're still going for that. Thank you so much for that, June. You are fabulous. I've got somebody I don't know in Discord communicating with me. Hopefully they're not some troll. We'll find out. Okay, back to the, I know she's.
If you can take a look at that and just let me know what the SAPD case number that was associated with the case was.
The SAPD case number is SAPD 17089350.
All right.
Yes,
And is
that was
there
down
an
in front of her.
incident number that was associated, or CFS case number associated with the call?
Yes, ma'am.
And what is that?
It is SAPD 2017-0424-102.
All right. And do you recall, or can you describe the scene that you encountered once you arrived at the location?
Yes. When I arrived at the location, I observed a deceased male with a yellow tarp over him. Parking lot was fairly empty. It was contained.
Okay. Do you recall what other crime scene investigators you were working with on that day?
Yes, Kimberly Wong and Matt Flores.
All right. And when you arrived on scene, how did shell casing been located?
No, ma'am.
All right. Ultimately, you recall who was able to locate the shell casing?
Yes, ma'am.
And who was that?
I identified the shell casing.
And in preparation, you met with me before this to go over your reports. Is that correct?
Yes, ma'am.
And you've had a chance to review some body worn camera footage that contains you.
Yes.
All right, I'm going to show you what's been marked as States Exhibit 14 and 15. Do you recognize what is contained in States Exhibits 14 and 15?
Yes.
And are they a fair and accurate depiction of the scene on that day?
Yes.
Okay. I'm tendering to defense for inspection. State offers States 13 and 14 and evidence.
No objections.
All right, States Exhibit 14 and 15 are admitted without objection.
May we publish, Your Honor?
Yes.
And she never paid attention to there was almost no logins, remote logins prior to the day of his unaliving.
Now, on States Exhibit number 14, can you see that up there? Can you explain to the jury what is depicted in States Exhibit number 14?
Yes, you can see the yellow tarp, the end of it on the bottom. There's a patrol officer and
And she has a yellow purse today.
Okay, and this,
yes.
what I'm pointing out is you.
Yes.
And States Exhibit number 15.
This one, again, you can see the yellow tarp in the back. That is Kimberly Wong. And then I'm also in that image.
And so this individual that I'm pointing to right here, who is that?
Kimberly Wong.
Okay, individual I'm pointing to, who is that?
That's me.
Do you recall, so ultimately, you're the person that locates the shell casing and points it out to Kimberly Wong and the officers on scene, is that correct?
Yes, ma'am.
Right. And do you recall what kind of shell casing it was?
It was a 9mm.
All right. Did you prepare a crime scene sketch in this case?
I did.
Right. Now, I'm showing you what's been marked as State's Exhibit number 16. Do you recognize what that is?
Yes,
And did you participate in the participation of this diagram?
I did.
And were you familiar with the locations and objects contained in the diagram at the time of the preparation?
Yes,
Okay, and is it State's Exhibit number 16 a fair and accurate depiction of the layout of the crime scene as it appeared at the time of your investigation?
yes.
Tendering to defense for inspection at this time, state officers, State's Exhibit number 16.
Objection.
State's Exhibit number 16 is admitted.
Permission to publish.
Granted.
I'll be right back.
So briefly, can you explain to the jury the process for preparing the sketch and obtaining the measurements that are obtained within the sketch?
Yes, ma'am. So after the items of evidence are identified, a sketch is completed, noting any structures or any information that may be able to provide detail about the location, in this case, a parking lot. Each item is measured from 2 points of reference using a wheel, measuring wheel. And then you take two measurements, one, in this case, maybe from a curb line to that item of evidence, and then from another curb line to that item of evidence.
And I'm going to zoom in on State's Exhibit number 16. All right, and we can see it reflected within your sketch on State's Exhibit number 16. There is something labeled E1. Do you recall what E1 represents?
E1 represents the shell casing that Kimberly Wong marked with the placard.
Okay. And is Kimberly Wong the person that sees E1?
No, I first identified it and then she put the placard down.
Okay. And at the scene, you earlier stated that there was a deceased victim identified. Is that correct?
Yes, there was a deceased victim on scene.
Okay. And as part of your duties as a crime scene investigator, had you previously been trained on collecting gunshot residue samples?
Yes.
Okay. Can you explain to the jury if that's something that would have been done in this case?
Yes.
And why is that?
Anytime that there is either evidence or suspicion of a gunshot residue tests are collected from anybody that's possible, even the deceased victim. And sometimes they want it from witnesses, but in this case, the deceased victim.
Okay. And what does the gunshot residue kit contain?
It contains 2 vials, one for your left, one for your right hand. It contains gloves, and it also contains a document that you have to fill out, basically answering questions if you're able to. Sometimes you can't answer the questions.
Okay. And can you just explain to the jury how you go about collecting the sample?
Yes. In general or in this case?
In this case.
Okay, so in this case, the medical examiner arrives on location and basically provides the permission to collect it. You again use 1 vial for their left hand, 1 vial for their right hand. It has like a sticky pad on it, and you essentially pat the back side of the hand, sometimes down the wrist, in between the fingers, on both hands.
Okay. And that's what you did in this case?
That is what I did.
Okay, and so did you follow all the appropriate instructions and procedures?
Yes, ma'am.
And you collected samples from both hands, is that correct?
Yes.
And were you wearing gloves when you did this?
Yes.
Okay, and after collection, what do you do with the sample?
I secure the sample. It has its own red label, and then you place it into another envelope, tape it, identify it with your badge number and initials, and then turn it into the property room.
Okay. And is this evidence seized under SAPD case number 17089350?
Yes.
Okay. And when you seized that, well, if you want to take a look at your report, was that marked as E1 in your report?
In my report, it was identified as E1.
Okay. And when you seized it, did you make any unique markers on it?
Yes, my initials and my badge number and the date.
Mm. I can eat tomatoes like candy.
All right, now I'm showing you what's been marked as State's Exhibit number 17. Do you recognize this?
Yes.
Okay, and is that physical evidence that was seized under SAPD 17089350?
It was.
Okay, and is State's Exhibit number 17 labeled as E1 in your report?
It is.
Okay, and you've seen this before, State's Exhibit number 17?
Yes.
And when and where did you first see it?
When I collected it, you mean?
Yes.
Yeah.
On
Yeah,
scene,
on
is that
scene,
correct?
yep.
Okay, and does it have any unique identifying markers on there?
Yeah, it does have my initials, my badge, the date. I also indicated a biohazard, and then of course the evidence ID label.
Okay, and is that how you're able to recognize that it's the same thing that you seized back in 2017?
Yes.
Okay. Do you want to approach and come look at it?
Sure.
Tendering to defense for inspection, but at this time, state offers State's Exhibit number 17.
Your Honor, can I briefly voir dire the witness?
Yes.
Afternoon, how are you?
Hi.
This is labeled as E1 on your GSR kit,
Yes.
correct? Okay, that's different than the E1 on the sketch that we see on the overhead?
That's correct.
Okay, so they're both E1 for
Yes.
these purposes, but this is just simply the gunshot residue testing on the hands of the deceased.
Yes, sir.
Okay, no objections.
State's Exhibit 17 is admitted.
And I,
Yes.
see. Thank you.
Okay, and just for the record, you've pulled out another envelope that was contained inside of State's Exhibit number 17. Can you explain what that is?
Yes, this envelope is the actual gunshot residue test. It has the contents of the vial, before you open it, it would have gloves and the document and everything in there as well.
Okay. And just on the front of that, do you have a unique identifying mark on that?
Yes, my first initial.
Okay, I've been corrected and I'm happy for it. Certiorari. Certiorari is how that is said. A writ of certiorari. Okay, so we'll read it again a little later. But we're going to stay here. We just got a few minutes before Monica Sementilli comes back.
Last name, my badge number, and the associated case number.
Thank you for the love.
We passed the witness hearing.
May I proceed, Your Honor?
Yes.
Thank you. So I want to call your attention back to the sketch that's on the overhead.
Yes, sir.
In that overhead, right, I guess directly east of the head of the deceased, you have a notation E1 that's circled. Do you see that?
Yes.
And in this sketch, E1 is the shell casing that you saw?
Yes.
Okay. And E2 would be the baggie of marijuana that you found?
I would have to reference Kimberly Wong's report for her
Okay.
items of evidence.
Let me ask you this real fast. In preparation for your testimony today, have you reviewed any of the reports that weren't authored by you?
I did get a chance to take a look, but I didn't read it in detail.
Okay, and when you say to take a look, are you referring to the property report or a specific report of Ms. Wong?
The crime scene report.
May I approach? I'm sorry, Your Honor, I forget.
No
You
problem.
don't need me to ask that.
No, you all can approach.
I just want to show you for identification, defendants 4. Is this a property report that was generated in association with the same case number 170-89350?
Yes.
Is this what you're referring to that you reviewed separately from your own report?
No, sir. It would look like this, the crime scene search report.
I see. But this was authored by you, correct?
Yes.
Okay, but you reviewed one by Ms. Wong that would look exactly like
Right.
this. Okay, but you did not review the.
No, I didn't see that.
Understood. So, speaking of the report that you have in front of you that you authored, you don't mention. Is there a key here that tells us what E1 and E2 are on your sketch?
No.
Okay,
Yeah.
so that part you're relying upon from your memory.
That part, yes, but also Kimberly Wong's report would indicate the items of evidence.
Understood, because as you were explaining, you saw the shell casing and the baggie of marijuana, but Kimberly Wong is the evidence technician who actually bagged those pieces of evidence to go back to the station for review, right?
Correct.
Okay, so did you, in your report, you do not notate that you gave Ms. Wong any kind of a list or an index of the evidence pieces that you identified in this sketch, right?
Correct. Because
Ms. Wong applied her own evidence labels to those pieces of evidence when she processed them, right?
Correct.
So your E1 may or may not be the same as her E1. Your E2 may or may not be the same as her E2. Fair to say?
Right.
Okay. So, who's Allison Bustamante?
She is another crime scene investigator.
Okay. And was she present at this scene?
No.
But she was involved in this investigation at another scene related to it, right?
I have no knowledge of what was processed outside of this scene, so I'm not sure if she was or not.
Okay, understood. So would it surprise you to know that there have been multiple items of evidence entered in as E1s, E2s, E3s, et cetera?
That would not surprise me.
Okay, that happens fairly common.
Yes, that is the standard.
That is the standard.
Yes,
In other words, your story is your story. What you did is in the chronological order of your observation, E1, E2, E3. And then somebody else was sent to the scene and they have their own E1, E2, E3.
correct.
Eventually, you all put barcodes on pieces of evidence
Ain't that the truth?
to better identify, right?
Correct.
When is the barcoding process done?
We create the barcode back at the, we have a crime scene lab, and that's where you enter the information into the database and it will print a physical label.
And you were not involved in the creation of any of the barcodes for any evidence seized from any scene in this case, right?
Just my own.
You just your own.
Yes.
Okay, so you would have created the E1 barcode?
Yes.
Okay. Is there a reason why ultimately that 9mm shell casing would be labeled with a barcode under Kimberly Wong on the final property report?
Kimberly Wong was assigned the evidence collection. So anybody on scene, all CSIs on scene are searching the scene. If we observe irrelevant evidence, then we can identify it. But the CSI in charge, in this case, this was Kimberly Wong's, she was the primary crime scene investigator, and it was her duty that day to collect the evidence.
Okay, but you created the barcode for this evidence,
I created the barcode for the gunshot residue test.
for the gunshot residue test.
Yes,
Okay, which is not E1 on the drawing.
that is correct.
It is E1 on your report, right?
Can you clarify, sir? Are you asking?
You have your report in front of
I
you,
do.
correct?
Mhm.
If you take a look at it, I want to make sure I'm not mistaken. You advise in the report that you collected the gunshot residue test, right?
Yes,
And then you also advise I collected E1 as stated above. Do
yes,
you recall writing that?
yes.
Is the E1 as stated above in this report that you authored the gunshot residue test, or is it the 9mm shell casing?
The gunshot residue test.
Okay, so your E1 on your report is the gunshot residue test.
Yes,
But E1 on the sketch is the shell casing.
yes.
Okay. You have no supplemental reports explaining that you called two different things E1 through the course of your role in this investigation.
No.
Okay. When would you have created the barcode for E1?
When I returned back to the office and I entered the information.
And that barcode was for the gunshot residue testing swabs.
Yes, sir.
Okay. So you did not create a barcode for a 9mm shell casing.
No.
Okay. Pass away.
No further question.
Is this witness excused?
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone while this trial is proceeding. Make sure you remove your microphone and then you're excused. Thank you. And if there's anything that's been entered into evidence, if you'll leave it with the court reporter.
Thank you.
All right, state, call your next witness.
State call Sergeant now.
If you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jurors can hear. And if you will state your name and spell your last name, please.
Yes, ma'am. My name is Robert Mount, last name Mount.
Right, state, you may proceed.
Thank you, Judge. And it's Sergeant Mount now?
Yes, sir.
And are you employed by the SAPD?
Yes, sir.
And how long have you been employed by the SAPD?
14 years. Next month will be 15.
Congratulations on 15.
I appreciate it.
And I'm assuming you go about becoming an SAPD officer, you have to go through certain training. What type of training, briefly, did you have to go through to become an SAPD, just officer?
Yes, sir. So I went to the San Antonio Police Department's training academy, and during the academy, became a state certified peace officer through the state of Texas. And during that training, we went over various topics such as the Texas Penal Code, the Texas Code of Criminal Procedure, and the San Antonio Police Department's General Manual, which goes over policies and procedures.
And again, you stated you've been with the SAPD for 14 years.
Yes, sir.
And when you initially joined up, you were a patrol officer or just an officer, is that correct?
Yes, sir.
And then is there anything in between an officer and a sergeant?
Yes, sir. So it was about 4 years in, I became a field training officer. And at that point, I was responsible for training new officers out of the academy.
And can you describe to the jury what a field training officer is?
Sure. So a field training officer, essentially officers will go through the training academy. Once they graduate, they have to ride in the field with a field training officer for a period of time. And they go through different phases of training. And then once they get through those phases of training, they're evaluated and then they're released on their own as long as they pass those different phases.
So a field training officer is somebody that assists other officers and I guess their duties.
Yes, sir.
And it's trains.
Yes, sir.
And is that commonly referred to as FTO?
Yes, sir.
And after you became FTO, then you become the sergeant. And how long have you been a sergeant?
Well, in between there, I was a family violence detective, and then I became a supervisor, a sergeant. And I've been a sergeant since October of 23.
Thanks. I'd like to reference April 23rd, 2017, roughly a little after 5 o'clock in the afternoon. That's why you're here today.
Yes, sir.
Do you recall that day?
Yes, sir.
And do you recall being dispatched to a certain location in San Antonio?
Yes, sir.
And what location was that and why were you dispatched?
We received a call for a shooting in progress, and we went to the location of 410 and McCullough is where the calls were coming out.
And this location, well, one, what are your initial duties at that time?
Up, eating.
So for us at that
Right.
point,
Candy.
acting in the capacity of a training officer, our job basically, we were taking report responsibility. So when we got there, we were trying to
Sorry,
gather
no.
information that was needed.
I have a bowl of candy that we put out for our customers. And my son helped a customer and I got the camera here. And he's sitting there jumping down on candy. And I'm like, stop eating my candy. He didn't respond. The second time he went. I think there's one piece of candy left. We'll keep going. I'm gonna go to the bathroom before we get back into Sementilli. They should be back any minute.
In order to establish, number one, whether or not a crime was committed, try to get the elements of the offense, and try to determine what evidence may or may not be available.
And you stated we. Do you mean all the officers at the scene, or can you describe to the jury what you mean by that?
Sure. So I was riding as a front seat passenger. I had Officer Chase Thackerson. He was riding with me at that time. And so we went to that location so that way he would be able to handle that incident.
And were you just riding along with him, or were you had other duties associated to you with Thackerson?
Sure. So I was evaluating him and what he was doing. And so I was acting in the capacity as a field training officer on that date.
So exactly what you just described to the jury about the FTO.
Yes, sir.
So when you did arrive at the scene, what did you specifically do as you arrived?
So when we first arrived on scene, I observed that there was a complainant that was apparently deceased in the parking lot of the Chick-fil-A. And when I had gotten there, I observed that there were other various people in the area. And typically when we have somebody that passes away, just out of respect, we try to cover that person. And so I got with one of the emergency medical technicians from the San Antonio Fire Department and asked if they had a yellow sheet so that way we could cover the complainant.
And did you obtain that yellow sheet?
Yes, sir.
And what did you do with that yellow sheet?
I took the yellow sheet and we covered the complainant so that way he wasn't exposed in the parking lot for all the passerbys. And we're right there on the 410 access road, so we wanted to make sure that it wasn't going to be an unnecessary distraction, but try to limit the number of onlookers that would naturally go to that type of call.
And I guess, did media ever show up at the scene?
I don't recall seeing the media. I believe the supervisor at the time might have spoken with somebody, but I don't recall seeing the media.
But you yourself did not speak to any media or anything.
Correct.
And were there any, you stated other individuals at the scene. Were there any other people of interest, such as witnesses at the scene?
Sure. So there were witnesses that were already separated at the scene by the time that we had gotten there. And I had advised Officer Thackerson that we needed to try to get the general circumstances of what happened. So we needed to identify which witnesses might have had a thorough account of the event, so that way we could give the homicide unit a good starting point for their investigation.
So you, I guess initially y'all speak with some of these witnesses.
Officer Thackerson did.
And were you present during some of these individuals speaking with Officer Thackerson?
I was there, yes, sir.
And as you progress through there, are there any other duties associated with this scene?
As far as searching for any additional evidence and things like that, when I arrived, I asked one of the officers that was already there if they had found any shell casings. It was believed that this individual had been shot, and I asked if they had found anything, and I didn't get an answer, and so I wanted to go look for myself to see if I could locate anything. So that's when I went over towards where the complainant was in the parking lot and started looking around to see if I could find a shell casing. And then at that point, one of the CSIs had shown up, Catherine, and when she got there, I guess her eyes are better than mine. She immediately saw a casing that was on the ground that fell into a crack near where the deceased was at.
And subsequently, did you view that shell casing that she had pointed out?
Yes, sir.
And did you do anything? Well, one, did you collect that shell casing?
I did not, no, sir.
Then, well, one, is that one of your duties is to collect evidence at the scene?
No, sir. That would be for the crime scene investigators.
And did you ever, the shell casing, were you able to identify anything on it?
Sure. So I kneeled down next to where the casing was located so I could try to read the head stamp, because I wanted to see if we could identify what caliber of weapon was used. If it was, in this particular circumstance, when I kneeled down, I was able to read that it was a Blazer Luger 9mm round.
And is that I guess, a caliber of a round?
Yes, sir. It's a 9mm round, and Blazer is just the manufacturer.
And at that point, after that, were you tasked with any other duties?
It's just general oversight of what Officer Thackerson was doing, making sure that if he had any questions, I was there to answer him. By the time that he gets to me and his training, he's getting ready to be released on his own, so he knows generally what to do. So I'm more of an oversight, just to try to see what he's doing, if we need to correct anything. He was generally doing everything that he needed to be done. But then while we were waiting for, I don't know if the homicide investigator had already gotten there or not, but then I know the manager of the Chick-fil-A had shown up, and I briefly went to speak with him because he claimed that he had video surveillance that would have captured the parking lot area where the complainant was located.
So did you ever view this video at that time?
Yes, sir. We went inside the location and he was able to access it on his laptop.
And with your own visible eyes, you were able to view the video that he had of the, I guess, of the location or the area.
Yes, sir.
And did y'all see anything of interest on this video?
Yes, sir.
What do you remember seeing on the video?
So the laptop, the screen was fairly small, but from what we could see, you could see a black car enter the parking lot of the Chick-fil-A. It appeared the complainant was on the hood of the car, and then the front passenger exits the vehicle, and he appeared to have a white shirt, and then you see the complainant fall off the hood of the vehicle, and then the black car takes off. The passenger got back in the car, and then the vehicle takes off behind the Chick-fil-A.
So at that time, did y'all at least have a suspect vehicle?
Yes, sir. We knew it was a black 4-door sedan.
And were you aware of what, I guess, not model, but I guess model or brand or?
There was some different
I don't know.
information on make, model, and
I don't know why in the Monica Sementilli trial, we are still waiting over an hour and a half after the lunch break. I do know they have a 30-minute delay, but that shouldn't affect us. We should already been right at an hour and a half, 1 hour, 32 minutes. So they should be hopping on real soon.
so we didn't definitively
We're
know
hanging out.
from what we could see on the camera. Mind you, it was a distorted view, so it wasn't 100% clear on what the make or model of that vehicle was, but we were just trying to get a best guess at that point so we can have officers be on the lookout for that particular vehicle.
And did you write a report for this incident?
No, sir. Officer Thackerson documented everything.
And why would you not?
Right. So as a field training officer, generally the officer that's handling the report, the probationary in this case, he includes that we were with him in this particular incident, but he's doing everything. He's interviewing the witnesses. He's handling the workload, and I'm just observing at this point. If it was earlier in his phase of training, I would have been more hands-on with him, but he's towards the end, getting ready to be released on his own. And so at that point, he's handling most of the responsibilities.
So at the time back when this incident happened, would you have reviewed his report?
Yes, sir. So generally what happens, and in this case, we went down to the homicide offices, and before his report was submitted, we had the homicide investigator, he reviewed it, and I reviewed it as well.
And I'm going to ask you, one, did you review it for before this time of the last, say, few months or so for this trial?
Yes, sir.
And that was Officer Thackerson's report?
Yes, sir.
And do you recall the SAPD number associated with this case?
I don't recall the full case number, no, sir.
I want to show you what's been marked State Exhibit number 18. And if you don't mind, just flip through there and tell me if you're familiar with that.
Yes, sir. This is the report that Officer Thackerson wrote.
Thank you. And on this report, is there an SAPD number associated with the case?
Yes, sir.
And can you please tell me what that SAPD number is?
Yes, sir. It's case number SAPD 17089350.
Thank you. Now, everything that you just testified to, is that something that would have been, well, one, I guess I should ask this first. Did you have a body worn camera on this particular day?
Yes, sir.
And everything that you just testified to, where they would have been depicted on these, on this body worn camera?
Yes, sir.
I want to show you what's marked State Exhibit number 19 and number 20. If you can just look at that, if you need to take them out of the envelope, that's fine. If you can identify that and let me know.
Yes, sir.
And
I just done an ad popped up on my one of my screens. Somebody used male prophylactic tube protection to polish their shoes. To polish your shoes. I'm sorry. I'm getting.
how are you able to identify these discs?
I've put my identifying information on both of these discs.
And have you viewed both of these discs?
Yes, sir.
And do they fairly and accurately represent your body worn camera that day?
Yes, sir.
And the only difference between these discs and the ones that I guess the camera, is that these don't have audio. Is that correct?
Correct. These have been muted.
Okay. And let me ask you this: there's two of them, and I think we discussed this before. Why are there two discs?
At one point, I had gone to use the restroom, and for obvious reasons, I turned the camera off while I was in the bathroom.
And so that's why we have two different.
Yes, sir.
Cameras.
Yes,
Okay.
sir.
And let me ask you this: when you went to the restroom, was it earlier on in the investigation of you at the scene, or was it later on?
It was towards the end when we were inside the Chick-fil-A. The manager was there to review the video.
Okay, thank you. Your Honor, offer state exhibit number 19 and 20. Will tender to defense for any objection?
No objection.
State exhibit 19 and 20 are admitted.
Maybe published? Your Honor?
Yes.
And again, Your Honor, we're going to be doing this from the hard drive of the computer for purposes of time. And if there's no objection, it's the exact copy of what we have on the disk.
That's fine.
You may proceed.
Thank you. For purposes of the records, I am going to start this at the VLC 727.
Zoom. What are we waiting for? Oh,
Going over the case with Officer Thackerson, just trying to make sure that we're getting everything done that's needed to be done.
And the person to the right in this video,
That was one of the witnesses that was identified and that he had spoken with.
fast forward to 1414. 1413. And again, this is another scene in the video. What are y'all doing here?
It's Officer Crystal Estrada, and she's talking with another witness that was there.
Fast forwarded at this point. 2327. And who is that individual in the blue shirt?
Detective Juarez?
And it was at do you know if that was the handling detective of this incident?
Yes, sir.
Thank you. Fast forward to 3355. And again, I guess this is very similar to some of the other scenes, but can you describe to the jury what we're looking at here?
I believe this is as just generally discussing how we're going to handle everything. That's Officer Sandra Chapa. And it's just a general overview of what we're going to do, what we've discovered, and how we're going to go about documenting everything.
Fast forward to 4311.
by the way, guys, I just want to let you know that the news media is no longer permitted to follow Karen Reed as she walks out in or out of court. They were blocked off by the police department. So there will be no more, or at least for now, mobbing of Karen Reed when she comes out of court. So I don't know what triggered that, but you know what? I think that's fair. I think that they needed to stop shoving the microphones in her face. If they want to give a press conference or share information, they'll stop and do so. In my humblest of opinions, which doesn't mean much.
Continue.
Thank you.
Oh no, she's still going. No, she's still going. She said
So
she was
again, when
done.
we left off at lunch, I had just spoken about the elements of murder.
No.
And we talked about malice that can be express or implied. I went through an example of implied, and that in this case, you have a clear intentional killing. So you have evidence of an express malice with intent that preceded the act. Because obviously, when we're talking about a
Mind blown.
conspiracy, we're talking about planning.
No.
I am obviously, as I said earlier, not going to go over every piece of evidence in this case, but I am going to give you examples of things that you can look for. That doesn't mean that when you go back in the jury room that you might not come up with numerous examples of your own from the evidence that I've gone through. But one of the examples, obviously, is the defendant writing Mrs. Baker on that mirror in June of 2016. Also, as I mentioned, and we're going to talk about a little more detail, sending the secret information for the home surveillance cameras to Baker. I talked about that this morning, but what I did not mention, and you can see it here in the slide, not only does the defendant send that email to Robert Baker, but if you recall the testimony of Officer Curtis Davis, she then engages in more consciousness of guilt evidence, because what does she do? She deletes the email that she sends to Baker. So again, they're constantly using various forms of communication that they then destroy. Similar to what we're going to talk about when we get to post-arrest conduct within the jail and the extensive evidence that was brought out by Detective Mitzi Roberts with respect to using various schemes to communicate, again, secretly and destroying that evidence. She also, we know, had to have shared the location of that DVR, and I'm going to get into the evidence that proves that, because as you also heard, it was, I think it was Detective Gable testified that Baker was 5'7". And you saw the height of that cabinet just outside the door leading from the kitchen into the garage on the left. So if you were going in from the garage, it'd be on your right, and that you have this cabinet that's about, I don't know, looks to be a person. You saw a picture of detectives there in the crime scene photos. It's clearly over 6 feet tall. And we'll talk about the description of the DVR box. That's a slimline DVR box, the new DVR. And it's on top of this cabinet. And we'll talk a little bit about how it's, as Detective Gable said, it wasn't in plain view. Someone would have to point it out to you. And there was that moment of testimony where defense counsel, if you remember, Miss Delia Rivera Pacheco, when she came in to testify, who used to be the housekeeper for the Sementillis that came every 2 weeks, defense counsel tried to get her to say, oh, yeah,
Your Honor, that's improper.
It's overruled.
the DVR box. And he showed her a picture of the garage, remember, with the cabinet. And she's looking at the photograph, and she has no idea what he's talking about, because as she testified, she knew that there was one day where when she was in the house, Monica had said something to her about, oh, something's wrong with one of the cameras. I'm going to go in the garage and fix it. But Delia, she has no idea where that box is. And she's at the house cleaning the house every 2 weeks and has no idea that that box was, prior to the murder, kept on top of that tall cabinet in the garage. We'll talk more about that. You also heard again from Detective Mitzi Roberts about the 180 Viber communications with Baker on January 22nd of 2017. And I am going to spend some time on January 22nd because that's a critical date. And you have an exhibit of those communications that was created as a summary from the Viber records that is in evidence for you. Also, we heard that on that same date of January 22nd, while Baker is waiting at the strip mall ahead of time because he's already been told by the defendant 2.5 hours prior to Fabio going out there. He has, after a phone call from the defendant, there are then, when he gets out to that location, as you heard from Ray testify, that there were 69 Viber communications going back and forth between the defendant and Baker just while Baker was waiting in that back parking lot behind the strip mall. You also have the evidence that on, as I said, January 22nd, the defendant sends Fabio out to that strip mall location, the same location that she gave Baker so that he would know where to be ready and waiting. So if you think about the type of place that they were going to pick up from that night. Remember the testimony of Robert Baker where he said, well, I knew the family only used 2 different locations that they ever picked up Chinese from. And I knew one was a Thai place. Well, that's not Chinese, it's Thai. And the other one was Spa, which some people might think it's Chinese, but it's not, it's Vietnamese. So even in his own testimony, he just kept doubling down on his lies and dug himself into not just a hole, but a grave. And so we heard that testimony as well, that he just coincidentally on his own figures out which of those 2 places Fabio's going to be at, and then sits there and waits for Fabio before Fabio even knows himself that he's going to be going out to pick up that night. So either Baker's lying, another series of incredible coincidences, or Baker had some sort of crystal ball because he knows what Fabio is going to be doing before Fabio even knows. So that's the kind of evidence that I'm talking about. And you can see from what I'm describing, you could go on and on and on through the evidence in this case. I'm just pulling out certain pieces that show you intent to kill or express malice aforethought. And there's more. There's also the 95 Viber communications between the defendant and Baker on January 23rd. Now note that it's less communications than the day prior, but what do we know about January 22nd? Well, we know January 22nd was a Sunday, right? And so we also heard the defendant's home that day, and we hear that because Ernie Valorano, if you recall, comes over to the house that day. He and Fabio take a ride in the Porsche. They're trying to get the Porsche fixed. He's leaving to go out of town the next day with his wife, and he doesn't learn about the murder until he lands, I think, in London. And so that day, the defendant has more free time, right? Because Fabio's out of the house and he's in the garage. You heard about this very odd exchange that occurred between Fabio and Monica that Sunday that Ernie was a little bit uncomfortable with. It wasn't the norm. But on the 23rd, which is a Monday, we have less communications. But what do we know about Monday? We know that she actually is with Baker for part of that day, right? She starts calling him at 6:50 in the morning. They start Vibering each other. It's Vibers, we're going to use it as a verb in this case. And she meets him at LA Fitness, right? And they're there for, I think she's there for a little bit under, I think it's like 54 minutes, a little bit under an hour, where she's there with Jessica. When supposedly the defendant works out with Jessica, is on the treadmill, and somehow Jessica missed a portion of that short time period where the defendant went and played racquetball with Baker. This injury occurs and he bleeds all over. We know that's a bunch of hooey. I don't know how to spell that. But then again, she doesn't need to be vibing so often with Baker because, as I said, they're together for a period of time. She goes home And then she starts communicating with Baker again the minute that they're out of eyesight of each other. And then what does she do? She goes and she meets him at Target. Okay. So we know that they're together for a portion of that time. And the only time they're not communicating via Viber is during the time periods when they're together, either at LA Fitness or at the Target lot. And then only one time during that window, suddenly, when we know this murder is going down, where the defendant sends a message, I believe it was at, to Baker, I believe it was at 4:46. And we'll talk about that when we get there. So again, we know that she has this secret meetup in the Target parking lot. Now, why do I call it a secret meetup? Because they were so secretive about it, right? It's, as Deborah Obad would call, shady behavior. The defendant, she contacts Baker. She knows he's in the Target lot. They're vibing. She communicates with him up until the point where she's taking that right off of the, I think it's Winnetka, into the parking lot, or Ventura into the parking lot. And then we see that she goes and does this weird thing where she stops at the area right in front of where the Payless store would be on the left. So when she comes in from Ventura, she takes a right, she then makes a left, she stops in front of the Payless, as I said, and we know Baker's still in the lot. And this winds up being this whole back and forth where we're fighting all about, like, could Baker still be in the lot? Is he not in the lot? Maybe he's not in the lot. How would we know that they met up? The phone records put them there. So I already told you they're both in the lot at the same time. And then Baker gets on the stand and says, yeah, so I met her at the Target. So we know also from looking at the video that when she comes in, Baker has now reparked the rental car, the Versa, at the back of the lot where Detective Roberts told you she went out and she looked at that little alcove area, she saw photos of it, and that there's a way that you can go around into that back shopping center and it brings you out of view of the camera. Why would anybody do that if you're not trying to hide? And if they're not trying to hide, when the defendant comes into the lot and stops, and as Detective Gable and Detective Roberts told you, you can see the figure and you can watch it back as many times as you want. That someone comes in and appears to get into the front passenger seat, the defendant then parks to the back of the lot. And I think it's it's a little over 4 minutes. And they have some communication. And I'm going to tell you what I believe happened during that 4-minute period in a little bit. And then Baker gets out. He goes back to his car. All of a sudden, you see the Versa. He's pulling out of the lot to go pick up Austin, or as he testified to, Austin was hiding in the car. And then the defendant goes and parks her car close to the front of the store and goes into the Target to create her alibi, as we also heard about from Austin. So that's why I refer to it as secretive behavior, consciousness of guilt. And at this point, we know that she has communications with Jessica to don't be late for babysitting. And Jessica's response isn't just, thanks, it's LOL, laugh out loud. Okay. And so she leaves. The defendant checks the IDMS app to make sure she leaves. And then we know that she lies, and we'll talk about this at some point later, numerous times to law enforcement about various things to cover up the murder and what she did on that day. Mm-hmm. She also makes numerous admissions, and as I said, the court is going to instruct you on the difference between confessions and admissions, and statements by a defendant are generally considered admissions. So you're going to hear instruction on that, and if you recall, we had the evidence that there were numerous statements after the arrest that she makes while she's communicating with Baker, both in the back of the black and white vehicle on June 14th, when they are whispering to each other, and we heard about the failed attempt by the detectives to have redundancy in terms of the recording devices in the vehicle. And then again, when she's in the cell with the Perkins agent, and then the spontaneous statements that she makes to explain away the DNA to Detective Gable. So there's all of that. So again, I just wanted to give you an idea of some of the evidence in this case. And obviously there's a lot more than that, and you'll hear more as I go through today, but feel free to make note of whatever rings a bell with you. So now I've talked about murder, and when we talk about murder, murder in general is murder of the second degree, unless there's something in addition that causes the murder to be a first degree murder, elevates it up to the level of first degree murder. And in this case, the judge is going to instruct you on two different theories of first degree murder. One is willful, deliberate, premeditated murder. I think that's the one most people think of when they think of first degree murder. Oh, it's a willful, deliberate, premeditated murder, and I'm going to go through it. The other is murder by means of lying in wait. Now, I'm going to tell you right now, when we look at the things, the type of evidence that support a willful, deliberate, premeditated first-degree murder, they're the same kind of things that we're going to talk about when we get to conspiracy. Because again, when you're talking about a conspiracy to commit a crime, there's planning, there's deliberation and premeditation. So a lot of the evidence that supports both counts 1 and 2 are the same. In addition to that, when I talk about first-degree murder, the second theory of first-degree murder, murder by means of lying in wait, I am also going to get to one of the special circumstances in this case that also is based on similar evidence, and that is the special circumstance allegation of lying in wait. So there's a theory of first-degree murder by means of lying in wait, but there's also a special circumstance if you meet the elements for lying in wait. They are two different paths to first-degree murder. The interesting thing is, let's say half of you think, I think it's a willful, deliberate, premeditated murder. The other half of you say, I don't think so. I think it's a murder by means of lying in wait. The law says you don't have to be unanimous as to which theory of murder you base your decision on, as long as all 12 of you agree that at least one applies. So as long as you all agree it's a first-degree murder, how you get there, what path you choose, doesn't matter. For instance, there's a couple different ways I can come from my house in the morning and get to the Hall of Justice, my office across the street. Either of those ways will get me there. Which one I choose doesn't matter as long as I get there. I hope that makes sense. So you're going to see an instruction the court's going to give you. It's going to read it to you, and it's going to talk about the fact that you do not have to be unanimous as to which theory of first-degree murder applies, as long as you all agree at least one does. I am going to argue to you they both apply. And it is entirely reasonable that the 12 of you, and you never know when you are up, because you've seen what's happened throughout this trial, you might all say, I think it's both. All 12 of you. Doesn't matter. When you get to the verdict forms, you're going to see the forms will be separated. There will be one for guilt and one for not guilty for the two crimes. Crime number 1, murder, which we've talked about. Crime number 2, I'm going to talk about in a minute, conspiracy to commit murder. When we talk about murder, there will be a place on the form that you will have to fill in as to whether or not it's murder in the first degree. It will not necessarily indicate, I haven't looked at the forms yet the way they are, but it will not you might not have to put in, I don't believe you're going to have to put in which theory. It's only going to ask you whether or not you all agree it's murder in the first degree. But the judge is going to instruct you on both of these theories because both of them are supported by the evidence in this case. I hope that makes sense. Okay. All right, so I'm going to talk about each of them. 2 theories of first degree murder. I'm going to, as I said, they both apply here. I'm going to talk about the evidence that supports both of them. First one, willful, deliberate, and premeditated murder. What does that mean? Well, willful, again, just like we were talking about the definition of murder, intentional murder, it's the plain meaning. Deliberate, you're going to hear from the instruction that deliberate means that you got there or was formed based on the careful thought and weighing of the considerations for and against a particular course of action. Now, I want to tell you that when we talk about deliberation, the law does not say that means you have to sit down and take a sheet of paper and make a pros and cons form and make a line down the middle and write all, this is the pros, this is the cons. That's not what we're talking about. But there has to be some consideration, some thought that goes into this. And we know there was an awful lot of thought because I'm going to talk about the fact that they had been planning this for quite some time. And we're going to talk about the July 2016 Las Vegas trip, as well as the spike in communications that Detective Roberts talked about, which is represented in another exhibit between the dates of January 11th and January 13th of 2017, when there are communications going back and forth between the defendant on her mobile phone, on her house phone, to Baker, and then he is communicating with Austin and back and forth. And then in the middle of those 3 days, lo and behold, Austin, with money provided by Baker, purchases his airline ticket to LAX to commit this crime 2 weeks out on the 23rd. So deliberate means, as I said, there has to be some thought that goes into it, because obviously they even thought about and talked about, as we heard from Austin and from Baker, about how to commit the murder. Gun would be too noisy. We talked about stabbing and how that's such a up-close personal way to commit this kind of a crime. Obviously, if you thought of, let's say, strangulation, you're talking about a guy like Fabio, he's a big guy, that's going to be tough, especially given the amount of time that would take. So they're thinking about how to do it. Baker tells you about how he bought various knives, that he brought a particular knife with him to Las Vegas to show it to Austin to gauge his reaction, and all of this. So again, planning, and they're weighing out how they're going to do it. Premeditated means it's considered beforehand. And as you're going to hear from the law that Judge Cohen's going to read to you, no exact measure of time is required. So the law, as I said, doesn't require someone to sit down and write up this pros and cons form or sit for a period of time and think about it. The test under the law is not the duration of time, it's not the amount of time, but it's the extent of the reflection, which in this case is enormous, given the planning behavior. Now, I also want to talk a little bit about motive again here. And as I told you earlier, you're going to have instructions on motive, the existence of motive or the lack thereof. In this case, we have a lot of evidence of motive. As I mentioned earlier, we have this obsessive nature of this particular intense affair. We're not just talking about maybe a fling. We're talking about an intense affair that's continued for over a year, where they have engaged in this alternate lifestyle that we heard about with the swinging, totally different, and obviously appealing to the defendant than being a wife and mother. And we heard about the fact that they were making future plans to be together. We talked about the mirror. We also, if you had any question about whether or not the defendant wrote that in lipstick in November of 2016 on Baker's mirror, we presented to you several jail kites letters that she sent to Baker that were found in Baker's cell, where she signed the jail letters the same way: Mrs. Baker, Mrs. Monica Baker, MB, all of that. So we know, obviously, that that is her writing and her future intent. We heard about Sheila Salehian testifying that the defendant and Baker often talked about making plans to be together in the future because they loved each other and wanted to be together, and that the defendant was unhappy in her marriage. One of the other instructions that you're going to get from Judge Cohen relates not just to admissions, but to what's often referred to as adoptive admissions under the law. And adoptive admissions are when you are in a situation where someone says something, and it would be the type of situation where typically one would respond if it wasn't true, but instead you remain silent. So you were adopting. In other words, the fact that Baker says things to people in front of Monica and she goes along with it, like the time when the defendant and Baker go to Vegas for the first time, and Baker introduces them to Ron and Michelle Ray. And after they have this lunch at, I think it was a P.F. Chang, Ron said to the defendant, "What's your last name?" And he's putting her contact info into his phone. And he said that the defendant and Baker.
Okay, guys, we have had a whole lot of listening going on here, and it's getting a little brain rattled. I'm a little rattled, not rattled, but it's getting very hard to stay focused on her. I popped a question up in Facebook. I popped a question up in the chat, and gotta get back to it because I accidentally closed it out. Let me get back to my chat. I have too many windows open, I'm sorry. Okay, so as a juror, does the length of the prosecutor's closing affect you? For me, yeah. I think that, number one, I am utterly and totally shocked that the judge has not put a limited amount of time, excuse me, on their closings, and again, on their openings, especially in this trial. So I want to hear from you. What are your thoughts? I think it wears me down.
Baker both looked at each other, and Baker responded, "Just put Baker," and the defendant said something about her name being long or complicated or something like that. So that's an example of what we're talking about. We also heard that Ron Ray testified that Baker came to Las Vegas. If you remember, Baker stayed again, although this was never brought out during the 12-13 interviews he had with the defense, but he stayed at various locations, various people's homes after the murder while he was waiting to see if the police would be coming for him. And he had the defendant communicating regularly with LAPD, asking about DNA results and things like that, because obviously Baker knows he's cut himself. And they've discussed this, and she wants to make sure there's no evidence that can point to Baker, because if Baker gets arrested, that just ruins their entire plan for this entire crime. So if you recall, when Baker comes to Las Vegas He initially comes out at the beginning of February when the defendant goes to Toronto for the funeral services the first week in February of 2017. Baker goes to Al Birdsong's in Las Vegas, and he stays there for a period of time before he comes back. And that's after he's already been at various other locations. He comes back, and sometime around Valentine's Day, remember Roger Brown said he came over and said, "Oh, I'm gonna stay with you and make sure you're okay." But obviously Baker's doing it so that Baker's okay. So Ron says that Baker says that he and Monica are going to be living together soon, and that they're already making plans to move in together, and that was already in progress. And that's at the beginning of February. Then both Baker and the defendant come back to Vegas, as we heard, in March of 2017, when they meet up there, and they, for the first time with the Rays, and the defendant reiterates exactly what Baker had said from the month before, that they're planning on moving in together soon, that she's going to sell her big expensive house in the Los Angeles area, and that she's going to buy a place in Las Vegas for Rob, and she's going to come and go, and they're going to travel to Italy and all these other things. So we know that they're already talking about their future plans, and Fabio's body is barely cold. And the defendant is acting as if she has a lot of money, and she's picking up bills and things like that for everybody. And we'll talk about that a little bit more in a little bit, but when we get to the special circumstance. But remember again, we're talking about the defendant, who, other than the money that she's taking in from this app that Fabio created, Scissor Boy, that she's taking in as her business and writing off, she doesn't really have another source of income other than Fabio. And then Baker, when he started telling you about how he was living off all the money that he had from his porno days or his management days, when I started showing him the bank accounts, he was very shocked to see his balances. So again, there's obviously been a communication between the defendant and Baker regarding the money that's coming, because that's the money that's going to fund their lifestyle. Okay. Now, as I mentioned, we talked about the two ways to get to first-degree murder, the first being the willful, deliberate, premeditated avenue, and I just explained that. And the second is by means of lying in wait. So what are the elements of first-degree murder by means of lying in wait? And what you're going to see in a couple minutes is that the instructions and the evidence are going to be very similar to the special circumstance allegation. So first-degree murder by means of lying in wait is generally characterized by a surprise attack, one would say, on an unsuspecting victim from a position of advantage. And what it requires is there has to be a period of watching and waiting for an opportune time to act. So let's start with that element, watching and waiting. So number one, we have on the 23rd, Baker and Austin are waiting around for Monica to give them the signal that Fabio is alone. Okay. We also have more watching and waiting. If you remember Austin testifying, and Baker actually as well, that when they got to the house, Austin said, per Baker, Monica said he's out on the patio, right? And so they're sneaking through the house. Whether you believe they came in through the front door, whether that she left unlocked, or whether she left the slider unlocked, doesn't really matter. They are sneaking through the house. Remember, Baker kept going over how he was so careful about entering because he wanted to make sure, bless you, that he didn't tip anybody off. I also want to point out something else that I don't believe is in my outline, but I remember thinking about it during the trial. Remember that when the defendant comes back from LA Fitness on the 23rd with Jessica, Fabio and Jessica are in the kitchen, and she is doing something in the living room. And she also mentions this later in the interviews with law enforcement. I think she might have said she was folding laundry or something of that nature and watching television and on her phone. And the television is on. Now, Fabio is working from home that day. He's not sitting in the house. He's in the kitchen. He's out on the patio. He's making business calls. He's back in the kitchen. He's on his laptop. And he's going back and forth. And when the defendant leaves to go meet Baker at the Target parking lot, which is only 3 minutes, a little over 3 minutes away, she leaves the TV on. Why does she leave the TV on? There's no one sitting in the living room. Delia, Miss Pacheco, she's there. She's cleaning. She's going to get her stuff done. Her family's going to come pick her up. She's leaving. Jessica's leaving to babysit. The only reason the TV is left on is to cover any sound that might be made by Baker and Austin coming into the house, because Baker and Austin are going to have to come into the home very carefully so as not to tip off Fabio. Because even though they've been told he's sitting on the patio, you heard about the fact that they parked the Versa down a ways from the house and then jog up to the house. And so there's no way of knowing that Fabio isn't going to go into the kitchen to get something to drink or go in and open up his laptop. So there is, again, another period of watching and waiting as Baker and Austin come into the home to scout out exactly where Fabio is. And of course, he's still out in his home office on the back patio. And you remember that whole portion of testimony that went on indeterminately, where Baker was talking about how he was waiting to see if Fabio could come in, and he didn't. And so that's when I brought up to him, because of course they never asked him, why is the power turned off? Remember when Detective Verna talked about going out to the crime scene and several of the levers in the power box just again next to that tall cabinet right outside the kitchen door in the garage? Why are several levers of the power turned off such that you had to pull on the emergency release for the garage door? Remember, we got DNA, touch DNA from Baker's hands off that emergency release that was hanging down inside the garage. Why did you turn off the power? Because then you'd have to pull on the emergency release to get the Porsche out. And he said, oh, I did that because I was trying to lure him inside. Remember that? I don't know if he turned off the power because he was going to yank the DVR out of the wall up there on top of the cabinet. There's some things in this case we're never going to know, right?
That's true.
We get some more details filled in by Austin, but there's some details in this case we're just never going to know. Because, again, how do you take anything from Baker's mouth to heart without having it corroborated by independent evidence? You can't. So, again, there's this period of watching and waiting, even once they get to the house, for the opportune time for he and Austin to rush out and subdue Fabio, who's much bigger and weighs much more than Baker. So that's going to take two. Then the second element of murder by means of lying in wait, there has to be concealment. Now, when we talk about concealment, concealment by ambush or secret design, the instruction says it's not necessarily concealment of your person, but concealment of your purpose or your secret design. So again, if you think about the defendant, where she's watching and waiting for the opportune time, and we heard that things went sideways the day before because Austin got cold feet at the strip mall. Now they're on to the 23rd trying to find an opportune time, and they have to sort of fit this in on that day. We were never going to know why Fabio wasn't at his colonoscopy appointment, what caused him to cancel, or if that wasn't really true, but somehow he is persuaded by the defendant, obviously, to stay home. And so there is concealment by ambush or secret design in order to take him by surprise. So again, if you think about a surprise attack where you're concealing your true purpose, that's what the law speaks to, and you're going to hear instructions on this as the second theory of first-degree murder. So again, we know the defendant is the one that has to set this up. There's no way Baker is going to be doing that. He needs inside information in order to get this job done. And so, of course, Fabio has no clue, no idea of what the defendant has been plotting with Baker, and that this is going to wind up being his last day on earth. And again, if you're talking about a situation where someone has a brief affair or a fling and cheats on their spouse and then realizes, I'm not going to destroy my whole life for this, that is not the type of affair that we have in this case. We have an obsessive love affair where this defendant is willing to blow up everything to be with Robert Baker. And so in order to get there, she has to lie in wait for the opportune time, just like we talked about. This would also apply to what they did on the day prior, on the 22nd, where she has to come up with an opportune time to send Fabio somewhere because they are going to ambush him and kill him in this shopping center, in this strip mall when he goes.
Okay, I gotta stop, because this is something I really struggled with. How many of us believe that she actually laid in wait, sent him off to go get food, groceries, dinner, knowing that the boyfriend and Baker and Austin, were going to ambush him? And when that didn't happen, things had to change. Do you believe that the state showed beyond reasonable doubt with that scenario that she knew that they were going to unalive him, Fabio? Do you believe, with what she's talking about right now, that she purposefully sent him out of the house because she knew, knew that Baker and Austin were lying in wait for Fabio? Now, guys, this has been a long trial, and I will be honest, it has been a little bit of a struggle for me, because it's going on and on and on and on and on. And I'm wanting y'all to just listening to closing arguments. And then we'll talk about more during verdict deliberation about all that they said. But this, I had to stop, because for me, as a juror, I'm going to look at this exact point, because she's saying she didn't know anything, but did she?
Goes out to pick up food the night before on Sunday night. So again, what the law says, and what Judge Cohen's going to read to you, is that when it comes to lying in wait as a means of first-degree murder, just as we talked about with respect to premeditation, It's not about an exact period of time or the duration of time. And that's what the law says again with respect to lying in wait. There's no time requirement, provided that the duration of whatever time is spent is a state of mind equivalent. And look at this. We're going back to what I just talked about. Like I said, there's a lot of overlap.
I wish I
To
could see that.
premeditation or deliberation. Okay?
A little part of
So we're
it there.
talking about the fact that there is planning, that there is a thought process that goes on, and that this is considered obviously before they kill Fabio Sementilli. Very similar. So again, with respect to lying in wait, it's first degree murder, concealment of purpose, and a surprise attack. That is the hallmark of a lying in wait murder. Also, again, just as I mentioned with respect to the money, the financial gain, keep in mind, Baker, as I said, not only did he plead guilty to the murder, to the conspiracy to commit murder, but he also pled guilty to the special circumstances of lying in wait, and he also pled guilty to the financial gain special circumstance. So 2 special circumstances where he is lying in wait that he admits to, as well as committing the murder for financial gain. So again, what does that mean? That Baker has now admitted to committing this murder for financial gain. I'm 100% certain that Baker is not one of the beneficiaries on any of Fabio Sementilli's life insurance policies or his beneficiary to any of his estate. So how is Baker going to get his hands on money? How does he derive a financial gain? The only way he derives a financial gain is through the defendant, because that tells you, again, they discuss this because he's expecting the 2 of them are going to be spending their future together and that they're going to live off of Fabio's money. Okay? So, just as I talked about there being 2 different ways to get to first degree murder, 2 different ways that you could get malice aforethought. In this case, once you determine that you are talking about a first degree murder, whether you get there by a lying in wait theory of first degree murder, or whether you get there by a willful, deliberate, premeditated theory of first degree murder. Once you make a decision that this is a first degree murder, only then do you move on to the special circumstances. If you find her not guilty, you don't got to worry about any of this stuff. Okay? But once you make a finding on the verdict forms that this is a first degree murder, then you're going to be asked to determine not guilty or not guilty, as you do with the charges of murder and conspiracy, but true or not true as to the 2 special circumstance allegations in this case. There are 2, as I just mentioned, one being, again, murder by means of lying in wait. And I'm going to go through the law and the special circumstance, and it's going to sound very similar to what we talked about in terms of the elements with respect to first degree murder. And then murder for financial gain. Again, both special circumstances that Baker pled to, because we didn't give him anything. So if we're not giving him anything, he either pleads to the sheet or he goes to trial. And of course, as you heard in this case, why does he do that? And you heard about all of these complaints about, oh, his attorney didn't tell him this, and the judge didn't tell him that, and he didn't know what the evidence was, and so on and so forth. Keep in mind, the one thing he does say he knew about was the DNA evidence. And you hear he and the defendant talking to each other about the DNA evidence in the lockup overhears. And he talks about just a few drops of DNA. What does that mean? Well, it depends. Depends if you have a DNA expert on the stand who's worth their salt, right? Another thing I just want to throw in here, when we talk about expert witnesses, because there were numerous experts that testified, and it's not, again, not in my closing, but every time I walk away from the podium, I think of something else. When you are talking about the evaluation of an expert, or whether you're talking about the opinions of an expert or even a non-expert, the most important thing to keep in mind is when someone expresses an opinion, again, I'll give you a perfect example. You want to look at the foundation, the basis of the opinion, right? Because if the basis of the opinion is solid, then you can build on it, right? Then you can say, well, if you have this, you follow the protocols. If you're talking about, let's say, a DNA expert, you're accredited, it makes you do things so that we can tell that the results you obtain are reliable and repeatable. That's the whole point of science, right? It has to be repeatable. It has to be reliable. It has to be something where someone else could come in, do the same work you did, and get the same result. The basis of the opinion has to be solid. Garbage in, garbage out, right? So let's, I'll segue over to her for a brief moment. Deborah Obad, right? Nancy Drew here. She's calling LAPD and she's telling them what to do, right? Like I said, detectives, they'll sit there all day long. They'll take in your information, but they're going to assess and they're going to do their own analysis and they're going to take in, but they're not going to give it out, right? They're going to play it close to the vest. They're not going to compromise anything. You have somebody like Deborah Obad who calls up and says, I think it's this person. I think it's that person. What is the basis of your opinion? Why do you think that? He's a short, boring Jew. Okay. So again, what's the basis of your opinion? I think it's this guy because there's DNA connecting him to the crime. Okay. Very different, right? It has to be solid. And again, whether we're talking about expert opinion or we're talking about what's referred to as lay opinion, someone who's not an expert, but they're going to say, I believe this is what it is based on X, Y, and Z. You have to have a foundation that is reliable in order to base your opinion. So also keep that in mind when you're looking at the evidence in this case. So let's talk about the two special circumstance allegations. As I told you, the two of them in this case is you have to have an intentional murder that's committed for financial gain. Well, we already talked about the fact that this is an intentional murder. I mean, this was a murder that was planned to the hilt, right? I mean, there is mountains and mountains of planning behavior that you heard about for weeks and weeks. So there's a plan to receive Fabio's money, whether it be from life insurance, whether it be from stock options, whether it be you heard about pension plans, savings plans, benefits, all of this money that Fabio had accrued over the years in his career. Intentional murder for financial gain. The second one, intentional murder by means of lying in wait. All right, let's break them down. The lying in wait, special circumstance. First of all, you have to have an intentional murder. We've already talked about that. We know it's an express malice, intentional murder. It was very premeditated and deliberate and planned out. And it has to be by means of lying in wait. So here the law requires that there be a substantial period of waiting and watching or watching and waiting for the opportune time to act. We talked about the period of watching and waiting when it came to the first degree theory of murder. Here, for the lying in wait special circumstance, the law requires that the period has to be substantial. And it talks about that the state of mind has to be equivalent, again, to premeditation and deliberation. Okay, which we've talked about. And then, once again, there is concealment of purpose, as I mentioned before, when we talked about the lying in wait theory of first-degree murder. Concealment by ambush or secret design, because again, Fabio is going to be ambushed, whether they planned it the night before at the strip mall while he's picking up food, or ambushed in his backyard by a secret design in order to take him by surprise. Now, we know, based on just even the way the crime scene looks, that this was something Fabio never saw coming. Whether you look at the despicable videotape of her dancing and singing with Fabio in the weeks before the murder, or the crime scene itself, he was being set up, right? What do we know? What does the evidence show us that bears this out? We know from listening to the testimony of the chief medical examiner in this case that Fabio did not sustain any defensive wounds. Defensive wounds meaning to the hands, to the forearm area, because somebody who is trying to ward off an attack, human instinct is the first thing you do is you're going to put your hands up, right?
That is true, but if somebody comes from behind and grabs your arms, ties your arms down while somebody else is doing the unaliving, and they get a stab or two in, you may not have defensive wounds. Just saying.
Right? So classic defensive wounds that you would expect. He doesn't even have the time to do that. He doesn't even have the opportunity. That's how fast this goes down. He is sitting outside. He's got his side to the door. He's facing towards his television over in the corner against that kitchen area, and they rush him, right? And Austin talks about how one of them he put his hands over Fabio's eyes so Fabio couldn't see where the knife attack is coming from. They put the hand over the mouth so he can't scream, so that the neighbors aren't alerted, and they stab him numerous times, and he goes down, right? He stands up at some point, obviously, because he's lying over the chair, right? He's got the handset for the home phone sitting on the chair that we see. His left wrist is hanging down with his Rolex watch, but he's got no defensive wounds. He had no time to defend himself. He would never have thought in a million years, he would never have fathomed that his wife of almost 20 years would conspire with her lover to murder him. So again, take a look at the crime scene photos for that purpose in this case. I am not going to show you any autopsy photos. We went through that so that you could get an idea of the injuries that Fabio sustained in this case. Feel free to look at them again if you need to. In the back, you'll have all of the evidence available to you. Again, one more thing I do want to say about the defense videos of the defendant and Fabio dancing and singing. Those videos may very well be proof of how much Fabio adored his wife. And that was testified to by several witnesses. But all it shows on behalf of the defendant is how well she was able to fool her own family, including her daughters and her husband, into believing that she was a loving, devoted wife, which she clearly was not. Another piece of evidence that backfired. Now, the financial gain special circumstance. You were told by the defense that there was no financial motive for the defendant to kill her husband. Now, in this case, there are at least two different motives that I'm going to talk about today. One, I've already spoken about, and that was the defendant's plan to be with her lover, Robert Baker. The second being the money. We heard a lot about the money. And by obtaining Fabio's money, that would give them the basis to be able to marry, if they so chose, to travel, to fund their lifestyle, to buy houses, property, whatever else they talked about. So I'm going to spend the next several minutes talking about money and the financial gain special circumstance. Some of it is very dry. You heard various experts testify in this case, but I'm going to bring it down to a very simple concept. There's no life insurance without death. This was an intentional murder. It was carried out for financial gain. Baker admitted to that. The defendant believed that her husband's death would result in this financial gain. Now, when Judge Cohen reads you this instruction, probably at some point tomorrow, if not Monday.
Oh God, please, not Monday.
These are the elements of the financial gain special circumstance. Part of that instruction also reads that the defendant need not actually receive any financial benefit. It's the expectation of the gain. In other words, the motive for the murder, that is the key. In this case, we know she did get a significant amount of money. The thing that was held back, if you recall, was the life insurance. Remember that. There was other monies that were paid out, and I'm going to talk about some of that. So again, whether or not the defendant actually received the life insurance is irrelevant. It's the expectation by committing the murder that she's going to be able to receive some financial gain. And it doesn't say, notice, oh, it has to be more than X amount. It could be $1, right? We know in this case, it was substantial. Also, this instruction tells you that financial gain does not need to be the primary or the sole motive for the murder. So as I said, the fact that this murder is committed not just for money, but also so that she can live her future with her true soulmate, Robert Baker, that is okay. It doesn't have to be your primary or your sole motive. So what type of evidence do we have in this case that proves, again, I always like to come back and tie it back to the evidence. What evidence do we have? Well, first of all, the very night of Fabio's murder, the defendant begins talking about and inquiring about the money. Remember the testimony from Fabio's boss, Sal Mocheri, the CEO of Wella at the time. Remember that after he gets word that Fabio has been killed, he takes some of his top execs with him. Takes Henry Meyer, head of HR, He takes Dave Diaz, who was previously Fab's boss up in Canada when he was working for P&G. And remember, Dave Diaz and Ruben Carranza, we'll talk about that. Before Fabio even accepts this position with Wella that then it gets bought out a couple of times, Dave Diaz and Ruben Carranza take not just Fabio, but the defendant out with Fabio.
I don't think so. They've been live on Fridays. And so, I mean, they've been in court on Fridays. I cannot believe if she goes longer than today, I'm going to be pissed. By now, I'd be doing my list and food shopping list done with my, it's hard. It's hard to stay focused on something like this. Case has been very hard to stay focused. Number one. I think she's planning on going into tomorrow like she did for her opening statement. And then the defense will go in. The defense won't be today. It'll be tomorrow. This has been brutal. I mean, this is why this case is going on so freaking long. Why? Why do we have to have a trial like this? I mean, this trial should have been over weeks ago. And this judge, I like his personality. I like the way he interacts with the lawyers. The only complaint I have with this judge is he does not put time limits on the opening and the closings. Never should have taken this long. And I don't have ADHD, but I feel ADHD because it is so hard to stay focused on this case.
Fabio for dinner. And they talk about financial benefits and why this is a good move for somebody who is running hair salons in Canada and is a top hair platform artist.
They had over 200 witnesses on their list.
With his sister Morella. And so remember, Sal says he goes out to the scene, he brings his people with him. They get eyes on Monica. They go back to the office, and these people are devastated, right? And they rally and they get together and they say, what can we do to support Monica and the kids for Fabio? What are we going to do, right? And what does he tell you? He tells you that he then starts receiving text messages from Deborah Obad. And I think at this point, I probably don't have to explain to you why you could picture that happening in your own head, why someone would be that presumptuous, right? And she's texting, by the way, just so that you know, she has somehow Sal Mocheri's cell phone number. He's the CEO, right, of Wella. And she's texting him, can you guys figure out his life insurance? This is within hours of Fabio being stabbed to death. Monica is asking. She said it all changed with Cody. It's different. She means Cody, C-O-T-Y. And although she thinks she's that smart, she's not that smart. And I'll tell you why in a minute. And so what does Sal tell you? And I know it's been a while since you remember Sal testifying, but Sal says she was so presumptuous. She was so forward, obnoxious would be my word, that he shows these messages. Remember, he goes and shows them to Henry. He's like, what is up with this? And he responds very professionally. He says, best scenario is for Henry, because Henry we know is the HR director for Wella, and someone from his family, meaning not you, we're not going to talk to you, kind of like law enforcement, about Fab's money, someone from his family to have a discussion. Like, not your place, lady. Can you have someone call Henry tomorrow afternoon? Sure. Who? Monica cannot talk. Yeah, well, you heard what happened from there. So remember that these text messages from Obad continue onto Sal's phone into the early morning hours of the next day saying the defendant wants to know about the life insurance. And Sal testified that he thought it was bizarre at the time because, as he said, and as you saw from him and various other individuals that came in and testified from the company, he thought it was bizarre because it wouldn't be anybody's main concern at that point. We're talking about somebody who was just brutally murdered. And he thought it was highly inappropriate. And so Sal then tells you that he was aware after the fact of that night that Henry was putting together a set of documents for the defendant with all the contact information in order to be able to reach out to all of the individuals, because remember, before Fabio comes to the US, he's working for, he's a platform artist, independent contractor along with Morella for P&G and Wella up in Canada. And so he had benefits even from the company in Canada. And so all of this is being put together with the appropriate individuals of who to contact to access all of the information. And what Sal testified is over the course of the next several weeks and months that he was made aware as the CEO that the defendant was harassing and pressuring Henry and his staff about the life insurance payout. And you heard from every single person that testified that these individuals at Wella did everything and anything that they could to try and make the defendant happy, and that they sent her claim to Tracy Rakovich, who was the HR benefits person for Cody, for the entire company out of New York, the New York headquarters. And that claim was submitted to MetLife, who the company contracted with in order to provide benefits and life insurance to their employees. And yet, even though it was out of Wella's hands, the defendant continued to harass Henry at that point, despite it being explained to her numerous times that the claim was now within the hands of the insurance company that doesn't work for Wella. They're a separate company. Then you heard from Sam Pulera. If you remember Sam, he's somebody who knew Fabio. He was a hairdresser himself. He worked at salons like Fabio did. He was also working for P&G and Wella, and Fab brought him into the company when he came. Like I said earlier today, Fab was one of those guys who wanted to take everybody up with him on his way up, and gave him a position. And Sam looked up to Fabio. He looked up to Monica. And despite the fact that the defense tried to spin the story that the defendant was unaware, even the divorce lawyer that was name dropping all of his clients made some comment about her being unaware of what the policies and benefits were. We know that is a completely false story based on the evidence. Again, always coming back to the evidence, not speculation, evidence. There has to be a basis for opinion. So what we learned from Sam Pulera was that the defendant, as well as Fabio, had told him numerous times, including when they had a going away party. Remember that for Fabio before he left Toronto to move to the United States? There was a going away party up in Canada, and Sam was talking to Fabio and to Monica about the benefits and things like that Fab was going to get by coming to this company and leaving the country. And in front of the defendant, Fabio told him he gives all of the financials, all the financial documents go to Monica for her to handle. And they talked about things like life insurance and profit sharing and stock. And the defendant boasted about how she handles all of the family finances. Now, we also heard that same story from Morella.
I would like to do that. We are almost done for the day. Let's see. Yeah, we're almost done for the day. I am going to take a quick break, grab my dinner, and then we'll come back and do the my brain Linda Sturmer trial, because I have some of you who are really interested in the Linda Sturmer trial. And I'm getting ready to plan. I'm going to also be planning my members only live. We haven't done them in a while because I didn't have enough members that felt that they could watch them and be a part. Well, now we do. And the members only live will be starting this Sunday. Will be the members only live. It is the first Sunday of the month. So we'll be doing a members only live, and I'm planning that right now. So if you are a member, put it on your calendar for the members only live. I will get it up there and posted. And anyway, let's just I hate to say get through this, but we're going to get through this. We're going to get through it. We will.
Recall that at that lunch, the defendant told Sam and his wife, Fabio's worth more dead to me than alive. All right, let's move on. As I mentioned earlier, we heard from Dave Diaz. He was the boss, Fabio's boss, when Fab worked for Wella as a platform artist. He and Ruben Carranza, who was the CEO before Sal Mocheri, took the defendant Fabio out to dinner in 2010 in Toronto in order to discuss the opportunity, as he put it, to grow wealth by coming to work as an executive for Wella. And Dave said that at that dinner, his job was to get Monica on board. And so he told her about the benefits the company offered, such as things like life insurance and stock options and things of that nature. He also testified that after the murder, he went to see the defendant over at the residence, the Sementilli residence on Queen Victoria, a couple of times. And he described some of this bizarre demeanor where she acted distraught, but yet she was shedding no tears. And she kept telling him and everybody else that she didn't know how they would survive financially. And remember this, and this is the same story she gave to law enforcement initially on January 23rd, after the murder, which quickly changed. She knew nothing about Fabio's benefits. And we know that was 100% a lie. How do we know that other than through numerous witnesses? We know because we presented exhibits where Fabio sent emails, just as he and the defendant talked about with Sam Pulera and others, emails of his benefit selections, including the percentages. And you heard from Alicia Truesdale, Fabio's executive assistant, about the fact that in 2016, Fabio was increasing the amount that he was taking out of his paycheck and putting into these policies because she knew that he wanted to make sure that his family was secure. And so, again, although she's telling people like Dave Diaz and Henry and law enforcement on the night of January 23rd and in the days thereafter that she knew nothing about Fab's benefits, we know that all of that was false. And we also heard that Dave Diaz was present at the house because he went there a couple of times on the day that he and Henry went back to the house and sat on the couch with the defendant. And Henry gave the defendant the set of documents that we've also marked as exhibits and put in, listing all of Fabio's assets, including the stock options, the savings plans, the retirement programs, the life insurance, both from the United States and from Canada. We heard from Henry. You remember, he's the gentleman who was the senior HR director for Cody North America. And you heard that he tried his best to help the defendant by preparing all of these documents for her with the contact information for the various assets. And he also said that he did a significant amount of research so that he could determine not only what Fabio had in the United States, but also what Fabio had before Wella was bought out by Cody when they were under the P&G umbrella in Canada. And so he actually sat down and went over all of these assets with the defendant in the days following the murder. And if you recall, again, these are some of the exhibits or portions of the exhibits. You can look under exhibits 102 and 103, but there's numerous financial documents that we put in to support it. And if you recall, he talked about Fabio's life insurance. He talked about Fabio's 401k. And I noticed that on the document that he prepared, he put in what he estimated the value at. And as you heard later, once we subpoenaed documentation from Mr. Rubin, the estate co-administrator, that he complained about because it took so much time to put the documents together. Those documents then were provided to Marie Ebersbacher, who's a forensic accountant in the family law arena, who divorce lawyers hire for these high-priced divorces. This wasn't one of those. This was not as complicated as the cases that she handles. As she talked about, the estate was relatively small. However, what we learned was that Henry underestimated the value of some of these assets, such as the 401k. The documentation shows it was approximately $30,000. The profit share and savings plans, which were $43,600. Fabio also had an international stock ownership plan through P&G through Canada. They referred to that as an ISOP. There was a 401k savings plan through Cody. He had restricted stock units, and Henry put together documentation on all of these assets, and he talked about how he spent all this time researching so that he could get everything together for her in one place. So when he met with her 3 days later on January 26th, he was able to provide that to her. And again, during that meeting where Dave Diaz was present, she claimed she didn't know about any of Fabio's benefits, and also told him that Fabio handled all the family finances, which we know is the exact opposite of what she told Sam Pulera and others. And she even went so far as to tell Henry that Fabio kept all of his benefits from her, which was also a lie given the emails that we found in her email accounts that we subpoenaed from his 2017 benefits enrollment, both in May and in October of 2016. And those are in the neighborhood of exhibits 96 and 97. Henry also provided contact information, as I said, regarding the ISOP. That was a Canadian pension that was worth approximately $61,000. He called as well to P&G in Cincinnati, as well as Canada. And he said that he did that for Monica to notify them about Fabio's death so they could start the process of the payout to the defendant for these various assets.
Let's take our afternoon recess for 15 minutes. The admonition of 5. See back here.
15 minutes? My God, y'all. This is insane. Okay, well, guess what? We have some news that's breaking. We got breaking news, but I got to give a shout out. As a gavel drops, I am very humbled by your support and your kindness. We have received some documents of some cases that have had some interesting changes. And if you want to be able to read these documents yourself, and or you love to do document research and would like to be a mod over at As a Gavel Drops, go to Discord, go to As a Gavel Drops, join, validate your account, and you too can have access to all this fabulous, fabulous documents. Okay. First and foremost, I got to get my thing straightened up. Let me embiggen me because I'm going to need to. We're not on that. Let me bring this in front of me. Okay. So we have the, I guess it's Jose Ibarra trial. He was convicted to murder 1, life without parole, felony murder vacated, kidnapping with bodily injury, life without possibility of parole, consecutive to count 1, aggravated assault with intent to EPAR, 20 years, consecutive to count 5, aggressive battery merged with count 1, obstructing or hindering person making an emergency telephone call, 12 months consecutive, tampering with evidence, 12 months consecutive, peeping Tom, 5 years consecutive to count 6, misdemeanor to come after felonies. He had 30 days. Okay. Well, they have filed. Let me pull it up. I've got to get things in different places. Let me see. Let me get to it. Sorry, I had it drop. Let me get over here. They have filed a motion. I'm trying to find it. It just disappeared. Why did everything just blank out in my Discord? It was my Discord, not anybody else's. It's just mine. Let me see. Where is it, Toxic? I know you gave it to me, girl. And I don't know why all this stuff is happening now all of a sudden. But anyway, they have some motions that's being filed. I'm getting down to it. Give me a minute. There it is. Oh, I lost it. Ruling hearing conference. Okay. They have filed a motion for a new trial. Okay. And it's a lack of evidence is the cause. And the trial date is 6/6/25 at 10 a.m. I hope to be able to cover that for y'all. I have started. I have put it on the calendar. So we will be definitely looking into that. But they're saying not enough evidence. Then we have, get over here, Julie Solpizio. I'm really bad with last names like this, y'all. She was been found incompetent to withstand trial in the lead shooting of multiple Lake County deputies. The chief assistant state attorney said the trial will be moved forward since she is treated for a host of mental issues. On Friday, WESH2 reported that she has been deemed incompetent by the Fifth Circuit Judicial Court said Monday that she's been sent to state hospital to be treated before returning their jurisdiction and so the case can resume. Okay, let's talk about that. Let's talk about that, y'all. Yes, definitely. Go there for all your court documents. So, what happens when somebody has been basically found incompetent to withstand trial? What happens? Well, they will be sent to the state hospital. They will be put on medications and they will do psychological care in hopes of getting them competent to withstand trial. But part of the problem with that issue is this. How do I know? I used to work at the state hospital for the forensically insane and incompetent to withstand trial. The same hospital that Andrea Yates is in. So I do have a lot of experience in this area. Here's where we have a problem. there are people who will go there and we go, oh, good. So in about a year or so, they'll come back and do trial. I wouldn't count on it. Here's the problem. The medications that they're on when they go in, get in the state gets them stabilized. They get them competent to withstand trial. So after they get to that point and they're ready for the hearing, days before, 3 to 4 days before, sometimes a little bit more, depending on how far they have to go, they will transport these people who have been accused of a crime and were found incompetent to withstand trial to the facility, the jail cell, the holding facility, whatever. And a lot of times they don't get their medications when they get there, because it can take time for them to set up the medications. They can't pre-set it up. They have to get the alleged criminal into the jail. Then they go through their check-in and view. They see their doctors, their nurses. They go through the whole rigmarole, and it can take days, and they're not getting their psych meds. Well, when you cold turkey cut psych meds, you go into psychosis, which means now you are not competent to withstand trial. So they send them back to the state. The state will get them balanced and get them back where they need to be and get them competent. And then once again, they get sent to a jail. They're not getting their treatment. They're not getting their meds. They're not getting the psychological care to keep them on that even kill. And going from a state hospital to a jail facility is a shock. It's very much a different environment. And once again, what happens? Yeah, they become incompetent really quick. Okay, civil trial against start the new. So we really have an interesting case there. I'd like to kind of talk to you guys for a minute. I owe you an apology. First of all, it's been a hard 6 months since my sister died. Well, not 6 months. Well, it hasn't been November, December, January, February, March. 4 months since my sister died, and it has been a very difficult road. And I have struggled with distractions. And then, of course, Sensei passing away Saturday has just exasperated that. Today, I have been very distracted. I've had phone calls I've had to deal with in concerning the remains of my dog, and phone calls concerning the company where I got her from. It's not a home trained service dog. She came from an accredited service dog organization. So yes, today has been a very distracting day. I apologize for that. But that said, let's move on and move forward and upward. And I wanted to let you guys know that I have a bunch of changes happening. And I have been working behind the scenes to try to get some things done. And one of the things is I am relaunching my members only live on the first Sunday of the month. So that will be this Sunday. That is where we can cut loose and say whatever we want to say, because it's members only. We don't have to worry about monetization. We don't have to worry about who's listening because it's members only. It's a private live. And we can really let our hair down. So that's what we're going to do Sunday night on my Sunday Night Live, members only live. And then I'm going to start. I kind of wanted to wait and implement a lot of the changes with the Karen Reed trial. As some of you know, I started doing this on a fluke. It was not a planned choice for me. I was just going to come on and do, hello, June. Hey, Haley Mouse. Thank you for that. I was just going to come in and talk about jail widow and talk about losing my husband to prison and all of that. And then it just exploded into something totally I was not prepared for and was not ready for. But it's been a wonderful ride. And I'm so blessed to have all of you. With that, there are growing pains and frustrations, learning curves. And I've kind of been stagnant for a while, I'd say since Tracy's passing. And I recently, the last couple of weeks, have been kind of taking kind of self notes and was going to use the Karen Reed trial as sort of a relaunch and kind of make some changes that I know needed to happen. So, how's that going to look for us? Well, it's going to be great. We're going to have a lot of different things going on. I'm going to start doing recaps at the end of every day. It's going to be easy with her because I'm taking a lot of notes. And I am going to be doing a weekend review on Friday nights, or after the Friday, whatever's on Friday. If we don't have a trial, I'll still do a weekend review. One of the other things is, instead of doing 7, 8, and 10 straight hour-long lives, when court takes a lunch break, we will be taking lunch breaks. I am one who needs to munch every day. I am not one who can eat a big meal in the morning and then not eat. I have to physiologically kind of munch. So we're going to take a break and oh, I'm sorry. Something caught my eye. We will be taking lunch breaks, and that way everybody can get a little break, get their lunch, be able to get fed. I will get fed myself. Now, understand, there may be a little snacking. I can't help it. It's my physiological makeup. Okay. But I'm looking forward to some of the changes. Yes, I feel like we've had some trials that have been disappointing, or like Sementilli, long. I'm sure Reed is underway. I agree. The problem is, it is a crapshoot when you pick a trial. You don't know how it's going to go. It could be very interesting to you and a couple of people, and then it fizzes out. We've had that happen. This trial, we've gotten too invested. It's like I'm too far into it to not see it to the end. So I know this has been a little frustrating to a lot of you. My apologies. I don't have, and that's the other thing. I have wonderful mods, and a couple of them have been honest with me, and it's not fun, but I need to keep them updated more. I need to be more involved in that. For me, it's been a very difficult time just getting up and getting out of bed some days, and I'm not making excuses. Everybody goes through grief. Everybody goes through loss of people in their lives. And I have tried to handle it to the best of my ability. But when I look back, I find that when everything kind of started going down for me was around the time of my sister's passing. And I have really struggled some days just to put my foot forward. Everybody has problems in their lives. This is no excuse. I'm being honest. I'm opening my heart, and I'm asking forgiveness if it's irritated you, but I want to thank you for sticking with me. But I feel that a good time for me to relaunch is come Monday, or with the Karen Reed trial. I do want to also follow the Lori Vallow day bail trial. So that's going to be hard because we have 2 trials going on at the same time that are massively important and everybody's following. So the schedule is going to look like this. In the morning, we're going to be going over Karen Reed live. We will break for lunch. I'm not going to hop in with another trial. One of the things says is that people click on a live and it's supposed to be Sementilli, and during lunch, we're on another trial. It's confusing. I get it. So we will break for lunch. We will watch the afternoon session with the Karen Reed trial. Then I'll take a short dinner break, refresh myself. Then I'm going to zoom through all of the breaks and pauses and everything. And we'll do the Lori Vallow trial, if that's my goal. Don't know how well that's going to work. I know the Lori Dayville trial will be starting a little later in the day, whereas Karen Reed is early during the day. Karen Reed is 7 o'clock my time, start time. And then the other one is, I think, Lori Dayville is, I think, 11, depending. They said 10:15 Monday morning, whatever that means. So we'll see how that goes. So we'll start that trial Monday morning. If we're in verdict watch, we will not be watching this in verdict watch until we get a verdict, and then I will pause and get that verdict in. So then that's how we're going to do it. I am open to suggestions. Let's see what something just handed me. Sorry, guys. As the gavel drops, just drop this into my Discord. Let me see what it is. U.S. judge throws out corruption case against the New York City Mayor Eric Adams. Oh my gosh. Oh my gosh. Seriously? Oh, that's going to be. That's not what I asked you to do. I've just moved around 10 windows at one time. That's interesting. Let me read it and see. United States federal judge has permanently dismissed corruption charges against the New York City Mayor Eric Adams. Even as he criticized Trump's administration arguments, the case should be dropped because it was hindering the Democratic politician help with the immigration crackdown. Okay, so that's all I'm going to say about that. I know some people are watching that. So there you go. There you go. I know. Can we just ask, hey guys, can we reschedule the Lori Vallow, not Karen Reed? Keep Karen Reed where it is. But there is, I only saw the cover for it. I talked to you about Jason Chin, right? Yes, I did. I told you about Jason Chin. Let me get Discord back up. See, guys, I have Discord up all the time. So also, in the Julia Grace Egler trial, it happened on 7/6/24. Defendant is 16 years old. It was filed on 8/6/24. 2 counts of first-degree redrum, cannot receive the unalive penalty. The next court date is set for April the 23rd. So we will see if we can fit that in. We will see if we can fit that in. My thing is we have so much happening. How do I get it all in? How do I get it all in? I don't know. I'm struggling with that. Oh, I need to go to Discord. Karen Reed. Okay. The Karen Reed. Okay, so they've asked for the list of jurors. Vacate. Oh, by the way, let's talk about, I want to talk about the Karen Reed situation real quick. Anybody, I've been looking and haven't found anything yet on the motion or the suit from the people who wanted to be outside picketing the Karen Reed trial against Judge Cannoni. Want to know if we've heard any more movement on that. If you know, let me know. In the meantime, we're coming back in. We have the judge.
Okay.
Oh God, no.
Up was that when he
We have probably another hour.
went to the home
If I could speed her up, I would.
to explain all of Fabio's benefits, whether that was January 26th or when he went again on February 9th, the defendant had her state lawyer there with her. And that Henry told the defendant in front of the lawyer that in order to get the insurance money, she was going to need to be cleared by law enforcement. The insurance company was going to require that before the insurance company would pay out. And yet, despite all of Henry's efforts and the work that he did to help her out, by March, the defendant began falsely complaining about him to other employees of the company. And he talked about how the defendant became very aggressive, that she hassled him, I think was his word, and harassed him about things like the life insurance payout that he had no control over. And as you recall, he said that he had no less than 4 conversations with her where he explained to her that that wasn't something he had control over. And again, keep in mind, whether we're talking about Henry or Dave Diaz or Sal or Sam or any of these individuals from the company, they were all aware of those Instagram posts that the defendant would put out, those public Instagram posts, which I spent some time in my opening statement, and you have copies of those in evidence as well. I believe those came in through Officer Curtis Davis, that the defendant, as I said, I used them as evidence to show you this double life, where on the public side of things, the defendant was posting about how much she missed Fabio and that she's just devastated. And that was the public persona or perception that she was putting out, that all of these people from the company were watching, and how it made them feel so empathetic and sorry and devastated for her, such that they were willing to do anything just to try to help her because they felt so bad. And yet none of them knew that behind the scenes, she had this other life where she's, as we heard about yesterday, running over to Baker's house and performing oral sex or and taking photos of it. You know, it's one thing if you were to go and have your affair, right? It's another when you are photographing it. And again, you have to remember the conversations the defendant and Baker had in the lockup, where she talked about how she was so afraid that law enforcement was going to get into her phone. And if they cracked her phone, what would they find? And again, we're not just talking about the fact that her iPhone was 119, her phone number 42442, to her iCloud. But then again, there's all these very provocative photographs that show her in various positions, which is why we were able to take that and juxtapose it with the calendar of events that were taking place, and be able to show you that we're really talking about somebody who's very devious and who's trying to display a different persona to everybody else than what's real, what's really taking place. And so, despite the fact that Henry was very empathetic and wanting to give her everything he could, he was then contacted numerous times by her lawyer, who wanted him again to speed up this insurance payout. That once again, Henry said, "Out of my hands. We have no control." And we know that it had already been processed, this claim, by Tracy Rakovich, because we heard from her as well. So regardless of how they characterize it and what experts are called, right now, as I told you during the opening, she stands to inherit over $2 million in assets. And maybe to some people that might not seem like a lot of money, but
yeah,
it is a lot of money.
It's a ton of money.
If she walks out the door, that's what she'll get to inherit, because that's what the value is now of the stock options, the life insurance, and some of these other things that have been waiting, such as the house, for instance. When the house was sold, they had to pay off the mortgage. She got half. The other half goes into Fabio's estate. Well, if she gets off, she gets the other half. As Marie was trying to explain to you in very simple terms, when you're looking at, just for an example, divorce was brought up, just to give you an idea of the difference between these things. In a divorce, you're maybe looking at, it's not necessarily 50% of every asset, but maybe 50. It could be something less, but there's negotiation that takes place, but it's not 100%. You only get 100% if he's gone, right?
Yeah.
Last time I checked, 100% still better than 50%. Again, common sense.
Really?
And I talked about the fact that she knew the value of these assets because she's the one who handled the family's assets, handled the finances. And then we heard from Janet Cover, and if you recall, Janet was also a person who worked for HR under Henry at Wella, and she also went to the residence a couple times to go over Fabio's benefits once again with the defendant. And there's a document, Exhibit 175, that she testified about, and that when she went over there to go through the benefits with the defendant and to assist her with the information so the defendant could contact some of the people that Henry had laid out for her. Instead, what happened was the defendant, if you recall, went out onto the patio to smoke a cigarette and talk on her phone, and Janet made the calls on her behalf to P&G in order to trigger the exercise of stock options and to P&G Canada for Fob's additional stock and benefits. And then if you recall, after that, the defendant then confirmed with Janet in the days thereafter via a text message exchange that the defendant did get a call back from P&G, and Janet told you that the defendant would then call her every couple of days to check in on the status of the life insurance payout, and repeatedly again mentioned to her that she had a lawyer to try and pressure these people who had no control. And then, as you heard from Janet, if you remember this, the defendant even sent her, and you can look at the text messages yourself between the defendant and Janet. She sends to Janet Detective Parshall's phone number, as if Janet should call Detective Parshall. So then we heard that on April 12th, the defendant texts Janet about the life insurance and the stock options. Remember when there was this claim that she didn't know about the stock options? She texts Janet specifically about the life insurance and stock options going to probate because Fabio died without a will. And that was Defense Exhibit 616. And then again, you heard the same thing from Janet, that the defendant would call repeatedly to complain after Janet made calls for the defendant. One of the things that we put into evidence in this case, we laid the foundation for it. There was a stipulation. When you have a stipulation, the judge is going to instruct you that that means that you're to take whatever information is in the stipulation as true. In other words, an agreement between the parties. It's not contested. You can assume it's been proven, and you can use that evidence for whatever purpose. In this case, we did not play, even though we put in, they're very short. They are audio files of the defendant's messages and calls to P&G regarding the stock options and the life insurance. And we also have, as we do for every audio, we have transcripts of that. And that is exhibits 237 through 242. Again, they were not played in court, but you should look at those when you go back into the deliberation room because we did not play them in open court. They're very short, but we wanted you to know that she made calls herself on top of all the calls that all these other individuals made. So then we heard from Fabio's son, Luigi Sementilli. And what he testified to was that he didn't even know his dad had a life insurance policy for him until the night that he gets a call saying that his father has just been murdered. And he testified that the first thing the defendant told him wasn't, "I'm so sorry, we're so devastated." It wasn't any of that. It was, "There's a significant amount of money coming your way." It was about money from minute one. that there was a significant amount of money coming to him from
Overruled.
from Fabio's life insurance policy. And this was, recall, within 1 to 2 hours of Fabio's murder. Luigi said he was in complete shock. He was at that point in Canada attending school. You heard that he completed a master's program. He was in complete shock, but it was the only topic his stepmother talked about that night. And then he said that at some point, Deborah Obad gets on the phone with him, and he can hear the defendant talking and telling Obad what to say in the background. And Obad says, Monica's saying there's money problems. And Obad tells Luigi that she's assured Monica, don't worry, Luigi will be willing to give up some of his money to give to you and the girls. And she's telling Luigi this as if she's making the decisions for Fabio's son. And as Luigi said, he found that to be kind of like what Sal Boccieri said, extremely presumptuous. It was inappropriate given the timing, but he was in shock. And then you heard 2 days later, Fabio's family on January 25th, which would be Wednesday, 2017, flies out to California, and the defendant gives Luigi the Rolex watch, and she asks Luigi to come upstairs with her. And as you recall from the photos of the second floor of the house, that's where Jessica's bedroom was. There's a bathroom up there. There's a big open living room area. And in the back of that living room area next to the window sits this desk that the defendant had along with her desktop, which we seized after the arrest on June 14th, 2017. And so he goes upstairs with her to the computer, and she shows him a spreadsheet that she has with a breakdown of the life insurance proceeds. This is now 2 days later. And he noted from the breakdown, at least, that she provided, that she was getting the most money, contrary to what the defense has told you, and that during that week that he's there, he has numerous conversations with the defendant where she brings up the topic of money. And then you also heard once he returns to Canada, the defendant continued to send him versions of that spreadsheet that she was constantly updating and editing, as we saw in Exhibit 75, where there would be columns that are blank, and then as she is learning about various assets, she fills in those portions, and then she calls and tells him. And then recall, there is a text string between the defendant and Luigi that takes place. It's Exhibit 77 through 81. And she talks about the life insurance, and she uses the language saying, life insurance, big numbers, unbelievable. And then she tells him to do what?
She does have a stepson. Yes, she does. And in fact, he kind of got more money, got a little more on the insurance money than the other two children. Just saying.
Delete the text. Once I send you the number, delete the text, because why would anybody be talking about the money this way in such a cavalier fashion? And of course, you heard that once we got those text messages from the phone, it showed exactly what he testified to. And
I feel sorry for that stenographer right there. Court reporter. I may have said that wrong. I feel so bad for her.
you also heard that up to that point, the defendant, until the time from the murder until the time of the arrest, she didn't want anybody from her family or Fabio's family contacting law enforcement. She got very upset about that. And Deborah said she was mad that I did that. And obviously we know why. But Luigi finally talks to law enforcement the day after the arrest, if you recall, on June 15th. And he tells the detectives about all of this information that he's now testified to here. And the family, who were so wanting to support Monica and the girls and to try and help her, now are learning about some of the evidence as well as the affair, and they feel betrayed, as anybody, rightly so, would feel. How else would one feel? And so they're attacked for that. They're attacked for the fact that they helped, and they're attacked for the fact that they feel betrayed. And so you heard, and it was testified to, and I'm not going to get into it too much because some of it is a tragedy and it's beyond anything we can control. But this murder literally rips these two families who for all of these years had been so close apart. And Fabio's family is left to grieve on their own and to their way of thinking. His daughters are acting disrespectfully towards Fabio and his memory, backing up their mother, hiding their heads, so to speak, in the sand. And as Deborah Obad said, they're all in denial. And so, again, as I mentioned earlier about the actions of this defendant and how it destroyed so many lives, when you think of, for example, if you were to throw a pebble into, let's say, a pond, that ripple effect, right? And it impacts so many people, whether it's intended or unintended, it doesn't really matter, but you literally rip apart these relationships that have been built on trust over the course of so many years. And so that's where we are. And so you heard that in the aftermath of this murder, Luigi, again, who's following the defendant's Instagram posts, he feels horrible for Monica, his stepmom, and they'd never really been very close, but now he said he reached out to her a lot. He would call her and check on her, and he would check on his sisters. And you heard that the defendant comes to Toronto a couple of times for various events, and she comes to Toronto for the end of February, around the 28th of February, for the 1-month anniversary service of Fabio's death. And he goes over to Monica's mother's house to see Monica, and she tells him that she's going to be liquidating these stock options. And she claimed at that time that they were worth more than $100,000. He doesn't know anything about the stock options. And she asks him again if he'll relinquish his portion, that at that point she said was approximately $30,000, because he had this, bless you, this Manulife policy under Canadian law. When you divorce in Canada, you're required to have support for your children. And so that was the policy that Monica had referred to, that Fabio had put into place for Luigi. And you remember Luigi talked about how the defendant, just like everyone else testified to, she constantly complained about the money problem to him over the next several months, and how she was struggling with bills. And so he agreed, because he thought his mom, his stepmom, and his sisters were struggling, but the defendant never followed through. And of course, as we know, and I've talked about, she knows that the longer she leaves those options without exercising them, as long as she can, if until they're ready to expire, they'll be worth more money. And that he felt, heartbroken for his entire family. But you also heard him talk about the fact that after his mother and Fabio divorced when he was young, he would spend weekends and various time in between the two households, and that it was very clear to him growing up that when he was in his father's house, that Monica was the boss, that she was in charge of the family's finances. She, not Fabio, was the one who reached out to Luigi's mom, Vonda, to talk about the payment of Luigi's school tuition. It wasn't Fabio who did that. Monica took that on herself because she is the one that handled the family finances. Now, as I mentioned earlier, we heard from Tracy Rakovich, who came in from New York, who was the benefits manager for the company for the U.S. operations for Cody. And she talked about how Cody purchased Wella and contracted, as I said, with MetLife to provide retirement benefits and life insurance. And that in 2016, Fabio had life insurance that was 6 times his salary. And that was in Exhibit 93. And she assisted Fabio with his 2017 benefits enrollment and the purchases of life insurance and supplemental accidental death and dismemberment coverage. These are contained in emails from Exhibit 92, and then the enrollment documents for 2017 in Exhibit 95, and that Fabio elected to purchase approximately $1.691 million in life insurance, where the defendant was the main beneficiary on each of those policies. When you look through it, you'll see that in certain categories, like the basic life insurance, 40%, and then other portions, 45%, and then in other portions, 50%, and the kids, as I mentioned, split the remaining portion. And so once Fabio did that, the defendant's share was $7,000, almost $800,000. That's the defendant's portion of the life insurance money, $800,000. And we also heard and saw that the defendant sent that Fabio sent his documents, just as he always said he did, to the defendant on May 17th of 2016 and October 4th of 2016. And those are Exhibits 96 and 97. And if you recall, Ms. Rakovich recognized those documents. We showed them to her as the same information, the same documents she provided to Fabio along with his selections. And so after the death, she was responsible for processing the defendant's life insurance claim. That was Exhibit 98. And once she made the claim to Fabio's policy, it triggered the payment process to all the beneficiaries. And you recall the constant questioning about what Luigi had done, and did he try to get the money? And Luigi kept saying, I never made any claim. They just sent me a check. And Tracy Rakovich says that's how it works. Tracy, when she makes the claim on Fabio's policy, it triggers the payout, and all of the beneficiaries that were cleared, meaning Luigi, who's in Canada, and his 2 sisters who are here, are paid out. But the defendant is not, because, again, we heard from a couple of detectives.
By the way, Toxic, I didn't know this. I'm going to share this with you guys. You guys can go over here, click, if you see over here, and it's in the comments, and I will pin message in comments. You can go to buymeacoffee.com. Okay, go to buymeacoffee.com, and you can donate money for As the Gavel Drops, because they pay for those documents. A lot of their mods pay for them, and we get to use them at no cost. So I didn't know you could be set up on a monthly, automatic monthly, like a membership. So I went over there, I signed up. I'm on a monthly membership now with As the Gavel Drops. supporting them as they support me. You guys, please go over there, whether it's $5, $10, $25, $50, whatever, one time or monthly. You guys can help keep them going. This is not an easy time for anybody right now. And court documents cost. And I only feel that if I'm using the documents, I'm going to support them. So I have done so in the past. This behind paywalls, yes, there's a lot of documents we can't get or they can't get unless they pay for them. I don't have the skills, honestly, with dyslexia. I struggle hunting for documents, and I know when I have a weak spot, and I cannot do that. That is a weakness for me. I love As the Gavel Drops. I love Discord. Discord I love, but the way everything is formed, I look at it and I go, I can't, there's too many lines, too many words. It's just crazy. So it is so wonderful that Toxic Orchid and Discord has everything as organized as they can have it, and you can go over there and find it. So please, you guys, jump on, go buy them a cup of coffee, even if it's a one-time thing. Every little penny helps. You have no idea how much these mods put out there financially every month to get documents for us. And if you use their documents, please use it responsibly. Give credit where credit is due. All right, we're going to get back on to the rambling. But it is true that the children have been paid out, and the money that would have gone to Monica Sementilli is sitting in a trust or something like it. And so when and if, and it's really going to be a small if she is found guilty, innocent, then she would get the money. If she's found guilty, then it goes to the children. Well, and also that the time they put into finding these documents is incredible. That is one thing that I know I cannot do right now. Right now. I'm trying to learn to use As the Gavel Drops in Discord better. Anything that involves reading and learning in a written form is hard for me. I can read how to make a YouTube short, and it takes forever. You can come and show me how to do it once, and I got it like that. So, but that is true. The time they put into finding those documents. So please go and help them.
About that, and I'm going to get to that. One of them was Steve Castro. And so at that point, she was also made aware, as Salma Cherry was, that the defendant was constantly contacting Henry Meyer and Janet Cover about the delay in the payment process. But again, as she testified, payments were only made once clearance was provided by the law enforcement agency. So we also heard that various other individuals were involved in this evidence. We heard from Ernie Valorano, one of Fabio's close friends, that he became quite worried after Fabio's death because of the defendant claiming that she didn't know how she would even survive or buy groceries. And if you recall, he, like Sam Pulera, offered the defendant money. He wanted to help her because she was the widow of his best friend. And so he offered her a job. And he had no idea during that same time period, as Henry Meyer testified, he didn't really understand what the all the pressure was, because at that point in time, she's getting Fabio's salary as if Fabio was alive. And when Ernie was asked by the defendant to get rid of, sell Fabio's Porsche, she took a lower offer, if you recall, to sell the Porsche in order to get the money faster. Instead of waiting, as Ernie said, he had another buyer who wanted to pay $15,000 more, but that individual was on vacation for a couple of weeks. But instead of getting additional money, $15,000 at that point. The defendant didn't want to wait, and so she told him to take the lower offer. And what we heard was, again, even more calls that were being made and more contacts that were being made with Wella about things that really might seem at this point to be obsessive. And we heard a little bit about that from Fabio's executive assistant, Alicia Truesdale, that the defendant even contacted her in the days after Fabio's murder because she wanted to obtain, if you recall this, Fabio's frequent flyer mileage. Because Fabio was an executive and was flying on the company dime, he, traveled significantly for business within the United States, also up to North America, Canada, and a couple times a year to Europe. And so he had acquired a significant amount of frequent flyer mileage. And Alicia, who was, again, felt so bad for the defendant, went about obtaining and transferring Fabio's frequent flyer mileage over to the defendant, even though the company paid for Monica to attend some of these events where Fabio received awards, such as the one was the Mirror Awards in Canada that we heard about in Toronto that year. And so we also heard, as I said, from Jim Duggan, the corporate security officer for Cody, who also flew out from New York. He contacted the defendant on March.
I guess I'm lucky. I can turn these babies down and not hear it and just read what she's saying. Just a thought.
March 9th, and he wanted to know, what can Cody do to help you? And she didn't ask for the things that he expected. She didn't ask, can you get me a new security system? She didn't ask, I want to move out of the house. Can you guys pay for moving costs so the girls and I can move to a place where we feel safe? She didn't even ask for corporate housing on a temporary basis. She didn't ask for any of that. The only thing she wanted from Jim Duggan was, can you help me get Fabio's life insurance? And so each time after that, the defendant contacted Mr. Duggan. The only topic she contacted him about was the life insurance money. Now, shortly after the murder, law enforcement learns that the defendant, again, is the single largest beneficiary of Fabio's life insurance policy. And Detective Steve Castro testified. He's now retired. He was the supervisor of the homicide division at Valley Bureau. He supervised Detective Parshall and Detective Verna. And you recall he testified about receiving a call from Cody in March about Fabio's life insurance policy for the $1.6 million that Tracy Rakovich mentioned. And he instructed the insurance company not to release any of the money at that point until law enforcement had cleared the defendant, because at this point we're talking about March 20th. Law enforcement is well aware of the relationship between the individual who left DNA at the crime scene in Fabio's Porsche and is having an illicit affair with the victim's wife. And so then, after he instructs the insurance company on March 20th of 2017 not to release the money to the defendant, 2 days later, he gets a call from the defendant, and she leaves a voicemail message. And recall Detective Castro testified that the defendant on this voicemail message communicated how unhappy and upset she was and wants to know why her insurance money isn't being released, and she demands a call back. And remember what Detective Castro said. he said that in all the years that he had been working homicide or had been a supervisor in a homicide division, he had never received a message like that from a beneficiary before. And then we learn on June 1st of 2017, he is copied on an email from the defendant requesting that they accelerate her clearance for the life insurance claim. Now, that was marked as a people's exhibit. It was also marked as a defense exhibit. And we saw that happen several times during this trial, where the people would put in an exhibit and a couple minutes later on cross-examination, they'd mark the very same exhibit. They'd indicate that it had additional information, and then they'd go through it, and it was exactly the same as the people's exhibit. So there is a defense exhibit 612 that mirrors the people's exhibit. And when you look at that email, if you recall, the letter that Marco Laurenti drafted for the defendant at Morella's request to help her out, to assist her in trying to get the life insurance money, that letter is exactly the same email the defendant sent to Detectives Parshall, Verna, and Detective Castro. And that's Exhibit 111. And that she claimed that it was urgent that she insurance and other assets, as I said several times today, to fund their life together. So again, it's not a complete coincidence that he's the first person she thinks to share the good news with. After all, as we've heard, he is the most important person of all to her. And I'm going to tell you why I say that in a couple minutes.
Well, actually, it would be good a little bit longer. Let me interrupt you. We're going to take our adjournment now until tomorrow at 9 a.m. The admonition applies not to discuss this case among yourselves with anyone else or form express any opinions of the cause is finally submitted to you. Have a good evening. See you tomorrow at 9.
Hallelujah! 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 I want to see us. Oh, they went straight to that. Oh my God. Okay, we're back tomorrow morning. They're going to be here on Friday. This woman needs a class on how to do an opening and a closing. She is hideous. Absolutely hideous. Her voice, yeah, I go to sleep and I hear her voice. Okay, guys, that's bad. We'll be grateful when this is over. I'm so ready for Karen Reed. I'm ready for Lori Daybell. I'm ready to get off of the Sementilli trial. So hopefully tomorrow we will be in jury verdict. It would be nice if this woman only took another 10 minutes in the morning. The defense comes in, and after lunch, we go straight to verdict watch. So we'll see what happens. Okay, let's do the giveaway. We only have 12 people in the giveaway, guys. If you have not liked the video, like it, comment I liked. I'll give you a minute. Haley Mouse, I want to tell you how much I really appreciate you. You are doing a fabulous job, Mod. When you consider how long this case has been, I understand there's a lot of information, but oh my word, there's a lot of information. But you know what? They made this case longer than it had to be. This case should have been done in 2, maybe 3 weeks, max. That includes with jury deliberation. Done for the night. We'll be back tomorrow morning at 11:30 for her case. Now, what's going to happen? What's going to happen? We're going to do the drawing, and we're going to do that. And then what I'm going to do is we are going to take a break and come back at 7 o'clock for the other trial, or maybe 6:45. We'll see. Has everyone typed like? Okay. Oh, we got one entry entered. Okay, I'm going to give you a minute. Oh, no, June. Oh, don't say it. Don't say it. I know she's got a rebuttal. Don't you dare say it. I don't want to hear it. I don't want to know it. Okay, here we go. Yay, K-Swan, you won. Woohoo! All right. With that, everybody, thank you guys so much for all that you do. Thank you for joining me. Thank you for supporting me. Thank you for hanging in there. It's been a rough time, but we're getting there. Upward and onward. New day tomorrow. We're going to do great. So I'll see you guys shortly for the other trial. Okay. Oh, I can't teleport because I've got a delay in the trial. Okay, guys, I'll see you in about 15 minutes. With that, have a great evening for those who can't rejoin us. Those who can, look forward to seeing you. These attorneys get spicy. You want to see some spicy sparring between attorneys and judge? Come on over to the next trial. We'll see. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.